Sail the raven waves, brothers, axes high, shields strong. From distant lands we gather, hearts of fire all along. Oh, big Nick calls we follow, through the storm and through the fight. For about how we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big because we follow, through the storm and through the fight. For about how we will borrow strength and might under moonlight. From horizons wild we roam, with thunder in our soul. Every battle brings us home to the stories ages told. Oh, big Nick calls we follow, through the storm and through the fight. For about how we will borrow strength and might under moonlight.
Let me recall that. I think the poly was off.
That's good.
Can you hear me now?
Yes, Your Honor.
Mr. Deanne? All right. Yeah, I'm going to recall the case. State of Michigan versus Mohammed Deanne.
Good morning, Ashley Lonnie with the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Mohammed Janan, who appears via Zoom from the MDOC facility. Sir, can you please state your name for the record?
Mohammed Janeh.
Thank you, Your Honor. I have discussed this matter briefly with my client this morning. He was recently transferred to a different MDOC facility, so to that end, I was unable to visit with him either via video or in person prior to today's date. So I'd be requesting a brief adjournment so that can happen.
What's my date?
2 weeks.
You want the 4th or the 18th? Well, it's 2 weeks exact on the 4th.
Yes, sir.
Maybe.
Maybe the 18th.
Sounds good, Your Honor. Thank you.
I'll adjourn the matter June 18th, 2025, 9 a.m. Bond will continue. Thank you, Mr. Barron.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of the people versus William Parker.
Ashley Lonnie for the people.
Hi, sir. Tom Piotrowski on behalf of Mr. Parker, who's approaching and standing to my right. Hi, sir.
Name, sir? William Parker? All right. What do we do?
This is scheduled for an arraignment. We'd waive formal reading and stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea.
We are asking for a pretrial. I believe I've confirmed this with your clerk at June 14th. Please.
14th.
Yes, please. June 18th. I'm sorry. Thank you.
I'll adjourn this matter to June 18th, 2025, 9 a.m. As to bond.
Good afternoon.
This is an alleged OWI second offense of the prior offense in 2022. People are requesting that the defendant be placed on a strand or a sober link. This light of crash, the defendant was stopped after being observed engaging in bad driving. And the alleged VAC in the matter is 0.129.
Your Honor,
0.129.
Yes, Your Honor.
I think sober link is a reasonable request, Your Honor. We would concur.
All right. Set the defendant's bond at a personal recognizance $15,000 bond. All order standard conditions, including no assaultive behavior or possession of any weapons. You understand that, sir?
Yes, I do.
There should be no possession of any alcohol, recreational marijuana, or any illegal drug. I'm also going to order that you report to community corrections for placement on a sober link testing device. All right, and I'll sign
Thank
that.
you.
over.
Thank you.
All right, thank you.
Set those to the sidewalk.
Court does call the case of the people versus Kamara Reed.
Ashley Lonnie for the people.
Morning, Your Honor. Dan Garrett on behalf of Ms. Reed. She's stepping forward.
Good morning.
Good morning, Your Honor. Kamara Reed.
For arraignment, we would waive reading and standing, please.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea.
I'm ultimately asking for another pretrial mid-June if possible due to my client's requested travel, which I'll address in a second, as well as travel I have.
All right. Pretrial in this matter then will be June 18th, 2025, 9 a.m. As to bond.
Here, this is an all alleged OWI first offense. There's no crash. Alleged BAC .099. We are requesting
099.
Probably soberly. This matter. No priors, Your Honor.
No crash.
No crash.
All right. It's a traffic stop. Is that
Traffic stop for no headlights. I think of note at the scene, it was a 08. And as it relates to any testing, I do want to address travel when Your Honor's ready.
all right? Set her bond at a $10,000 personal recognizance. All other standard conditions, including no assaultive behavior or possession of any weapons. There should be no use of alcohol, recreational marijuana, or any illegal drug. Given the BAC level, I'm not going to place her on a testing device at this point.
Your Honor, I appreciate that. One of the things we added it. Let me say this a different way. She's asking to go to Arizona today, leaving in like 2 hours. I was going to adjourn, but Ms. Blondie and I agreed to just do that today. So she's asking permission to.
If I said no, what happens?
She's staying right here with us. That's what happens.
Why are you going to Arizona?
My cousin's graduating high school.
Family that graduates. See, Karen knew that.
I did know that.
Yeah, and it's gonna. How long? Today through
The 31st.
the 31st. It's a long graduation.
And family reunion.
Leave that out. All right.
Yeah, one thing I did want to mention, but I neglected to, I apologize for the interruption, is that the defendant at the time of the offense was 20 years old. She had not yet
Oh,
21.
she's
So
not yet turned 21.
that's correct.
Okay, that changes. Thank you.
I apologize for the interruption.
All right. So I will indicate that the defendant may travel to Arizona today. I am going to order community corrections. I am going to order that she be placed on a sober link device, given that there's an age issue.
Could she go right?
She can go right now.
Good.
They're usually watching, but if they have a problem, they can call in.
Sounds good.
Usually people don't run over there asking to be put on a device. So
Get her over there right now. Thank you.
All right.
Return.
thank you.
Thank you.
Have fun in Arizona. It's hot.
Yes.
Court calls the case, People versus Aaron Salazar.
Ashley Lonnie for the people.
Morning, Your Honor. David Chan, on behalf of Aaron Salazar. We do, Your Honor, we do have a plea in this matter in return for the super drunk charge being dismissed. My client will plead to OWI first.
That's correct, Your Honor. The 93-day misdemeanor, $100 to $500 fine, 6 points from his license and various other Secretary of State sanctions. Contrary to 257-6251A, will dismiss the OWI 5 BAC. There had recently been, not a violation, but a progress report cautioning the defendant to remain compliant with his sober link device. Mr. Shan had shared with me some of the explanation as to why there was that late/miss test. So I'm satisfied with that explanation and ready to move forward with this plea should be court accepted.
All right. And that's a correct statement of the plea.
Yes, it is, Your Honor.
All right,
He cleans residential houses and he takes sober link with him. And he left it at a residential house that he cleaned and then had to go back and get the owner to get the sober link out of the residential house so he could do the testing. So that is what happened.
May I have him sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Aaron Salazar.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated. That is a misdemeanor, punishable by up to 93 days of jail, a $500 fine plus court costs. The court could order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
And understanding that, do you still wish to plead guilty?
Yes,
And to that charge, how do you plead?
yes, I'm guilty.
You pleading guilty?
Guilty. Yeah.
All right. Now you understand that by pleading guilty, you'll not have a trial of any kind.
No trial.
Not right.
That's the stuff that we went through. Yeah.
You understand that you will not have a trial, sir.
I'm sorry, boss.
Do you understand there'll be no trial?
Oh, yeah.
All right. You signed an advice of rights form today, is that correct?
Mm-hmm. Yes, sir.
All right. Do you have any questions regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand that you're giving up those rights as well as all the rights on that form.
You understand these?
Yeah, I understand.
All right. You understand you're giving up those rights.
Yeah, you're waiving those. You're giving them up.
Yeah.
Okay. Is he understanding me?
Yes,
Because I've got to make sure that he does.
yes, he does. And that's why I'm slowing down, because you speak really quickly and he does.
So that's the second insult Shane has given my court today. The first one when I wasn't out here, but was reported to me.
I did that.
No,
That is
you
not
said
an
it, and
insult.
I know you said it. Now you just did that. That first one was about how hard I think I work my staff.
It was an
And
honest,
then this
honest
was just a
statement.
direct attack on me. All right. So, no, I won't hold that against you. All right. But is he understanding?
yes, he is.
All right. So you understand you're not going to have a trial. You're waiving all of the rights that are on this form.
I understand.
All right. You understand that you're giving up your right to appeal of right.
Yeah, I understand.
All right. Are you on probation or parole?
Yeah. I understand.
That's beyond bond.
Okay.
Yeah.
Are you under the jurisdiction of any other court?
No.
All right. Have you ever been to prison for longer than a year?
Okay.
Have you ever been to prison?
Yeah.
Have you been to prison
The president, well,
in the United States? Have you ever been to prison? Not jail, prison.
yeah.
Okay. Counsel approach person. Record should reflect that it had a bench conference with counsel. I'm going to stop the plea at this time. I'm going to adjourn this matter out June 4th, 2025, 9 a.m. And we'll take care of submission. All right.
Thank you, Your Honor.
Thank you. Bond will continue. Court does call the case of the people versus Sarah Orr.
Testimony for the people.
Sherilyn Foster Tucker on behalf of Sarah Orr.
Sarah Orr, Your Honor.
Thank you. All right.
Can we read first?
Briefly, yes. Never gonna get through this. In fact, we've had a bench conference in this case.
Yes, Your Honor, and there has been an offer extended to the defendant to plead to an added count of failure to report $1,000 damage accident, 90-day misdemeanor, $100 fine, and 0 points, contrary to MCL 257622. In exchange for that plea, count 1 will be dismissed.
That is correct, Your Honor. And Ms. Orr does wish to accept that offer today. And I have handed the court an advice of rights form.
May I have her sworn, please?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Sarah Orr.
No. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of failure to report an accident with damage over $1,000. That's a misdemeanor punishable by up to 90 days and a $500 fine plus court costs. You understand that?
Yes.
All right. Understanding that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
All right. You
Sure.
signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do, Your
You
Honor.
understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes,
Because you believe that you are indeed guilty of this offense?
yes, Your Honor.
On May 22nd, 2024, at the location of Moon Road near Michigan Avenue, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
All right. Were you involved in an accident?
Yes, Your Honor.
What happened?
So I was in the yield lane or the merge lane, whatever it's called. And the other guy was in the through lane and we were at the red light. And when we were driving through, I got in front of him and then he got into the turn in lane. And then he says he was going to turn, but I don't think he was because the way the damage is, he hit the front of my car and the front of his car. So he was trying to get back in front of me.
You're
But then
heading,
we collect-
you're heading north.
Correct.
You were heading toward Ann Arbor.
No, away.
You were heading away from Ann
So
Arbor.
south.
So you were coming past the Walmart,
Yes,
heading out.
right. Where State Street turns into Moon Road.
Yeah.
Yeah.
Okay. All right. And so you had this collision. Did you immediately stop your vehicle?
I did not. I was a little scared, so I did not.
Okay, you didn't stop. Did you immediately report that to the nearest and most convenient police
I did
station? Did not. Would you dispute that the aggregate amount of damage that can include repair costs was in excess of $1,000?
For mine or for his?
Total.
So you obviously don't know how much his vehicle.
Right, correct.
But would you dispute that if he says it was more than 1,000, would you dispute that?
I didn't see the damage, so I don't know.
We can stipulate that it was over
The
1,000.
damage, total amount of damage to both vehicles was in excess of 1,000, including repair costs. You'll stipulate to
Yes.
that, counsel. All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
June 25th. At 9 a.m.
June 25th, 2025, 9 a.m.
And Your Honor, I do not expect a restitution. I do believe the insurance covered everything.
Covered everything. Okay, fantastic. All right. Thank you. All right, bond will continue. You'll stop down at probation on the way out.
Okay,
Check out. All right.
okay. Thank
Thank
you.
you, Your Honor.
Thank you. Court does call the case people versus Michael Klustra.
Ashley Lonnie for the people.
Morning, Anna Uwe Das with and on behalf of Mr. Klustra, standing to my right. Mike, please state your name for the judge.
Michael Klustra. All right.
We have an adjourned plea trial, had discussions with Ms. Landy. Make counsel approach, please.
Yes, briefly,
Thank you.
folks.
Today's the day.
I got a whole
I
lot
know.
of cases.
Thank you, Anna. We're looking for another adjournment if we could. I don't know how long Ms. Landy thinks it might need to be.
I will accommodate the defense counsel schedule.
I'll do the 18th, 2025 at 9 a.m. If you think what you're working on is going to take longer, then let the court know and we'll figure that out.
Thank you.
Very
All
good.
right. Thank you. Court does call the case people versus Gabriel Boyd.
Ashley Lonnie for the people.
Good morning, Judge. Rita Sparks on behalf of Ms. Gabrielle Boyd. Judge, I had a very lengthy conversation with my client last night. I am quite shocked she's not here this morning and very, very surprised. I'm hope that she's okay. So I'm just asking if you could just pass it for a moment. I've been trying to get in touch with her, but this is quite shocking. She's in here every single time, so I hope. that
So it was a good conversation?
Yes, very good
Okay, all right.
conversation.
I don't know. Maybe you were yelling at her.
No, it was not anything bad. That's
No,
why I'm a little
okay.
bit, I'm a little bit worried about it. If you could just pass it.
I'll pass.
Thank you. I appreciate it.
Court does call the case people versus Rebecca Dilworth.
Ashley Lonnie for the people.
On behalf of Ms. Dilworth, not sure if she's logged into Zoom yet, Judge.
And Your Honor, I have prepared a nollie in this case. If she's not, I don't know if the court's received it.
I don't have Ms. Dilworth.
With the case, Judge, we are asking that the court excuse her presence. We are expecting a dismissal from the people anyway.
You're moving to dismiss.
That's fine. Yeah, it works on its way. It should be during time now.
Okay. No, thank you, Judge.
Case is dismissed. Thank you. Court does call the case of the people versus Natasha Olmos.
Ashley Lonnie for the people.
Kyle Burdell on behalf of Natasha Olmos, who's approaching the podium. And Ms. Olmos, please say your name for the record.
Hi, good morning, Natasha Olmos.
Thank you. What are we doing?
So, Your Honor, we are currently in plea negotiations. I believe we can come to a resolution soon. We are asking for an adjournment in this matter. I believe the court was giving June 4th or the 18th.
Yes.
I'd ask for the 18th. I'm not available on the 4th.
People picking their dates again. June 18th, 2025, 9 a.m. Bond continued.
And if we maybe heard us to bond.
Yes.
Go ahead. So, Your Honor, Miss Olmos has been on a sober scram tether since the inception of this case. She's had no issues. There's been no positive tests. Nothing with the tether. We are asking that
Operating with an occupant less than 16.
Yes, Judge.
She'll remain on the tether. If that's what you're trying to ask.
Thank you, Judge.
Thank you. Court does call the case of the people versus Arello Beavers.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Beavers, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
I don't have him there either.
Your Honor, I did speak to him.
Arello Beavers? We have no response.
Your Honor, I did speak to him and did anticipate that he would be here today. I don't have an explanation for his failure to appear. For the record, I'd request an adjournment.
Beavers? No, not here. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. I'll give a 10% privilege. That warrant will issue immediately.
Thank you, Your Honor.
Court does call the cases of the people versus Byron Blair.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Blair, Your Honor, who I do not believe is present.
Cedric Blair.
Oh, Cedric Blair.
Hello, who are you? That's Cedric Blair. That's not Byron.
I believe so, Your Honor, based on his voice. So as to Mr. Byron Blair, Your Honor, he does not have a working phone number. He is usually a resident of the Delana Center. I did send him an email and I did not hear back. To that end, I do not have an explanation for his failure to appear, and for the record, would request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. I'll give a 10% privilege on it. Thank you. Court does call the case of the people versus Cedric Blair.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Cedric Blair, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Cedric Blair. All right, what are we doing?
Thank you, Your Honor. There is a resolution in this matter to which my client will be pleading no contest to the added count of retail fraud in the third degree, and in exchange, count one will be dismissed.
That's correct, Your Honor. That is contrary to MCL 7503560 as in dog 4. Now you can get your $500 fine or trouble amount.
Sir, please raise your right hand. You'll need to unmute now, Mr. Blair.
I was trying to.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Cedric Blair.
All right, you can put your hand down. Mr. Blair, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that becomes the maximum fine. You understand that, sir?
Yes, Your Honor.
All right. And understanding all of that, do you still wish to plead guilty?
If I may, Your Honor.
Or plead no contest, I'm sorry.
Thank you. That's what I was just about to say. Excuse me, Your
All
Honor.
right. You understand what a no contest plea is?
Yes,
All right. Two things about it I have to make sure that you understand. First thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
yes,
Second thing you need to understand about it is it means that the court is going to treat you the same as though you had pled guilty for the purposes of sentencing. You understand that?
yes.
Basis of the no contest plea.
Potential civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes,
All right. You signed an advice of rights form, is that correct?
that's correct.
Any questions regarding any of those rights?
No, Your Honor.
You understand that you'll be giving up your trial rights, which are described in paragraph 5, as well as all the rights that are contained on that form.
Yes,
You understand you're giving up your right to appeal of it.
yes.
Are you on probation or parole? That was a question, sir. Are you on probation or parole? Did he freeze?
Yes, he did. He's here.
He's out. Okay. Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
All right. The court has been handed and has reviewed Pittsfield Township Department of Public Safety report for their case number 24-16486. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt of the defense counsel. Have I complied with the court?
Before satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Defendants referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be June 25th, 2025, 9 a.m. Bond will continue. I don't have probation. I do. All right. Bond will continue. Sir, wait on the line. We're going to put you into a breakout room with my probation department so we can start the sentencing process.
Excuse me. Hello?
Yes.
You said I'm just automatically on probation? I'm just curious.
I didn't say that.
Oh, okay. That's why I was asking, Your Honor. No disrespect.
All right. But my probation department will interview you and will make a determination. So you need to wait on the line. You'll go into a breakout room with my probation department so we can start the process.
Okay.
Thank you.
Thank you, Mr. Blair.
Court calls the case People versus Candace Brooks. You gotta come closer to the microphone. This is your first time doing this, right?
Yes, Your Honor.
Okay, go ahead.
Okay.
Take your best shot.
Your Honor, Christina Barrick-Darian requesting conditions of practice pursuant to Michigan Court Rule 8.120 under supervision of Assistant Prosecuting Attorney Ashley Lonnie.
I won't embarrass you by going through the series of questions. I did that the other day. I know where you're from, where you are, right? You're at Wayne State, right?
Yes.
Okay, good school. You like Wayne State? You do? Okay, we'll let her practice. Permission to practice is great.
Your Honor, Christina Barrick-Darian for the people. Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Brooks. Ms. Brooks, can you unmute and state your name for the record, please?
Candace Brooks.
Okay.
You know, we are requesting an adjournment. Just want a little bit more time to talk to the people about a potential offer.
Hearing no objection, I'll adjourn this matter June 4th, 2025, 9 a.m. Thank you. Court calls case of the People versus Jason Brooks.
Absolutely, the people. Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Brooks. Oh, thanks. Please state your name.
Jason Brooks.
Thank you, sir.
Your Honor, I am requesting an adjournment. I was unable to speak with Mr. Brooks prior to today. I'll get updated contact information, just make sure we have the right number for him before he leaves the building.
All right, June 4th, 2025, 9 a.m.
Thank you.
Thank you, Mr. Brooks. Court calls the case of the People versus Zachary Burlett.
That's the line of the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Burlett, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Zachary Burlett.
There he is. Okay.
Thank you, Your Honor. I have discussed this matter with the people, and it was my understanding that this was going to be a dismissal. Oh, sorry.
What did you say?
Just getting my notes pulled up, Your Honor.
Oh, okay.
One moment, but drop my screen. That's correct, Your Honor. We are going to be dismissing this case.
So certainly no objection to that.
Case is dismissed. All right. Thank you, Mr. Burlett. Take care.
Have a good day.
Thank you, Mr. Burlett.
Court does call the case of the people versus Justin Goltowski.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Goltowski, who I do not believe is present, Your Honor.
He's in.
Oh, he's in Zoom. Perfect. So my message got to him.
State your name, sir.
Justin Goltowski.
Thank you.
Thank you, Your Honor.
You're probably gonna need an adjournment.
I am respectfully requesting an adjournment. I was able to speak to, I believe it was his roommate yesterday, so I'm glad the message got passed along. That is excellent news. But I do need to talk to Mr. Goltowski himself regarding his case, so I'd ask for an
June
adjournment.
4th, 2025, 9 a.m. All right. Thank you, sir.
I got a phone number for you. It's for my attorney, if you don't mind.
What'd you say?
I have a new phone number for my attorney, if you don't
Okay,
mind.
I don't want you broadcasting it that way.
Okay.
So, you can call the clerk's office and give it, or let me give you the public defender's office number.
Okay.
It's area code 734.
Yep.
222-6970. Call them, give them your updated phone number, as well as, making sure that your email that they have is correct, and then you'll be all set.
Okay, thank you, Your Honor.
Thank you.
Thank you, sir. Thank you, Your Honor.
Court calls case of the people versus Isa Awad.
Ashley Lonnie for the people.
Isa Awad.
Your Honor, this should be Ms. Ward. I don't.
I'm here.
I'm here.
Who are? Okay.
I'm here.
Oh, there's Miss Ford's here.
Yes, Deborah Geraldine Ford on behalf of Isa Awad.
All right. And Mr. Awad?
Yes, Your Honor.
All right. I need you to turn on your camera, state your name.
Isa Awad, and my camera's not working. Give me 1 second.
Okay, well. All right, and Miss Ford, you can verify that that's your client?
Yes, that's my client.
All right, what are we doing?
I'd ask that the matter be continued to June 18th. I would at 9 appear in person. My client has stated all along that he wants a jury trial, and I'd like to talk to the other side and see if we can negotiate anything. If not, then go further.
Can't do that by the 4th?
I feel it would be a strain.
June 18th, 2025, 9 a.m.
Thank you very much.
That's gonna have to be in person because he doesn't have a camera.
I'll be in
So
person.
that hearing's in person.
We will be in person. Thank you.
Thank you.
Thank you, Your Honor.
Oh, no, let's get this done. Court calls cases of the people of the state of Michigan versus Jason David Allen, all 9 of his files.
Ashley Lonnie for the people in all matters.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Allen, who should be present via Zoom from Dawn Farm. Sir, can you please unmute and state your name for the court?
Jason Allen.
Thank you, Your Honor. There is a resolution of all 9 of these matters today, Your Honor. I don't know if it's Lonnie would prefer to put the resolution on the record, or I could do so.
I am happy to do that. Your Honor, chart 2410696, the defendant will plead no contest to this charge to retail fraud in the 2nd degree.
Hang on, which case?
696.
696, he's pleading no contest
As charged.
as charged. All right. Got it?
698,
Yes. He's doing what?
no contest to an added count for retail fraud in the 3rd. Says count 1, count retail fraud 2nd.
That's no contest to that charge also.
Yes,
They're all no contest
Yes.
from the reports I read. Okay, I hope they are. All right. Go ahead.
697,
Yes.
he'll be pleading no contest to an added count to a retail fraud in the 3rd degree, dismissing count 1, retail fraud in the 2nd degree.
All right. Okay,
328,
yes.
no contest is charged for retail fraud in the 3rd degree.
Okay. Okay.
And lastly, 278,
Yes.
no contest to an added count to a retail fraud in the 3rd degree, dismissing count 1, retail fraud in the 2nd degree.
Okay.
Case 699. And don't please use the civil cases now, 699.
700 and 2419, and then 218 would be dismissed.
That's correct. Restitution for all cases and all counts.
So basically, he's pleading to 5 counts of retail fraud third degree.
1 retail fraud second, 4 retail fraud thirds.
Okay, hang on a second. Got it. Okay, 696, he's pleading to retail fraud in second degree.
Exactly right, Your Honor.
Fine, I don't know, but is that correct? Is that a correct statement?
Yes, it is, Your Honor. That is what I discussed with my client, and that is what he would like to do today.
All right, Mr. Allen, raise your
Yes,
right
sir.
hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, state your name for the record, please, sir.
Jason Allen.
All right. Mr. Allen, it is this court's understanding that you are going to be pleading no contest to 1 count of retail fraud in the second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. Do you understand that, sir?
Yes, Your Honor.
And that also you'll be pleading no contest to 4 charges of retail fraud in the third degree. Those are misdemeanors punishable by up to 93 days in jail, $500 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would be the maximum fine. Do you understand that?
Yes, Your Honor.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right, 2 things about a no contest plea is that I have to make sure that you understand is that first of all, it means that you're not further desirous or wanting to contest any of these charges. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Basis for the no contest plea in these cases?
Potential civil liability, Your Honor.
All right. So, sir, to the charge of retail fraud second degree, how do you plead?
No contest, Your Honor.
To the charge of retail fraud third degree as contained in the case ending in 698 with an offense date of March 12, 2024, how do you plead?
No contest, Your Honor.
To that same charge of retail fraud in the third degree contained in the case ending in 697 with an offense date of March 17, 2024, how do you plead?
No contest, Your Honor.
To the charge of retail fraud third degree as contained in the case ending in 328 with an offense date of 8/29 of 2023, how do you plead?
No contest, Your Honor.
To retail fraud third degree as contained in the case ending in 278 with an offense date of November 27, 2023, how do you plead?
No contest, Your Honor.
All right, now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct, sir?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
All right. Looking at paragraph 5, those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am a participant of Judge Hunky's drug court.
All right, so you're on probation. Well, were you on probation at the time of any of these offenses?
No, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will?
Yes, Your Honor.
All right. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report in the case ending in 696, the report number 23-14001. In the case ending in 698, the public safety report and case number 244086. In the case ending in 697, court has reviewed the police report 244362. In the case ending in 328, court has reviewed the police report and case number 23-12936. And in the case ending in 278, court has reviewed police report ending in 2318100. Since I've read all those, counsel, is there any objection to the court having reviewed those reports?
No, Your Honor.
No, Your Honor.
All right, the court in each of those reports does find a sufficient factual basis in which the court could find the defendant guilty of the offenses as alleged for sufficient evidence of defendant's guilt in those cases. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's pleas?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas in all of these cases to count 2 or to retail fraud second in case 696, and in the other matters to retail fraud third. The other cases, as indicated on the record, which are no longer with me, those matters are dismissed. All
Thank you,
right.
Your Honor.
Defendant is referred to probation for pre-sentence investigation and report. Sentencing in these matters will be June 25th, 2025, 9 a.m. Defendant's bond in all of these cases will continue. Mr. Allen, I need you to wait online. We're going to put you into a breakout room with my probation department so that we can begin the sentencing process. Okay, sir?
Thank you, Your Honor.
Thank you.
Thank you, Mr. Allen.
Thanks, Natalie.
Court does call the case of the People versus Lisa Keebler.
Actually, want to go to people?
It's not a matter. Oh. Yes, I see that.
Morning, Judge. John Shea with and on behalf of Ms. Keebler.
Your name?
Lisa Keebler.
Thank you.
May we approach?
Yes.
Thank you.
All right. Record should reflect we had a bench conference in this case. I will adjourn this matter out to July 2nd without objection, 2025 at 9 a.m. Would also indicate that the defendant is to report over to community corrections for switching of her devices from a sober link to a scram tether.
Thank you, Judge.
All right.
I will be in touch with Ms. Landy and hopefully we'll move this case forward next time.
All right.
Thank you very much.
Pardon? Okay, do I have any I can call in this block? I'll try to get them. Well, no, I've still got, is your,
She on Zoom, Judge. She was on Zoom, then got kicked out for some reason. Probably something she probably has coronavirus, and now she's getting on vaccine.
you have her?
She's not currently.
All
I
right.
just resent her the Zoom ID again. She got.
We'll get you if there's anything I can do from that block and then before I take a break
Yes.
and try to get some of these folks out. So we don't fall.
And I can start calling.
Let's just roll while we can. Court calls the case of the People versus Nadia Cosley. Good morning, sir. Yoo-hoo. Cosley.
Independent as well. Oh, that's me. I'm sorry, Your Honor.
No, it's okay. You guys were in some, I don't know what kind of conversation you were in. You were in some conversation. I was willing to wait. The only reason I said anything is because of Alan. No.
Well, thank you, Ellen. I appreciate the heads up. Good morning. Assistant Public Defender Lauren Perry on behalf of Ms. Cosley, who should be on Zoom.
She is.
So we're here for one, well, I'd ask her to state her name first, please. Ms. Cosley, can you unmute and state your name for the record?
Nadia Cosley.
All right.
So we're here for pretrial, and then
There's another case.
correct. We've waived formal reading and standing to those charges, Your Honor.
All right. On our other matter, that being the case ending in 513, defendant waives for reading stands again. All right.
And then as for pretrials, I'd ask for an adjournment of both cases. She's working on getting her license back.
Okay, where is she in that process?
Ms. Cosley, do you know what you need to do to get your license back?
Yes, I just have to pay my insurance ticket. I got it suspended because I didn't pay the ticket. I'm just working with my manager to get my money.
Oh.
I've just been working. I'm in
So-
college and I'm paying rent.
Hold on.
So I'm just giving the money
You
to
said
pay the
you said a
ticket.
lot there. Hold on a second.
I'm sorry.
No, it's okay. So you got to pay the insurance case because you're suspended because of that, right?
Yes, because I got into an accident with no insurance and I never paid the ticket.
Got it. And that's the ticket we just arraigned her on? Or is it another?
There's another no insurance, I believe. But I have insurance now. I have car insurance now.
Still infraction, no proof of insurance. Still infraction, no proof of insurance.
Yeah, she didn't pay that ticket, so then Secretary of State suspended.
Suspended her license and now we have this new one.
Yes.
Okay. All right. So how much time is she gonna need to straighten this whole mess out she's created?
I will say for the record, she does now have insurance on the vehicle.
Oh, okay. Well, good.
Right. So she's making progress. She just has to get the money to pay that ticket off.
To pay that ticket off. Can she do it by the 18th of June?
Mhm.
Subway pays well. She'll get it.
My birthday is
June
also this week, so I'll get birthday money.
What'd you say?
My birthday's next week, so I'll get birthday money.
Oh, well, happy birthday.
Thank you.
June 18th, 2025, 9 a.m. Bond continued. All right, thank you. Well, I'll have to set a personal recognizance bond in her other matter. I'll just give a personal recognizance $5,000 bond. All right, thank you. Court does call the case of the people versus Sean Chernley.
Kind of still on the end of Ditchfield Township.
Which one's in the ring?
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Charnley. Mr. Charnley, please state your name for the record.
Before we go on to the other case, Mr. Chernley, you have a new matter before me. That case alleges that on or about March 24th, 2024, at the location Carpenter Road in Pittsfield Township, that you did possess drug paraphernalia. You understand the nature of that charge, sir? I do. And that's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that, sir? I do. All right. Do you wish to be represented by an attorney? I do. All right. This is a public defender case.
Your Honor, pertaining to the arraignment, we'll waive formal reading and stand mute to the charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea.
As for all the pre-trials, we're asking to adjourn all of them. Mr. Charnley is up in court, and we're kind of just seeing what happens on those. His next dates on those are June 5th.
Right.
Well, he has some May 29th. The latest date is June 5th. So I'm asking,
June 18th date?
yeah, I'm asking
What a date after those?
after June 5th, right?
All right. So, well, on his new case, I'll order standard conditions: no assault behavior, no possession of weapons, no alcohol, recreational marijuana, or any illegal drugs. I'll adjourn all of these matters then to June 18th, 2025, 9 a.m. Bond and the other matters will continue.
Thank you, Your Honor. Thank you.
I did not. 5,000. 10%. She's okay. Hang on. Let me do this one real quick. Court calls the case People versus Billy Cobb Gully.
Echelon for people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Cobb Gully, who should be present via Zoom. Sir, can you please unmute and state your name for the record?
Billy Cobb Gully.
Thank you, Your Honor. As to the case itself, there is a resolution to which my client will be pleading no contest to the added count 2 of OWI, and in exchange, count 1 will be dismissed.
That's correct, Your Honor. That added count 2 of operating while intoxicated first offense, 93-day misdemeanor, $100 to $500 fine, 6 points and various license sanctions is contrary to MCL 2576251A. They believe it will be a no contest.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, state your name for the record, please.
Billy Cobb Gully.
All right. Sir, it is this court's understanding that you're going to be pleading no contest to the charge of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could order any rehabilitative services or community service the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
Two things about a no contest plea I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
Basis for the no contest plea.
Potential civil liability, Your Honor.
Sir, to the charge of operating while intoxicated, how do you plead?
No contest.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
That is correct.
Any question regarding any of those rights?
No, sir.
Looking at paragraph 5, those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
All right, the court has been handed in, or has been provided and has reviewed Michigan Department of State Police report for their case number 9303-24. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
On a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Before satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be June 25th, 2025, 9 a.m. Bond with its conditions will continue. Mr. Gully, wait. I need you to wait on the line. We're going to put you into a breakout room with my probation department so we can start the sentencing process. All right, sir?
Okay, thank you.
All right, thank you.
Thank you, sir. Thank you, Your Honor.
Thank you. Court calls the case People versus Stephen Grisbeck.
Conrad Silver on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Grisbeck. Mr. Grisbeck, please state your name for the record.
Stephen Grisbeck.
What are we doing?
Your Honor, we're asking for an adjournment of this pretrial of the possession of drug paraphernalia case.
Okay.
He's currently serving a sentence on his domestic violence case. I've been in communication with, and just, I guess for the court's knowledge and Mr. Grisbeck's knowledge, I've been in touch with Ms. Pilara. He's at risk of losing his Section 8 housing. I know Mr. Bernstein handled that DV case. I know the court's aware of that. So she may, if he continues with the domestic violence classes, may move up his review hearing to June. They recommend that the court.
We were trying to move his case closer so his certificate or in the house wasn't in jeopardy.
I have 9 days before the 93 days is up.
I have him in custody for 55.
Your sentence is up in 9 days?
The voucher.
Oh, the voucher. You have 9 days left on that.
Are you saying that because of the amount of time you've been in custody?
So how much longer do you have on the DV classes? I'm doing the ones in jail.
Yeah, I already did 5 classes.
How many are there?
There's 12-week class. I've already done 5 of them.
You're about halfway through.
Correct.
All right. So I know we were trying to get him to a certain point so that he didn't lose that, but so I'll adjourn this pretrial to June 4th, 2025, 9 a.m. I don't want to go, if we have to do another adjournment, we'll do it, but you've been in contact with Miss Flair.
Yes.
Okay. Okay. I don't know where you guys are in your discussions, but then have Miss Blair get in touch with me so we can see if we can maintain his house.
Okay.
Okay.
I appreciate it. And if I may ask, is his bond on this case a personal bond? If we do resolve the DV case issue?
I do, yes.
Okay.
I think the last time we were talking about his housing, I set a PR in this case.
Okay.
So that everything will be clear.
So if I released, would I be on a GPS tether, correct, on the DV?
I'm not sure under what terms we would do the release. Okay, or that we're going to do it even. I know that we were trying to make everything work out for you on that. Okay?
Thank you.
All right, thank you. Oh. Court recalls the second time, case People versus Gabrielle Boyd.
Morning, Judge Ada Spahich, on behalf of Ms. Gabrielle Boyd, who's present via Zoom. Judge, again, thank you so much for passing this matter.
Ms. Boyd, can you state your name, please?
Yes, Your Honor, Gabrielle Elise Boyd.
Your counsel told me to issue a bench warrant. She told me, she said, go out and find her. I had faith that she'd show up. I'm just letting you know.
I'm so sorry, Your Honor. I would never leave you guys. I would never do that. I would never stand off like that.
Okay.
Thank you, Judge. I
It's
appreciate
okay.
it.
No.
Fire me and then we're going to do that.
The reality is your client, your counsel stood up for you and had me pass it and everything and had me not issue the bench warrant.
I appreciate that so much.
All right.
Thank you so much, Judge. Last time we were here, we adjourned the pre-trial because I needed some time for discovery. I have received all discovery. I have reviewed it. I am speaking with the sister counsel with respect to just if there's a way that we can resolve this case. There might be some potential legal issues in the case. I just needed some more time to discuss it with Ms. Landy because we might be able to resolve it short of me filing a motion. So that was just going to be a quick adjournment, and I wanted to address the bond as well, Judge.
All right. So will the 4th be enough time for you? Or
So, Judge, this is another thing. If I could, I know. I'm sorry, Judge.
man.
I know.
No, go ahead.
We're
taking all day with this case anyway.
I know. I might as well, I am going to be going out of town to visit my family back home in Bosnia. So, I work when I'm there as a solo practitioner. I can't really take a lot of time off. So I work while I'm there. So I'm going to be appearing via Zoom. If you could give me the June 18th date, just because I'm traveling on that 3rd and 4th, it takes a long time to get there. If you could give me the 18th date, I can appear via Zoom. If this is okay with you, Your Honor, and obviously allow my client to appear via Zoom. I will be working. I will be in communications with Ms. Landy.
That's fine. We'll do that for you.
Thank you, Judge. I appreciate it.
All right. June 18th, 2025, 9 a.m.
Thank you, Judge. And
as your invite indicates, yes, that's the bond.
just with the bond, yes. Judge, you previously granted my client a request to travel with her family on a cruise starting tonight, until May 31st.
I did that?
Yes, Judge, that was granted. However, I did not take into consideration the travel time back from Europe. So she's actually coming back June 1st. So I was going to ask for just that one additional day. I didn't want her to just assume that she can come back on June 1st without asking you directly, Judge.
I'm trying to see. Did I sign an order? I did. Okay. And so your travel date is the 1st of June.
So we fly back the 31st from Barcelona, but apparently time-wise, since they're 6 hours ahead, it will be the next day. So that's what my mom told me, at least, is that we will be arriving early on the 1st, but we will be departing for travel on the 31st.
You know what? You've got till June 2nd to get back. I'm not going to do international date lines or anything. I'm done with that. So you have till June 2nd.
Okay, I'll for sure be back by June 2nd, for sure.
Perfect, Judge. And then one more request, and I will leave you alone, Judge. I
really?
swear, I know you're gonna.
Really?
Me. At least I don't come
It's
get that
my
often.
fault.
No, you don't.
You know,
but
so
when you're here, there's a lot of requests. Go ahead.
yes, Judge. So my client has twin sisters who are, who have their last performance as the lead of their Broadway musical in New York. So the whole family is going to that
What?
show from June.
So they're
6th
going to
through
Barcelona and New York.
No,
in June.
so
That's in
mine-
June.
Yes.
So that's from
mine-
June 6th to the 9th, and I'm respectfully requesting that you allow my client to travel to New York with her family from the 6th to the 9th to attend the show, the musical, that her twin sisters are participating in.
So hold it. She's going to Barcelona. She comes back. I've
Correct.
given her to June 2nd.
Correct.
She's then gonna like basically catch her breath and then she's off to New York.
And then,
Yes,
yes,
which is gonna be very tough because I travel to Europe quite a lot and it's exhausting.
My twin sister's been the lead of a Broadway musical for the last year and a half. Her
So
last.
hold on. It's not so it's your twin?
It's my twin sister. She's my twin.
Oh,
yes.
no,
Sisters, not
there's like two of them.
Yes.
Well, there's like five.
Oh, she-
There's
there's-
five daughters.
I know, but there's 5 daughters.
I believe
Yes.
so, right, Miss Boyd? Okay.
Yes,
Wow.
there's 5 of us total, and she is extremely hardworking, a U of M musical theater graduate. It's really important to her that I be at her last show. She's expressed to me, and
She
I also
wants her twin there.
she has stated that to me very clearly that she wants me.
So I'm supposed to do this for her.
For me, Your Honor, because I would really love to be there to support her. I would be traveling via train with my grandfather to take him because it would be his last opportunity to see her. So
Oh,
it's
okay.
yeah.
You sold me. I'm done.
Okay.
I'm done.
Thank you, Ms.
What
Boyd.
dates? What dates are there?
June
June
6th
6th
to June 9th. We will be back the 9th.
Council, if you can prepare an order,
I will, Judge.
like just that includes both of your clients.
I will make sure I prepare a new order.
All right.
So it'll include both, and I'll make sure I file that today.
Thank you.
Thank you, Judge. Thank you so
Take
much for your
care.
patience.
So
Thank you,
much.
Ms. Boyd.
Godspeed to all of you on your journeys.
Thank you so much, Your Honor. I appreciate you.
You're welcome. I know. I will. Court calls the case People versus James Gann. Do I want? I don't know. I'm gonna, yeah, at some point I've got a break. It's been going a while here, but.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Jantz, who stands to my right, please state your name for the record, sir.
Thank you.
Thank you, Your Honor. There is a resolution in this matter to which Mr. Jantz will be accepting the offer extended by Mr. Stiller, pleading guilty to the charge of MCL 257326, and in exchange, count 1 will be dismissed.
So, Your Honor, I move that counsel allowing an ineligible person to drive MCL 257. Plea. Original charge.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yeah. State your name.
James Gann. Sir, this is court's understanding you're gonna plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. Is that correct?
Yes.
That's a misdemeanor. It's punishable by up to 90 days of jail, $100 fine plus court costs. You understand that?
Yes.
Still wish to plead guilty? To that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5, you'll see a copy up there. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Bless you. You understand you're giving up your right to appeal of.
Yeah.
Are you on probation or parole? Has anybody promised you anything in order to get you to plead? Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty of this offense?
Yeah.
On the date. Oh no, she's coming back. On the date of January 21st, 2018. Is it 18 or 19?
31.
2019. Location of Carpenter Road near Washtenaw Avenue in Pittsfield Township, Washtenaw County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who is otherwise ineligible, maybe inclusive of yourself, to operate that motor vehicle?
Yes.
Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Anything you want to say before I impose sentence in this case?
Just briefly, Your Honor, I would ask the court to consider sentencing my client to the state minimum fees and time served. It's my understanding he served about 31 days in custody. He's being held on another matter on a $10,000 bond. I would ask, given that, the court would consider the state minimum and time served for sentence.
Is there anything you want to say?
No.
$125 statutory fees, 31 days in jail, credit 31, sir.
Thank you, Your Honor.
Court calls case People versus Ashton Ebler.
People.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Ebler, who appears via Zoom. Sir, can you please state your name for the court?
Ashton Ebler. All right, what are we doing?
Thank you, Your Honor. I believe we are very close to a resolution. I'm respectfully requesting a very brief adjournment. I did provide some documentation to the people, and I believe they just need to check with the officer in charge.
June 4th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you, sir.
Court calls case People versus Carl Tinsley.
People.
Is that what Johnson was here on?
Yes.
Is that, you gotta watch, Alan, did you see him sitting over there in the corner? He was hiding. He comes in here and hides. Go ahead.
Good morning, man. Please, this Honorable Court, Kareem Johnson, on behalf of Carl Tinsley, who's approaching from custody.
They're ringing. Your name, sir?
Carl Tinsley.
Thank you. Just step over. Yeah, there you go. All right. Okay, what are we doing?
Your Honor, we ask this matter be set for jury trial.
All right. Jury final settlement conference, June 6, 2025, 9 a.m. Jury selection, if necessary, June 9th, 2025 at 8:30. Both of those proceedings are in person.
Your Honor. I'm sorry. I'd like to speak.
Okay, hold on. Yeah, counsel first.
I have jury selection Lawrence Buckner in the Ypsilanti District Court on June 9th.
Jury selection?
Yes, Your Honor.
Before Judge Barr?
Yes, Your Honor.
It'll be here.
Okay.
We all select on the same day.
All right.
So.
Your Honor, if I may, so Mr. Johnson and I are at a fundamental difference in strategy. There's no point in us moving forward together on this case. Mr. Johnson is representing me in circuit court. I've submitted a motion to have Mr. Johnson remove his counsel in that case.
Why?
Excuse me? Why? Because Mr. Johnson is totally uninterested in this case, in that case, in this case
Mr. Tinsley, you've been before me before, and I'm just going to tell you this.
Okay.
I haven't known Mr. Johnson necessarily all that long.
Okay.
But I'm going to tell you for maybe about the past year plus that he's been appearing before this court, there has not been a client that he has walked into this court where he has not been interested in their case and zealously representing his defense. So I don't believe you. You coming before telling me that about this attorney, I don't believe it for 1 minute. Not 1 minute. I think because you've been before is that you're probably not listening to him. He is advising you. I can guarantee he's protecting every right you have.
And you'd be absolutely wrong.
Fullest.
I have not seen this gentleman has told me he's going to show up to see me countless times at the county jail. He has not. I've been waiting over 2 years for discovery in another case at all. This gentleman doesn't answer his phone. You're making these assertions without having personal experience.
I'm done.
I'm
done. If you want to file
a tool for defense.
If you want to file, Mr. Tinsley, you're done. You're done. You are done.
Yeah, I think I need to respond to the 2-year comment. Mr. Tinsley does have a matter that's been pending for 2 years. I'm the 4th attorney on that matter. I have only been representing him since April. When I go to speak to him, he doesn't want to talk about what I want to talk about, Jan. So I just want to clear that up for the record.
And Mr. Johnson, I meant my words sincerely. I've dealt with Mr. Tinsley before. It's the game he plays. So I'm done.
All right.
You're still on this case, regrettably, but you're still on it. All right. Take care, sir. Court calls the case, People versus Otis Elliott.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Elliott. Mr. Elliott, please state your name for the record.
Otis Elliott.
Your Honor, my client and I have spoken about this case. We are asking for an adjournment. It's a little bit old. We are gonna do an investigation, and do some things, speak to people about.
Well, it's old because he was like benched.
He wasn't benched.
He was like 2 years. That's why it's old.
Yeah, but he's back here now, so.
Well, kinda. All right.
Hopefully we'll get things back
So you
on
want
track.
another adjournment to what day? What, you want the 18th or
I'll
the
take
4th?
18 if that's okay. Fine, thank you.
You're gonna come back, right?
Yes, sir.
All right. June 18th, 2025, 9 a.m. All right. Take care. We'll see you then.
Thank you, Judge.
Thank you. Court calls the case, People versus North Kasham.
Conrad Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Sham, who stands to my right, please state your name for the record, sir.
Okay, Sam.
How you doing?
Morning, Your Honor.
Good morning, sir.
Thank you, Your Honor. I do want to apologize to my client. I did just find out this morning that he was in custody, so I was.
Me too.
So, which explains why he didn't respond to me. He does.
I was following the case and I expected maybe, okay. Okay.
So, he's not being held on this case, Your Honor. I'd request a brief adjournment to probably get that documentation regarding his vehicle to resolve this.
But June 4th, you think? Would June 4th work then?
Yes, definitely, Your Honor. Thank you.
I'll adjourn the matter June 4th, 2025, 9 a.m. Yeah, for sure. So did you have a PR on this?
Let me check. I believe so. She could see it.
Yeah, I think I've got a PR on this case. I was gonna leave that if you want me to leave it, or do you want?
That would work if it was held as a PR, Your Honor.
Or do you have? I just want to make sure he does.
This
So that
actually has a $1,000 cashier.
I did. But that was
That's back in January. I don't have anything else.
That was January, and then I set it at 10%, but then I said to be a PR on January 15th. And
Yes.
apparently nobody changed it. So, I'll just do it this way. I'll set it at a PR $1,000 bond on this case.
Thank you, Your
That
Honor.
way, it just,
Yes.
okay.
Thank you, Your Honor.
All right, thank you. Thank you. Thank you, Mr. President. Court does call the cases of the People versus Sarah Gray.
Conrad Silver on behalf of Pittsfield Township.
Ash Shalani for the people. Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Gray. Your Honor, I have not had contact with Ms. Gray. I did provide her with. I'm not sure if she's pregnant.
Are all three on?
So bottom one of yours, bottom one. We don't have.
She's not on the thing.
I have no explanation for her. I request them.
Bench warrants will issue for the defendant's failure to appear in these matters. Bond will be set in the amount of $5,000. I'll give a 10% privilege on each case, and each case sale will issue immediately.
What was the bond that was on the
5,010.
on the felony as well?
The felony, actually, I don't think, felony already has a warrant.
That's okay. Thank you, Your Honor.
Court calls the cases of the People versus Christopher Minor.
That's the people.
Conrad Silver on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Minor. State your name, Mr. Minor, please.
Thank you.
So, Your Honor, we have made a little bit of progress. We were waiting to see what happens with the felonies. He has pled on those felonies to all misdemeanor cases, or all misdemeanor charges. His sentencing is scheduled for June 5th, I believe. I'm sorry.
On the misdemeanor cases? On the
Sorry.
felony cases that are now misdemeanors?
The sentencing is scheduled for June 9th. So we're just asking for a date after that to see what he's sentenced to and hopefully, if, depending on what it is, get some parity with these.
Got it. So June 9th is when his sentencing is on those other ones, right?
Right.
All right. So I'll adjourn these out then to June 18th, 2025, 9 a.m.
Thank you, Your Honor.
All right.
Thank you.
All right. Thank you, sir. Court calls the cases of the people versus Larry. Is it Wikima? Yeah.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Hawkema.
You don't have him in Zoom?
Okay, well, I did speak with him, Your Honor. He does have a valid license now. I'm not sure why he's not here. I did provide him with the necessary information. I would request an adjournment on all three cases.
He has a valid? Yeah, he does. So there would be some type of deal on these, correct?
Yes, that's what I'm hoping for.
All right, I'll adjourn it out one time. I'll grant you the adjournment. June 4th, 2025, 9 a.m. on all matters. Figure out what we're. Court does call the case of the people versus Daniel Sims.
Echelon for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Sims, who is approaching. Please state your name for the record, sir.
Mr. Sims, Daniel Sims, sorry.
Thank you, Your Honor. I have discussed this.
I'm not all the way awake, I'm sorry.
You don't know your name? All right, no, go ahead. You're all right.
At least you said Mr. Sims. I mean, it's still correct.
I just repeated her, I'm sorry.
So, Your Honor, I have discussed this matter with my client as well as the people. We are wishing to set this case for final settlement conference at this time.
All right, jury final settlement conference for Mr. Sims will be June 6, 2025, 9 a.m. Jury selection, if necessary, June 9th, 2025 at 8:30. Both of those proceedings are in person.
Thank you.
All right, all right. Thank you.
Thank you, Your Honor.
Go back and get some sleep. Court calls the case of the people versus DeJohn Holmes. 3 cases.
Echelon for the people.
Pardon?
Conrad Silver on behalf of Pittsfield Township.
I don't.
He was. I didn't hear your first part.
I don't have him having comment.
Oh, I don't know either. DeJohn Holmes, I think because we've issued bench warrants, but I don't even know why these are on. Did he do a warrant?
There might have been one.
I don't see the paperwork. All right. Let's go through the motions again. Bond in each of these cases will be set in the amount of 10,000, 10%. Those warrants will issue immediately on all these matters. Court calls the case people versus Jason Williams.
Echelon for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Williams. Ms. Williams, please state your name for the record.
Jason Williams.
We're here for a pretrial hearing. I also filed a bond motion on behalf of Mr. Williams.
All right.
I would rely for the most part on the written motion. However, I do want to emphasize a few things. I did speak with Mr. Williams, his therapist at his substance abuse treatment center. He did do a number of sessions before being for his bond being remanded, including 8 group therapy sessions, 6 individual therapy sessions, and 8 AA sessions. She did indicate due to his positive test, they'd love to see him back, and that they would recommend extending his treatment for an additional 90 days. I also spoke with his employer. They gave him a 30-day leave of absence. He is welcome to go back to his job if and when he is released. And they all
Works
seem
at U-Haul.
at U-Haul, correct, in Novi. They all seem very happy with Mr. Williams' performance, and do want him back. He has been in custody for 28 days as of today. So given that, I'm asking for the court to consider releasing him on a personal bond. We've spoken many times since he's been remanded. I think this is the first time he's ever done any time in jail. He's had a lot of time to think about his choices, and I think he's ready to get back on the wagon, get his life back on track, and take care of what he needs to do. He's willing to provide the court with progress reports of how his treatment is going. I think he'd be willing to wear a scram tether or any increased bond conditions the court may recommend.
Anything from the people?
Now, with a history of non-compliance while on bond, the people would request electronic monitoring of some kind, preferably a scram tether, perhaps just for the interim, to make sure that the defendant is not going to be taking a lot of bond with this operating while intoxicated offense.
Anything you gotta say, Ms. Ford?
No, sir.
Been an educational experience for you, hasn't it?
Yes, during these 28 days when I was here, I did learn a lot. I did become better. I had a lot of time to think. I have grown since I've been here. Like, at the end of the day, you have to be responsible. You have to obey the law. You have to do what you need to do and be able to just act the life and do what you have to do when it's all said and done.
Sorry it took this for it to come to that, but however, we have to learn that, right? I'm gonna set his bond at a $25,000 personal recognizance bond with his previous conditions reinstated. Scram tether prior to release.
Thank you, Aaron.
All right. And then how much time did you want me to adjourn this out?
I think June 4th should be sufficient. I just need to have another conversation with Ms. Lundy.
Adjourn it to June 4th, 2025, 9 a.m. All right. Thank you, sir.
Thank you, Aaron.
Court calls the cases of the people versus Jermaine Nathan. 3 cases.
On behalf of this township.
And Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Nathan, who is present via Zoom. Sir, can you please state your name for the court?
Jermaine Nathan.
Thank you, Your Honor. I have discussed this matter with my client, all 3 of his cases. There was an offer extended in the township case. Ultimately, we're asking for a 4 to 6 week adjournment in all 3 cases to see if Mr. Nathan can become validly licensed.
Okay. So he's trying to get his license back.
He is. He just needs to check on some things. But yes, Your Honor.
I'll adjourn July 2nd, 2025, 9 a.m.
Thank you, Your Honor. Thank you, Mr. Nathan. You're all set.
Thank you.
You're welcome.
Sorry. Court calls the case people versus Rick Artuso.
Ashley Lonnie for the people.
Probably. Artuso. You know, Got it. Go.
Thank you, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Mr. Artuso in two of the matters, but not on the case ending in 217. I believe that is Mr. Burgess' case, Your Honor.
It is. And do we know, anybody know whether Mr. Burgess is gonna?
I have not had communication with him, Your Honor. No, I cannot speak to that.
Got nothing from him this morning. Okay, well, what were you gonna do on your case?
So we were going to ask for a very brief adjournment so I can confirm the status of my client's license and provide that to the people. I have discussed this matter briefly with them regarding both of the cases I am on. So I'd request a very brief adjournment. He is being held on a felony matter with his next court date being the 29th
Of
May.
Okay. Well, why don't I do this? There must be some mix up because Mr. Burgess is usually here. Have you spoken with him, sir?
No, I have not, Your Honor.
You haven't? Okay. Then there's something.
And Your Honor, Ms. Payne, I believe did alert me as well to the two ticket cases. It may be duplicated. So it may be duplicate files. So I need to review those as well. So the 6/4 date, if the court would so kindly be one.
Yeah, I will adjourn it to that day. We'll just put it out to June 4th. All right.
Thank you, Your Honor.
And Ms. Payne, if you could be so kind as to, for your client's sake, let Mr. Burgess know.
Absolutely.
Okay. So, sir, I'll adjourn this out June 4th, 2025, 9 a.m. All right?
Thank
you, sir.
Thank you, sir.
Court does call the case of the People versus Rashad Shafi.
Conrad Solar on behalf of Pittsfield Town.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Shafi. State your name for the record, please.
Yeah, he's in jail.
Yes.
Mr. Shafi?
Hello,
Hello. State your name.
Rashad Shafi.
Thank you.
I'm
He's
requesting.
not driving, is he? Stop.
Hey, do you see me?
Moving. You're a passenger. Okay.
Well, Mr. Shafi is maybe on his way to Bear River right now. He's going to Bear.
Where you're heading?
That's exactly where I'm going. I got these gentlemen that picked me up at Bear River or at my house, and we're going.
Okay, everybody's gonna wave now.
I like the view.
All right.
So as part of the plea agreement, if Mr. Shafi completes treatment, this case will be dismissed. So I'm asking, he may be there for a 30-day period or 60-day. As the court knows, there's an assessment that's done. And so I asked maybe go out 30 days, and if he's still there.
Yeah, I got you. So I'll go to July 2nd.
Okay.
2025. 9 a.m.
Thank you so much, Your Honor.
Not a
Appreciate
problem.
you letting me go to retreatment.
Not a problem, sir. I appreciate that you had the courage to do it.
Mr. Shafi and I go back 30 years, Your Honor. So,
Really?
I'm familiar with it.
All right.
So, yeah.
All right. His bond will continue. Mr. Jaffe, good luck to you, sir.
Thank you so much.
Court calls case, People versus Kevin Kernan.
Conrad Solar on behalf of Pittsfield Township.
And good morning, Your Honor. Joseph Paul appearing for on behalf of Mr. Kiernan, who is approaching. And Kevin, if you could state your name for the record, please.
Kevin Kiernan. Thank you.
You have an agreement, Your Honor. On that count 2 of civil parking. Defendant's going to admit responsibility to that count 2. We accept it and move to dismissal.
That's a correct statement, Your Honor. I have authority from the client to admit responsibility on his behalf, and I do so for Your Honor's purposes.
All right. Court will accept that admission. To count 2, count 1 is dismissed. Fines and cost of $180. When can that be paid?
Your Honor, can we get 14 days to pay, please? I said please.
You got $180.
I said please, Judge.
Pay it by June 6th.
Thank you very much, Your Honor.
Thank you. Thank you, folks.
Take care. Yep.
Court calls the case of the people versus Jessica Fox.
Ashley Lonnie for the people.
Good morning, or good afternoon, Assistant Public Defender Lauren Perny on behalf of Ms. Fox. Ms. Fox, please state your name for the record.
She isn't in my front.
You read her?
Yeah. Lonnie Jessica.
Okay, I think I got it.
Okay, your name?
Jessica Fox.
All right, very good. All right.
Your Honor, I did, just last night, Ms. Fox did get proof of her treatment and, tests for the last, from July to December of last year. I did confirm that she was negative for alcohol in all of the tests, and she did complete, treatment for quite some time. I think she started back in, 2021 and then completed in 2024. I can provide that to the court if the court would like that. Given the nature that I just did get that to the people last night, I am requesting an adjournment for further plea negotiations, and hopefully that can assist us in coming to a resolution.
June 18th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
All righty. Thank you, Ms. Fox.
Thank you.
Court does call the case people versus Freyon Haywood.
Ashley Lonnie for the people.
I'm sorry.
This is a show cause for them to appear.
So show cause is already been issued.
Yes.
Freyon Haywood, no response, bench warrant, 5,000. 10%, that warrant will issue immediately. Court calls case people versus Christopher Holt.
Ashley Lonnie for the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Holt.
He's on. Christopher Holt.
Yeah, good morning. This is Christopher Holt.
All right, thank you.
So, Your Honor, I apologize. I'm asking for one last adjournment. Mr. Holt and I did speak about the offer. I think we're getting very close. We just need to finalize some details.
All right. June 4th, 2025, 9 a.m. Bond continue. All right. Thank you, Mr. Holt.
Thank you, Your Honor.
Court calls the case people versus Micah Jones.
Ashley Lonnie for the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Jones. Your Honor, I attempted multiple times to contact Mr. Jones. I was not successful. I don't see him here in the courtroom. Not sure if he's on Zoom. I don't have an explanation for his failure to appear, and for the record, I would request an adjournment.
I got two screens, so I don't.
He's not.
You don't have it. All right. Jones, Micah Jones, no response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 5,000. With a 10% privilege. That warrant will issue immediately. Court does call the case of the people versus Pauline Macharia.
Ashley Lonnie for the people. Assistant Public Defender Natalie Tate, with on behalf of Mr. Charia, who should be present via Zoom.
Yes.
Can you please unmute and state your name for the court?
Pauline Macharia.
Thank you.
Thank you, Your Honor. I'm respectfully requesting an adjournment. I have discussed this matter both with the people and my client. I believe this is a case that will ultimately be able to be resolved, but we just need to speak about a few more things before that happens. I agree, Your Honor.
June 18th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor. Thank you.
Thank you.
Thank you.
Thank you, ma'am. Court calls the case people versus Rebecca Miller.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Tate, with and on behalf of Ms. Miller, who appears via Zoom from Dawn Farm. Ma'am, can you please unmute and state your name for the court?
Oh, there she is. Can you unmute, Ms. Miller? If you can't, oh, see ya. If you hold on the space bar, you'll be good.
Okay, I got it. Thank you, Jonathan. Sorry, I
All right.
wasn't unmuting.
Your name?
Rebecca Miller.
Thank you.
Thank you, Your Honor. So the people have extended an offer in this case that I was able to briefly discuss with my client yesterday. However, she is inpatient at Dawn Farm. We were just able to connect for a phone conversation last night. So I'd be requesting an adjournment to further discuss that with her, and then if she would like to accept that offer, days of property.
Adjourn the matter June 4th, 2025. 9 a.m. Bond continued. All right, thank you, Ms. Miller.
Thank you, sir.
Court calls the case, People versus Kiana Patterson.
Ashley Lonnie for the people. Assistant Public Defender Natalie Pate on behalf of Ms. Patterson, who may be present via Zoom.
I'm down to one screen. Patterson, I don't have one.
I don't have an explanation for Ms. Patterson's failure to appear. I did leave her a voicemail, but unfortunately did not hear back. For the record, I request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. Give a 10% privilege on that. That warrant will issue immediately. Court does call the case of the People versus Alicia Stewart.
Ashley Lonnie for the people. Assistant Public Defender Natalie Pate with on behalf of Ms. Stewart, who will be present via Zoom. Ma'am, can you please unmute and state your name for the record? She's not.
She is also not checking.
Your Honor, I did speak with her and asked for an adjournment. She did end up having her administrative hearing date with the Secretary of State on May 1st, and we're still awaiting a decision. I did provide her with a Zoom and expected her to be here. For the record, I request an adjournment.
Alicia Stewart, no response. 5,000, bench warrant 5,000, 10%. Warrant will issue immediately. Court calls case of the People versus Jada Taylor.
Ashley Lonnie for the people.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Taylor. Ms. Taylor, please unmute and state your name for the record.
Hi, Judge.
Your Honor, we're asking us if this for final settlement conference.
Jury final settlement conference, June 6, 2025, 9 a.m. Jury selection, June 9th, 2025, 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you.
Thank
All right,
you.
thank you, ma'am. Court calls the case of the People versus David Wagner.
Ashley Lonnie for the people.
David oh, there he is. Okay. I kept looking at my screen and didn't realize there were actual people here. No. Your name, sir? David Charles Wagner Jr. All right. Sir, you are, this is all right. You are before the court on a misdemeanor complaint that alleges that on or about September 26, 2024, at the location of 2224 Gulfside Road in Pittsfield Township, Washtenaw County, State of Michigan, that you did fail to provide proper care and or work beat 2 or 3 animals, contrary to Michigan statutes. That's an abandonment or cruelty of animals statute. You understand what you're charged with, sir? Yes, sir. All right. That's a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Court could order community service also, or any combination of those penalties. You understand that? Yes, sir. You also understand that the court could order a psychiatric evaluation and may order cost of care of housing any animals that were seized, as well as either housing costs or veterinary costs. You understand that? Yes, sir. And I also could order that you not possess or own any animals. You understand that? Yes, sir. All right. First question I have for you is, do you wish to be represented by an attorney? Yes. This is a public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Wagner, we would waive any further reading, stand mute, and ask for an adjourned pretrial date, please.
And in every way, formal reading, standing mute, court will enter a not guilty plea in this case. Pretrial in this matter will be adjourned June 4th, 2025, 9 a.m. As to bond.
Your Honor, people do request standard bond conditions and unsecured appearance bond. We also are going to make a request that while on bond, the defendant have no animals in his ownership or custody or control.
Not in my name. Yes. I have 4 cats and two dogs. They belong to my wife, my kids. Anything you want to say, Ms. Payne?
Just briefly, Your Honor, I would ask that those animals be allowed to stay in the home. He states they belong to his wife and children, understanding that my client should not have any interaction with those animals, so to speak. I would ask that he be allowed to remain in the home, certainly, and ask that the pets not be removed from his wife and kids.
You said there were how many cats? 4. And 2 dogs? Yes, sir. What kind of dogs? One is, it's a small dog. That is my wife's dog. It's a poodle. Yorkie poodle. That's my wife. That's my, okay. What kind is the other dog? All right, here's what I'm gonna do. Gonna set his bond at a $10,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drug use. I'm gonna indicate the defendant is not to have contact with or have possession of any animals. Yes, sir, I understand. So I'm going to indicate that with reference to the 4 cats and 2 dogs, I would need either veterinary paperwork or others type of purchase paperwork that would indicate by the next hearing, that would indicate that these animals have ownership with someone else other than the defendant.
Yes, Your Honor.
Yes. Otherwise, so that we're clear. If I don't get that, I think what's going to end up happening is I'm going to order all of them removed from the home. All right? Understood. All right. Thank you. Thank you. We'll get this number to you.
Yeah, that was 6-4 or 6-18, I'm sorry.
6-4.
Thank you.
Court does call the case People versus Kalaya Williams.
Ashley, one of the people.
This is a show cause for people to appear for.
It's a show cause.
Yes.
It is. Kalaya Williams. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give it 10% privilege. That warrant will issue immediately. Court does call the case of the People versus Monai Williams.
Ashley, one for the people.
This is an arraignment.
Yes, sir.
Monai Williams. I'll issue an order to show cause on this.
Thank you, Your Honor.
Court does call the case People versus Sammy Alderson.
This is Public Defender Natalie Pay on behalf of Mr. Alderson, who gave me authority to accept the offer on his behalf.
So, Your Honor, I move to add count to double parking. Defense counsel is going to admit responsibility if you accept it and move to dismiss.
And you have authority to accept that?
Yes, Your Honor.
And on behalf of your client, do so?
I do so, yes.
Okay. Court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can they get that paid?
Your Honor, I did have a long conversation with Mr. Alderson. He receives SSI and was just asking if the court would give him as long as possible to pay. So I told him that.
Do we know how much the SSI is?
I don't know exactly, or I should say I did not write down how much he gets monthly, Your Honor. He did say that he knows for a fact he could pay it within 6 months or by the end of the year. So I said I would explain to Your Honor the situation after.
Yeah, without knowing what his SSI is. So here's what I'll do. I'll indicate that he needs to pay that by July 31st. Okay, so that'd be 3 months. That'd give 3 months if. Okay. Court does call the case People versus Audrey Beatty.
Conrad Solar on behalf of Digital Township.
Chief Casey.
I'm here, Your Honor. Good afternoon, this is the Public Defender Lauren Perny on behalf of Ms. Beatty. Ms. Beatty, can you state your name for the record? Audrey Beatty. All right. So, Your Honor, we have come to resolution. Ms. Beatty got her permits. She passed her driving test on Monday. I did provide that to Ms. Miller. I hope. I did email it over yesterday.
You got her permit when?
She passed the test on, Monday.
And I do have a copy of it, Your Honor.
You did, okay.
I do, so. In case 1391, she's going to admit double parking.
Okay.
So I had that count to double parking in 1391. If you accept that admission, move to dismiss the original misdemeanor as well as case 1392.
Correct, counsel.
That is correct, Your Honor. I actually would like to accept that offer today.
All right. And Ms. Beatty?
Yes, Your Honor.
All right, do you admit responsibility to the fact that on August 10th, oh my goodness, 2016, at a location of Michigan Avenue in Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle?
Yes, Your Honor.
All right, court will accept that admission to count two. Count one is dismissed, and that's in the case ending in 1391. And also case ending in 1392 is dismissed on the prosecutor's motion. Fines and costs of $180. When can you get that paid, ma'am?
By Friday, Your Honor. This Friday, Your Honor.
This Friday?
This upcoming
Okay.
Friday.
It's 16? No, 23. Working on Alan's calendar. I know. I resisted, but now it's all on. All right, pay it. Ma'am, pay it by the 23rd, okay?
Yes, Your Honor.
Actually, no, here's what I have to do, ma'am. Pay it by the 27th. I'll give you till after the holiday. Okay,
Thank you, Your Honor.
thank you. All right,
Thank
you
you.
have a great day.
You have a better one. Thank you.
Court does call the case of the people versus Tasha Beavers.
I'm going to have a Pittsfield Township.
This isn't the right one. Oh, hello.
Hello,
What's your name?
Tasha Viewers.
All right. Ma'am, you are before the court on a misdemeanor complaint or citation that alleges that on or about April 18, 2025, at the location of Twin Lakes Drive in Pittsfield Township, Washington County, State of Michigan, that you were in possession of drug paraphernalia. You understand the nature of that charge, ma'am?
Yes,
That's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. Do you understand that?
yes,
All right. So first question I'll ask you, ma'am, is do you want to be represented by an attorney?
yes.
It's a public defender case, please.
Good afternoon, Assistant Public Defender Lauren Penny on behalf of Ms. Beavers. We waive further reading, standing it to the charges and request another pretrial date, please, Your Honor.
Defendant have a way formal reading. Standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to June 4th, 2025, 9 a.m. Bond in this case will be set in the amount of a $10,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or any possession of weapons. I will indicate that there's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand all of that, ma'am?
Yes,
Ma'am, if I sent you over to test now, would you come back clean?
I have marijuana, Mrs.
Pardon?
No,
What would show up?
marijuana,
Do you have a medical marijuana card?
no,
Is that the only thing that would show up?
in my medicine.
I'm gonna order drug of choice in this case goes a while.
Marijuana,
I'm gonna order one time per week random testing at community corrections. I want the defendant to test today.
Do you have $12?
no.
Okay.
All right, thank you. We'll see you on the 4th. Yeah, because I got to get in order.
Yeah, thank you.
Court does call the case of the people versus Kia Berry.
Conrad Soto on behalf of Pittsburgh Township.
Public Defender Natalie Caitlin on behalf of Ms. Berry. Ma'am, can you please state your name for the record?
My name is Kia Berry.
So Your Honor, Ms. Berry is scheduled to retake her test again this coming Friday.
Which part? The written or the
It
driving?
might be the road or the written test. Is that correct?
Okay.
Ms. Berry?
Yes.
Okay.
I'm very hopeful as is she that she'll pass. We're asking for an adjournment so that she can take that test.
What's this, May 12th? All right, I'll adjourn this. I finally saw one. Hang on, I'm correcting. I'll adjourn this. June 18th, 2025, 9 a.m.
So June 18th, is that right?
Pardon?
June 18th at 9 a.m., right?
Yes, ma'am.
Okay. Thank you so much.
All right, thank you.
Thank you. Thank you.
Court calls the case, people versus Daniel Bowe.
Conrad Soto on behalf of
This
Pittsburgh.
one. Yeah.
Assistant Public Defender Natalie Pate and on behalf of Mr. Bowe, who stands to my right, please state your name for the record, sir.
Daniel Robert Bowe.
Thank you.
Thank you, Your Honor. So actually, Mr. Bowe is going to be accepting the offer extended today of double parking, but he did want to appear to speak with Your Honor as well.
Your Honor, he does have a temporary instructional permit, so I'm going to move that count 2 of double parking. Accept that admission and move dismiss the original charge.
All right.
I was just wondering if.
Hold on, let me do this
all right.
part. Now, I'll hear from you, okay? Hold on. Just hold on a minute. I can get to that. Mr. Bowe, do you admit responsibility to the fact that on July 12, 2024, at the location of Carpenter Road in Pittsfield Township, Washington County, State of Michigan, that you did double park a motor vehicle?
Yes, sir.
All right, court will accept that admission to count 2. Count 1 is dismissed. All right, what do you want to tell me?
Only thing I was asking is there any way I could get my fines and costs waived? Because I had to pay $3,400 to get my license back, and I'm about flat broke. I literally just paid. I think it was $34.50. I paid a little over $3,400 to get my license.
For what?
Huh?
Tickets and stuff?
Well, I was in prison during COVID, and my sister got a ticket in Livonia in my vehicle, and they didn't pull her over, but they issued the ticket to my plate, and it lapsed, and it turned into like over $3,000 in tickets. I ended up having to pay them. So
not from one ticket, but
no, it was because my car wasn't registered while I was in prison, and she drove it. So it got hit with no registration, no invalid plate.
Now he's here blaming his sister.
Well, no, I mean,
no, you see what happened?
I still paid it.
You know, you see what he's doing?
I still paid
He came in and he said,
but-
"Yeah, I want to go before the judge because I'm gonna blame her." Because how long did you do, young man?
I did about 3.5 years. Oh, sorry.
He also has a new baby at home.
Yeah, I got a 6-month-old.
I don't care. No, I'm kidding. I'm kidding. Is that your first?
No, he's my second. I got a 14-year-old who goes to Franklin High School in Livonia. So it's
You waited a
it's
while.
a challenge right now. Yeah, I got two different worlds going on.
Little boy or little girl?
Little boy.
And the older one is?
A boy.
So you got boys?
Yeah.
Okay.
I wanted a girl, but once the boy came, I was happy.
No, you want a little girl. Then they become teenagers, and
Yeah, I know. I got a buddy that has nothing but girls, and they're all teenagers now. Looks like he lost all his hair in the process. So
wow, that's what happened. I don't have to hold on to anything. I don't think I
don't think so.
Hang on a second. And you're gonna stay on the right course if I do something for you here on this?
Yes, sir.
Sure.
Absolutely.
So let's see. You told me you had a baby, right? Trying to get sympathy. And he said, none of this is my fault. It's my sister. Trying to say, oh, poor guy. Then I'm flat broke because I paid these other people $3,400, but I don't want to pay you, Judge Simpson, a dime.
Damn.
That's what I'm hearing, man.
When you put it out like that, it sounds way different.
I know. Didn't it though? Fines and costs of 180. I'll waive the entire balance. Good luck, young man.
Thank you, sir.
Thank you, Your Honor.
Thank you.
sir.
Court calls the case People versus Anna Lee Burgess.
Senator Silver on behalf of the township.
Assistant Public Defender Natalie Pate with on behalf of Ms. Burgess, who should be appearing via Zoom.
Yes, she's there.
Please state your name to the record.
Annalee Burgess.
Thank you, Your Honor. We're respectfully requesting an adjournment. Ms. Burgess has a DMV appointment out in Rhode Island, where she has family, where I believe her license originates from, on the 11th of June. So we would be asking for an adjournment after that date.
Will she be back by the 18th if she goes out?
Yes.
Yes.
You will? Okay. I'll adjourn you to June 18th, 2025, 9 a.m. All
Thank you,
right?
Judge.
Thank
You're
you.
welcome. Court does call the case People versus Diamond Buyers.
Senator Silver on behalf of the township.
Good afternoon. Assistant Public Defender Lauren Kearney on behalf of Ms. Byers. Ms. Byers, please state your name for the record.
Diamond Byers.
Okay, there she is.
Your Honor, we are requesting an adjournment so Ms. Byers can consider her options further.
Adjourn the matter June 18th, 2025, 9 a.m. Bond continue. All right, thank you, Ms. Byers.
Thank you.
Court calls the case People versus D'Amico Cummings.
Senator Silver on behalf of the township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Cummings.
Oh, wow.
Well, Your Honor, I don't have an explanation for his failure to appear. I just gave him multiple times this week regarding this case. I did provide him with information and the time. I don't have an explanation for his failure to appear. Request an adjournment for the record.
Bench warrant, 5,000. 10%. That warrant will issue immediately. Court calls the cases of the People versus Derek Embry.
Senator Silver on behalf of the township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Embry. Mr. Embry, please state your name for the record.
Derek Embry. All right, he's sideways, but that's okay. Now he's upside down. You don't know what you're doing, do you?
I'm on my phone. I'm on my break right now.
It's all right. Oh, now you're good. No, I don't know. All right, what are we doing? Because he's making me dizzy.
Unlike the previous case, Mr. Embry and I have not had a conversation. However, he is here. So I'm asking for an adjournment. There has been an offer made on this case. I think we're going to be able to resolve it. Just need a little bit more time.
All right. I'll adjourn it June 18, 2025, 9 a.m. All right. Thank you, Mr. Embry.
Thank you. Have a good one.
Court calls the case of the People versus Michael Erickson.
Senator Silver on behalf of the township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Erickson. Your Honor, there has been an offer to double parking in this case. He has given me permission to accept that offer on his behalf.
So Your Honor, I move to add count 2 of double parking. You accept the admission. We'll dismiss the original charge.
And you have authority to do so, and you do accept so on behalf of your client.
That's correct. Yes.
Court will accept the admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can he pay?
He's asking for 30 days. He is inpatient at Don Farm right now. But he said he can get it paid in 30 days.
July 31st, 2025. All right. Good time to get it done. Court does call the case of the People versus Angel Ford.
Senator Silver on behalf
This is an arraignment and his board is in Zoom.
Yes, she is. Ma'am, state your name, please.
Angel 4.
All right. Ms. Ford, you are before the court on a citation that alleges that on or about April 22nd, 2025, at the location of Ellsworth Road in Pittsfield Township, Washington County, State of Michigan, that you did operate a motor vehicle in violation of your license restrictions, namely you drove without an interlock system. You understand the nature of that charge, ma'am?
Yes.
That's a misdemeanor, punishable by up to 90 days, $500 fine plus court costs. Do you understand that?
Yes.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes.
This is a public defender case.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Ms. Ford. We waive any further readings, stand new to the charges and request another pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned June 4th, 2025, 9 a.m. For bond in this case will be a $10,000 personal recognizance bond, standard conditions, including no assault behavior, possession of any weapons, no use of any alcohol, recreational marijuana, or any illegal drugs. You understand that, ma'am?
Yes.
And Your Honor, we do not have a number for Ms. Ford in JIS. I would ask that you call up to the court and or the public defender's office and update your contact information, Ms. Ford.
Mm-hmm.
Okay. Did you need the public defender's office number?
I do.
Okay, let me give it to you. You're in Ann Arbor, so it's area code 734-222-6970.
Okay. Got it.
Thank you.
Thank you.
Court calls case People versus Trevor Score.
Good morning, Your Honor.
All right. I need a camera, please.
All right. Can you see me, Your Honor? Good morning.
Yes, I can see you. State your name.
My name is Travers Wolfcore.
All right. Score, you are before the court on a misdemeanor complaint that alleges that on or about October 13, 2013, at a location in Pittsfield Township, that being Lily Park North, that you did operate a motor vehicle with a high blood alcohol content, with a high blood alcohol level. You understand that?
I do understand that.
All right. That's a misdemeanor. It is punishable by up to 180 days in jail, a $200 to $700 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could also order you to pay the cost of the prosecution as well as the cost of any emergency governmental services, as well as immobilize your vehicle. You understand that, sir?
Yes, Your Honor. I don't have.
All right. So my first question for you is, do you wish to be represented by an attorney?
No, I'd like to resolve this problem as soon as possible.
Okay, so what are you gonna do?
Can I explain what had happened that I remember?
I can't, if you can have a trial, if you want it set for trial, I can set it for trial. I might suggest that you might want to be represented by an attorney, sir, if you're looking to get this resolved because of the nature of the charges.
Yeah,
But that's up to you. Do you wish to be represented by an attorney?
Yes, please.
It's a public defender case.
Afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Gore. We waive further readings, stand new to the charges, and request another pretrial date. I will say, check JIS. It looks like Mr. Gore now lives in Florida. I would ask that he be able to,
I'll let him stay where he is.
Thank you, Your Honor.
All right, I'll set the pretrial for June 18, 2025 at 9 a.m. What was the alleged BAC in this?
Data master, 30.29.
Ooh.
Yeah.
Okay. So here's what I'm gonna do. I'm gonna set his bond at a 30,000 personal recognizance bond. All other standard conditions, including no assaultive behavior or possession of any weapons. There should be no use of any alcohol, recreational marijuana, or any illegal drugs. Under these circumstances, I would normally order a tether of some type, and I'm just, this was a 2013 case. Have you been in treatment at all, sir?
I have. I just, tomorrow is my 20 months sobriety. I was at the Salvation Army of Tampa, ARC for since the 21st of 2023 till April 25. So I did 19 and a half months of in-house treatment and worked for the Salvation Army. I've done the 12-step program, and I now sponsor other men in the program.
Okay, so here's what I'm gonna do. I'm gonna withhold my decision as to whether or not to order a tether. You are to provide through your attorney, treatment information, and then I can take that into consideration in terms of any further bond conditions.
I have all that with me today, actually. So.
Okay, so you'll need to submit that to your attorney, and then we'll see where we go from there.
Okay.
All right?
All right. Thank you. Now, how do I get a hold of my attorney? Do I call that 222 number, or do I?
Yes, if you wrote it down, thank you.
Yeah, 222-6970.
Yes, area code 734.
Yes, sir.
And I have a number for you that ends in 0016. Is that the best number for you?
00. Yep. Yes, ma'am.
Perfect. Okay, thank you.
All right. All right. Thank you, sir.
All right. Thank you very much, Your Honor.
All right. Take care. Court calls. Yes, yeah. Court calls case people versus, is it Array, Enray, Gory? Enray?
Conrad Siller on behalf of the township.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Gore. Mr. Gore, please state your name for the record.
Gory. Gory. All right.
Your Honor, we do have a resolution.
Why is everybody sideways? It's just like the second one. I'll go through. There you go. All right. Well, now, okay, there he is. All right, what are we doing?
We do have a resolution. Mr. Gore is going to accept the prosecutor's offer to plead to 257.326.
Okay, the allowing an eligible driver.
Correct, Your Honor. Okay, count to allowing an eligible driver to operate MCL 257.326.
All right. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I didn't hear.
Yes.
Okay. Sir, it is this court's understanding you're going to plead guilty to the charge of allowing an eligible driver to operate a motor vehicle. That's a misdemeanor punishable by up to 90 days in jail, a $100 fine plus court costs. You understand that? Do you understand that, sir?
Yes.
All right. Understanding that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding those rights?
No.
Look at paragraph 5 on that form. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised he needs to be stationary?
I'm sorry.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
July 5th, 2023, at the location of Carpenter Road near Ellsworth Road, Pittsfield Township, Washington County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who was otherwise ineligible to operate that motor vehicle?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
That's fine, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Sir, anything you want to say before I impose sentence?
No.
Fines and costs of $250. I'll suspend 90 days in jail. When can you get the $250 paid?
Can y'all give me at least 60 days? I'm clearing up. I got about $1,500 in fees to pay. I'm getting all these courts out the way, and you guys were the last court that I had to get in contact with. So
you held us till last?
Say it again.
What? I said you held us till last?
I was going in order. That's all. I was just trying to get it out.
Oh, okay. So we ended up washing out, so we're at the bottom. Okay.
No, y'all at the top.
y'all
the furthest too. So
all right. Okay. Look, young man, get this paid off. I'll give you till July 31st, 2025. How's that?
Thank you.
All right. Take care.
Oh, you too.
Court calls the case People versus Shamika Grimmett.
Henry Fuller on behalf of Pittsfield Township.
Assistant Public Defender damage. Presently in Zoom.
I think I did see her. Yep. Ms. Grimmett?
Yes, I'm here.
Okay. Need a camera. All right. What are we doing? Oh, there she is. Okay.
Thank you, Your Honor. So Ms. Grimmett had 4 tickets that were holding up her license before she could take her test again. 3 of those tickets are paid off, and 1 of them actually gets paid on the 4th of June. So then she can potentially take her test. That being said, I'm not trying to pick a date, but I would ask if the court would consider adjourning this out to July 2nd.
She's got a warrant out of 1484.
I did not know that.
For another driving while license. Hold it. Yeah, for driving while license suspended charge. That occurred. The offense date of that is February 20th of 2025. So after you were arraigned on this, you picked up another ticket. It was February 20th at 11:01 p.m.
Thank you, Your Honor. Would Your Honor, I know it's not you probably can't.
I know about
answer,
that ticket. I was on my way to
I
work.
can, but she needs to appear over there.
Yes, Your Honor.
Well, actually here, because yeah, if she appears here or sends in a warrant recall, they'll probably do that and set her another date.
Thank you, Your Honor. But she has not been arraigned on that case yet?
She actually was. Yeah, well, hang on a second. It looks like she was.
I don't show that she was arraigned.
You don't show it?
No, sir.
Okay, I just see the next things appearing. So she has not been arraigned.
Oh, okay.
So this case, I will adjourn to the July 2nd, 2025 date, 9 a.m. I'll give her the time to do that. She's got to get that other thing clear and then try to get a license back. Court does call the case People versus Chelsea Hogan.
Henry Fuller on behalf of Pittsfield Township.
Defender Dan Lee, on behalf of Ms. Hogan.
Ms. Hogan, can you state your name, please?
Chelsea Hogan.
All right, yep, she's here.
Thank you, Your Honor. I think there's a resolution in this case to which my client will be admitting responsibility for the civil infraction of failing to stop, and in exchange, the misdemeanor will be dismissed.
That's correct, Your Honor. So I move failure to stop within an assured good distance. MCL 257.627.
Sure.
Or 9? I think it's 7.
Okay, we'll try that. What do you have? Is that?
120.
All right. And then count 1 would be dismissed.
That's correct. Thank you.
All right, ma'am, do you admit responsibility to the fact that on November 10th, 2024, and a location in Pittsfield Township, that you operated a motor vehicle and that you failed to stop at a shared clear distance.
Yes, Your Honor.
All right, court will accept that admission to that count two. Count one is dismissed. Fines and cost of $120. When can you get that paid?
Can I get 14 days for that?
14 days? I think we can do that. How about June 6th?
That's perfect. Thank you.
All right, June 6th, 2025.
And
All
I
right.
think that it is MCL 257.6.
627. All right, thank you. All right, thank you, ma'am.
Thank you, John.
Thank you.
Thank you, Robin.
Court calls the case, People versus Yusuf Jama.
Conrad Siller on behalf of Pittsfield Township.
On behalf of Mr. Obama, who is supposed to be a Zoom, here, can you please unmute and state your name for the record?
Yusuf Jama.
Thank you, Your Honor. I'm respectfully requesting an adjournment, I guess 2 in a row, or not quite in a row. I will be asking for the July 2nd date. Just this morning, I was able to provide some treatment verification to Mr. Siller. We're hoping to see possibly some more information or to see how well Mr. Jama continues in that program. So I would ask.
So he's currently in treatment.
Yes, Your Honor.
Without objection, July 2nd, 2025, 9 a.m. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Chad Jones.
Conrad Siller on behalf of Pittsfield Township.
This is a short one.
Chad Jones. I issued an order to show cause.
Yes.
Not appearing, bench warrant will issue, bond 5,000. Give 10% privilege, that warrant will issue immediately. Court calls case of the People versus Merriman Kasham.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Kasham, who does have a valid license and did give me permission to accept the offer on her behalf.
So Your Honor, I moved at count 2 of double parking. If you accept that admission and dismiss as a criminal charge.
And you having authority, you do admit responsibility to that on behalf of your client.
I do.
Court will admit responsibility to count 2 or accept responsibility. Accept the admission to responsibility under count 2. Count 1 is dismissed. Fines and costs of $180. When can that get paid?
I'd ask for 4 weeks, Your Honor.
Just cause or what?
Right? Seems good. Nice round number.
Pay it by June 30th, 2025. Court calls the case, People versus William Katke.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Katke. Mr. Katke, please state your name for the record.
William Katke.
Your Honor, we have come to a resolution. Mr. Katke is going to be pleading guilty to allowing an ineligible driver to operate a motor vehicle, 257.326. I do have an advice of rights form that he gave me permission. Never mind, I don't even need this. Mr. Schiller informed me that he's going to give you an even better offer, Mr. Katke. He's offering you to admit responsibility of double parking, which is not, it's a civil infraction, doesn't go on your driving record, doesn't go on your criminal record. It's a fine of $180.
I'm good with that.
Okay.
Might be going. Later on, I moved at count 2 of double parking. If you accept that, move to dismiss as a criminal charge.
All right, Mr. Katke, do you admit responsibility to the fact that on February 10th, 2025, location of Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, that you double parked a motor vehicle?
I do.
All right. Court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can you get that paid, sir?
Today.
Oh, thank you. Pay that today. May want to wait till later in the afternoon to try to, if you pay it online.
Yes, sir.
Okay. All right. Thank you, sir.
Thank you.
Court calls the case, People versus Jaden Kendrick.
Conrad Siller on behalf of Pittsfield Township.
Public Defender Natalie Page. Oh, somebody is here on Zoom. On behalf of Mr. Kendrick, who appears via Zoom, sir, can you please state your name for the record?
Jaden Kendrick.
Thank you, Your Honor. I do not have a good phone number for Mr. Kendrick. I do have an email address, however, so I would ask first for an adjournment, and then secondarily, if Mr. Kendrick would be so kind as to call the public defender's office, update his phone number.
I'll adjourn on June 18, 2025, 9 a.m. Okay? You got the PD's number?
Oh, which Washtenaws?
Yeah.
I can get it.
Okay. You got to call them, make sure they have a good phone number for you.
Got it.
Okay? All right.
And this is by June
Thank
18th?
you. Yes, the 18th.
Thank you, Your Honor.
Court does call the case of the people versus Vincent Lambert. Okay, no.
So this is an arraignment, Your Honor. The second case is in
Warning.
Mr. Lambert.
Vincent Lambert, no response. I have another warrant, so bench warrant will issue for defendant's failure to appear, bond $5,000. I'll give a 10% privilege. That warrant will issue immediately, given the other warrant. Court does call the case of the people versus Montez Miller.
Conrad Silver on behalf of Pittsfield Township.
On behalf of Mr. Miller, who may be present via Zoom. I don't have Mr. So, Your Honor, I was able to, I do not have a direct number for Mr. Miller himself. I only have his mother's number and then the number of the Christian Guidance Center. I spoke with someone there. It is my understanding that he's not currently there, but has been there previously. To that end, outside of not having a direct phone number for him, so I was unable to communicate with him directly. I do not have an explanation for his failure to appear for the record.
Bench warrant will issue bond 5,000, 10%.
They are here in Zoom.
They are. The court does call the case, Pittsfield Township versus Guzin Hung.
Here.
No, that's not you. Ms. Hung?
Kim time đây đâu?
Ừ.
Hai, Lê Hậu.
All right. She's there. We were unable to get an interpreter through our two services. So I do not have an interpreter. Is there somebody there with her that
Yes.
does speak?
Yes, I am the daughter.
Pardon?
I am the daughter.
Okay. So since we don't have a court interpreter on this, I'm going to adjourn this out and give us time to try to find one. I'll adjourn it to July 2nd, 2025, 9 a.m. or as your invite indicates. And hopefully we can get an interpreter prior to that time. All right?
You say July 2nd?
Yes, yes, ma'am.
July 2nd, 9 a.m.?
Yes, ma'am.
Okay, thank you.
All right, thank you.
Thank you.
Your Honor, I apologize. Mr. Siller and I very briefly approached on this regards to that issue, the
Okay, we're all set on that case. And then we're actually back on time, kind of. So court's gonna stand in recess. We'll come back to our next block shortly. Court's in recess.
All right. 14-day district court for County Washington, State of Michigan is now back in session beyond.
You may be seated. Oh, great. Elman's here.
Good to see you guys.
That's what I meant to say. Court calls the case of the people versus Tanisha Moore.
Conrad Silver on behalf of Pittsfield Township.
This is an arraignment, Your Honor, and I don't have her check. Oh, would you like to be in Zoom?
Tanisha Moore. I got one screen, so I don't see.
Yeah, I don't have her.
This was separate arraignment initially. All right, I'll issue an order to show cause on this. Court does call the case of the people versus Amy Moriarty.
Conrad Siller on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pay on behalf of Ms. Moriarty, who may be present via Zoom.
Moriarty, you have her at all?
I do not.
I don't have her.
Your Honor, I do not have an explanation for her failure to appear outside of the fact that I did not have a phone number for her, just an email address, but I did not group back, so I don't know if that was good or not either. For the record, I request an adjournment.
Bench warrant will issue bond 5,000, 10%. That warrant will issue immediately. Court calls case of the people versus Demarius Munoz.
Conrad Siller on behalf of Pittsfield Township.
Public Defender Natalie Pay, with on behalf of Ms. Munoz, who is present via Zoom. Ma'am,
Oh, there she is. Okay.
sorry. Ma'am, unmute and state your name for the court.
Damaris Monreal Munoz.
Thank you, Your Honor. I'm respectfully requesting one, I believe, last brief adjournment of this matter so I can discuss this more in detail with my client. We've been playing a little bit of phone tag. She's in school a lot during the day. I've spoken to her brother.
All right.
Okay.
June 4th, 2025, 9 a.m. Bond will continue. Thank you, ma'am.
Thank you.
Case people versus Giovanni Benitez Flores.
Conrad Siller on behalf of Pittsfield Township.
This is an agreement.
All right.
Then I don't have it.
Oh, he's right here. What's your name, sir?
Giovanni Alfredo Benítez Flores.
¿Habla inglés? No, nada más. Un poco.
We have 3 more. Yes,
Okay. We had 3.
we need a Spanish interpreter.
Okay. I'm gonna ask you to wait so we can get an interpreter.
Okay,
Okay? All right.
thank you.
We can put that.
Just cross it.
Court calls case of the people versus Ernesto Gundoro Ramirez.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon. It's Assistant Public Defender Lauren Perry on behalf of Mr. Ernesto Uno Ramirez. He has, I don't know if he's there, but he has given me permission to admit to double parking on his behalf.
Carduno Ramirez? Not here. But you have permission.
That's correct.
So Your Honor, I move that counsel double parking. You accept that admission to dismiss the original charge.
And you having authority to do so, you would so admit responsibility to count 2.
Yes.
Court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can that be paid?
Well, Your Honor, regarding the money, I'm asking that the court consider not ordering any fines and costs. Mr. Garduno Ramirez was recently deported from this country to Mexico. As you can imagine, that's a big disturbance in his life. I think he's, getting back on his feet in Mexico, but he doesn't have any income or anything like that at this time.
So he's been deported.
Yes, he did communicate with me about this. He wanted to resolve this, but he just had
So
no.
despite that, he still was trying to resolve this.
Yes.
I think costs are waived. Court calls the case, people versus Tridaniel Pearson.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Pearson, who I'm hoping is on Zoom.
I do see him. I see.
Oh, yeah, he is.
Mr. Pearson, can you unmute?
Tridaniel Pearson, you need to unmute and turn on your camera. Oh, there he is. Okay, we got a picture of him. Now I need you to unmute.
Okay.
Got
Hello?
it? Okay. What's your name, sir?
Tridaniel Pearson.
Even though he's up there with that Alabama hat on. I don't know. This is Big Ten country. We might need to do something there. Where we going?
Well, Your Honor, I'll pass along the message. Mr. Pearson his license has been medically revoked. He has gotten the medication necessary from his doctor to go back to the Secretary of State to, I think some circumstances have changed to ask for his license back. So he's just waiting for a date from Secretary of State, and we're asking for an adjournment so he can complete that process.
Okay. But we don't have any idea how long that.
No,
When-
I got the paperwork here. I'm sorry, I faxed it to him, and I'm just waiting on the appointment that my doctor filled out, that it was okay, to reinstate my license, and I'm waiting on.
Okay. Here's what I'll do. I'll adjourn it out to July 2nd, 2025, 9 a.m. Okay?
Okay,
And
thank you.
hopefully what that will do is that will give enough time for them to give you your appointment, tell you what you need to do, and for you to buy a University of Maryland hat.
Oh, no, I don't know about that.
All right, Mr. Pearson, you take
All right.
care.
Thank you, I appreciate it.
All right.
All right, bye-bye.
Court calls the case People versus Stephen Pena.
Henry Silver on behalf of Pittsfield Township.
Public defender Natalie Pate for Mr. Pena, who gave me permission to accept the offer on his behalf.
Your Honor, he does have a valid license to add count 2 of double parking. You accept that admission, you just charge.
And you having authority, you do admit responsibility to count 2.
Yes, Your Honor.
Court will accept that admission to count 2. Fines and costs of $180. When can that be paid?
We're asking for 30 days, Your Honor.
June 30th,
Thank you, Your Honor.
2025. Court calls case People versus James Raggett.
Henry Silver on behalf of Pittsfield Township.
Good afternoon, this is the public defender Lauren Harding on behalf of Mr. Raggett. Mr. Raggett, please state your name for the record.
You have it? Oh, he is there.
James
There he is. Thank you, sir.
Your Honor, I am requesting an adjournment so we can review the video. I did receive that from Mr. Siller's office this week.
I'll adjourn the matter to June 18th, 2025, 9 a.m. Time continue. Oh. Court calls the case People versus Todd Rayberg.
Henry Silver on behalf of Pittsfield Township.
It is a show cause. Todd Rayberg? Not here. Bench warrant will issue for defendant's failure to appear. Bond $5,000. Give a 10% privilege. Warrant issued immediately. Court calls case People versus Jacob Robinson.
Henry Silver on behalf of Pittsfield Township.
This is a public defender Natalie Pate on behalf of Mr. Robinson, who gave me permission to accept the offer on his behalf.
Defendant does have a valid license, so it's moved to add count 2 of double parking. And of course, if you accept that, I move to dismiss the original charge.
You having authority, you do admit responsibility to count 2?
Yes, Your Honor.
All right. Court will accept that admission to count 2. Fines and cost of $180. When can that be paid?
Mr. Robinson was asking for 2 months, Your Honor.
You're just extending, aren't you? But
No.
yeah, you are.
2 months.
July 31st, 2025.
Thank you, Your Honor.
Court calls case People versus Kent Robinson.
Henry Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate for Mr. Kent Robinson, who may be present via Zoom. Sir, if you're there, can you please unmute and state your name for the court?
Kent Robinson? No response.
Your Honor, I don't have an explanation for his failure to appear outside of the fact that I did not have a phone number that was in service for him. I did send an email, did not hear back. I don't know if it was his correct email or not. For the record, I respectfully request an adjournment.
Bench warrant will issue on 5,000. I'll give a 10% privilege on that. That warrant will issue immediately. Court calls case People versus Amy Schaffler.
I read solar on behalf of Pittsfield Township. He says a show cause.
Amy Schaffler. No response. Bench warrant will issue for defendant's failure to appear. Bond 5,000. Give a 10% privilege. Warrant will issue immediately. Court calls case of the People versus Michael Scott.
Read solar on behalf of Pittsfield Township.
Good afternoon, Federal Lord Attorney on behalf of Mr. Scott. Your Honor, I know Mr. Scott is homeless. He does not have any direct contact information. I attempted to contact his friend, I've spoken to his parents before, but I was not able to speak with him this week. I have no explanation for his failure to appear today. I would ask for an adjournment of the pretrial.
Bench warrant will issue for defendant's failure to appear. Bond 5,000. 10% warrant will issue immediately this time. Court calls case of the People versus L.C. Scribbling.
Read solar on behalf of Pittsfield Township.
Oh, there it is.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Scribbing, who stands to my right.
Sorry, excuse me.
Your name is
L.C. Squibbling.
Thank you, Your Honor. There's a resolution in this matter to which my client will be pleading guilty to the added count 2 of allowing an ineligible person to drive, and in exchange, count 1 would be dismissed. I do have his signed advice of rights form here.
That's correct, Your Honor. So, yeah, count 2 was allowing the person to operate in the sale of 57326. You accept that guilty plea, dismiss your charge.
Yeah, have it.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
L.C. Squibbling.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days of jail, $100 fine plus court costs. You understand that, sir?
Yes, sir.
All right. Understanding that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding those rights?
No.
Please look at paragraph 5. Those are your rights, which are part of the trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes, sir.
And because you believe that you're guilty of this offense?
Yes.
All right. On the date of May 20th, 2022, at the location of Washington Avenue in Pittsfield Township, Washington County, State of Michigan, did you have custody or control of a motor vehicle?
Yes, I did.
Did you allow someone who was otherwise ineligible to operate that motor vehicle?
Yes.
Counsel, have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Anything either of you'd like to say before I impose sentence?
Nothing, Your Honor, except I would ask that the court consider the least amount of fines and costs for Mr. Scribbings. He's been great to work with. The little bit I've known him, I would just ask for the court to consider.
So you want me to, what, lower the fines and costs?
I know the typical sentence is 250 in that range. I would ask the court to consider the statutory minimums, given he's represented by our office and has appeared in person here today.
Where did she come up with that argument? All that. She must like scribbling. He must be a really nice person.
Yeah, and he even gave me my pen back. I gave it to him and walked away like for an hour, and he made sure I got it back. Like, I was real impressed.
So I had to lower his fines because he returned property that was already yours? What?
An added argument. Yeah, he's on top of things.
Is there anything you want to say? He said, no, I'm just a nice guy. $250 fines and court costs, 90 days in jail that is suspended. When can this be paid?
About 5 minutes. Right now.
Pardon?
I can pay it right now.
Oh, do you pay it today? Okay.
Yes.
Pay it today out at the counter. I was gonna say, if you needed time, then take her pen and sell it. No.
Get a penny for it, maybe. Has something tucked in it.
All right. Thank you, sir. Take care of yourself.
Take it easy.
Court calls the case, People versus Bosie Smith.
Conrad Silver on behalf of Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Smith. Mr. Smith, please state your name for the record.
Boise Smith.
All right, Your Honor, we have been here multiple times with Mr. Smith, but he has made some kind of progress. He submitted his packet to the revocation board. He's just waiting for his date. So he submitted that 3 to 4 weeks ago and is just waiting to hear back from the Secretary of State.
Well, I'll grant one more adjournment, June 18th, 2025, 9 a.m. All right.
Thank you, Your Honor.
Thank you, sir. Court calls case, People versus Kevin Stevenson.
Conrad Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Kay on behalf of Mr. Stevenson. Your Honor, he is currently
Oh, the
incarcerated.
nice guy showed back up.
Mr. Stevenson is currently incarcerated as of today and confirmed finally at the Calhoun County Jail. He was expected to be released sometime at the end of this month, but as of today, that has not happened. So
He's scheduled to be released sometime at the end of this month.
yes, he had told our office like well over a week ago that he thought he'd be out late May. I checked again today, he is still very much there. So that's when I keep for failure to appear. So I would ask for an adjournment. Given
June 18th, 2025, 9 a.m. They were both on.
Yes.
Case of the People versus Zachary Steiber.
Conrad Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Kay on behalf of Mr. Stiver, who I believe is present via Zoom. Sir, can you please unmute and state your name for the court?
My name is Zachary Steiber. Hello, Your Honor.
Hello, sir.
Thank you, Your Honor. I had the opportunity to speak about this with my client. He is actively working with someone, and he has sent me some documentation to that end to try to get an administrative hearing date in front of the Secretary of State. We're asking for an adjournment to see if that is able to happen, and also if there's some documentation I'd like to provide to Mr. Stiller.
All right. I will adjourn the matter July 2nd, 2025, 9 a.m.
Thank you, Your Honor.
All right. Thank you. Thank you, sir.
Thank you.
Court calls case, People versus Soraya Streeter.
Conrad Silver on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Streeter. Ms. Streeter, please unmute and state your name for the record.
Soraya Streeter.
Okay.
Your Honor, Ms. Streeter had her permit, but then it expired. She has not been able to get back to Secretary of State to get it updated. She had surgery on her foot. I think that's been kind of preventing her from getting around. We are asking for an adjournment so she can do that and avail herself to the office.
Unfortunately, I had complications during the reconstruction surgery.
Okay. And so you're not sure when you're going to be able to get down there to.
They say that I should have at least 4 more weeks of PT left
Got it.
because they did have to take my big toe.
Okay. July 2nd, 2025, 9 a.m. Okay. Thank you, ma'am. Court calls the case of the People versus Mallory Tyfel.
Conrad Silver on behalf of Pittsfield Township.
This is a show cause, Your Honor.
Mallory Tyfel. Not present. Bench warrant will issue for defendant's failure to appear. Bond 5,000. 10%. Warrant will issue immediately. Court does call the case of the People versus Stephen Trent.
Conrad Silver on behalf of Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Trent. Mr. Trent, please state your name for the record.
Stephen James Trent.
Oh, there he is.
Your Honor, we are requesting adjournment of the pretrial. Mr. Trent is, working on getting his license. He too has sent his packets to the revocation board and is waiting on a date.
Oh, okay, I see. July 2nd, 2025, 9 a.m. All right, okay. Thank you, sir.
Thank you. Have a good day.
Take care. Court does call the case, People versus Daniel Nuggle.
Here, sir.
Conrad Silver on behalf.
And good afternoon, Your Honor. Brendan Dabolsky appearing on behalf of Daniel Nagel. Your Honor, at this time, we would be asking for one final adjournment. I've been in talks with Mr. Nagel and I've been conversing via email with Mr. Siller. I think we may be close to a resolution, but I just need just a little more time in this matter.
Mr. Noggle, can you state your name, please?
Daniel Nagel.
You pick it up?
Yeah.
Okay. No, it's okay. I'll adjourn the matter June 18th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you,
sir.
Thank you.
Thank
Court calls the case, People versus Jada Tavaro.
Conrad Silver on behalf of Pittsfield Township.
Good afternoon, Your Honor. Wonderful to see you. Robert Ellman with and on behalf of Mr. Varro.
Good to see you, Mr. Ellman, as always. Yes. All right. Your name?
Jada Trevero.
Tavaro.
Your Honor, I have wonderful news to share. After a long and arduous discussion with Mr. Siller, he has agreed to dismiss this case.
Okay. I mean, no, what?
No, he came to the reasonable conclusion.
My mind. No, Your Honor, I'm moving to dismiss.
And I'm assuming there's no objection.
None at all, Your Honor.
This case is dismissed. That's without prejudice.
Thank you.
Thank you.
Have a great day.
You do the same. Court calls the case of the People versus Ebony Whitsett.
Conrad Silver on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Whitsett. Ms. Whitsett, please state your name for the record.
Get her there.
Ebony Whitsett.
Okay, there she is. Okay.
Your Honor, we have come to a resolution. Ms. Whitsett is going to be pleading guilty to allowing an ineligible driver to operate an added count to the case ending in 0079.
Okay, so it's gonna be on that.
Count 2 and 0079.
Okay, and then what are we doing with the other case?
That case will be dismissed.
Okay, so count one. Oh, gotcha.
My phone might die.
Well, you're gonna have to come in person, so you might want to charge it.
Huh? It's on the charger right now.
Okay, all right. Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, state your name again.
Ebony Whitsett.
All right, this is, ma'am, it's the court's understanding that you are going to be pleading guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs. You understand that?
Yes.
And understanding that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form?
Yes.
Any questions regarding those rights?
No.
Okay. Paragraph 5 is your trial rights. You understand that you're giving up those as well as all the rights that are contained on that form?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily
Yes.
and of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
January 26, 2023, at the location of Gulfside Road in Pittsfield Township, Washington County, State of Michigan. Were you in possession and had custody and control of the motor vehicle?
Yes.
And did you allow someone who is otherwise ineligible to operate that motor vehicle?
Yes.
Go ahead, I comply with the court rule.
Yes, Your Honor.
Court will accept the defendant's plea to count 2 in case 790079. Count 1 as well as the case ending in 1595 is dismissed. Ma'am, is there anything you want to say before I impose
No.
sentence? Fines and cost of $250. I'll suspend 90 days in jail. When can you get that paid?
Probably. Can I get a month? But it'll probably be quicker than a month, though.
Pay it by June 30th, 2025.
Thank you.
Thank you.
Mhm.
Court calls the case People versus Henry Williams.
Assistant Public Defender Natalie Payton on behalf of Mr. Williams, who should be present soon.
He is here.
Henry Williams.
Oh, there you go. Thank you, sir. So I have discussed this matter with my client. He's asking for a 4 to 6 week adjournment to work on getting his license.
Where are we on this? He just, I'll adjourn the matter to July 2nd, 2025, 9 a.m. On continue.
Thank you, Ron.
Thank you.
Thank you, sir.
Court calls case People versus Mark Williams.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Williams. Mr. Williams, please state your name for the record.
He's now.
Well, Your Honor, we did speak to him. We provided him with the Zoom information. I don't have an explanation for his failure to appear today.
Bench warrant will issue for defendant's failure to appear. Bond 5,000, 10%. That warrant will issue immediately. Thank you. You may be seated. I did. All right. They're both the same type of motion.
And so just to begin with, I have no pleas being withdrawn.
Hang on a second, let me call the case.
Okay.
Court calls the cases of the People versus Hakeem Dairy and also Nasser, no, I'm sorry. Is it Malik Kafar? That's about the best I'm gonna do, Al. Okay, can you state your names?
Akin Al-Bidiri.
Karar Maliki.
Okay. Oh, and she is so cute.
Thank you.
Who is she?
She's my daughter.
Oh, okay, I thought as much. But what's her name?
Her name? Arak.
She's beautiful. How old is she?
She's 2.5.
2.5. All right. She's like all of these strange people. She's like looking at her. All right.
So Tanner and Silver on behalf of Pittsfield Township. Your Honor, we've come to a global resolution and everything.
Okay.
So for each defendant, I have no objection to the court withdrawing their pleas.
All right, so I'm going to put defendant's motion to withdraw, please, is granted. No objection from People.
No objection.
All right. All right.
For Ms. Baderi, I'm going to move to dismiss her case.
Okay.
I believe the officer made a mistake by issuing the citation.
I was curious as to how 2 happened, but
Correct.
I'm not.
Yes.
The
The court has seen a lot of citations and it caught your attention.
It did that, and I thought if it rightfully belonged to someone, I couldn't tell who it did. Let me just get her file straight. So, Ms. Baderi, your plea in this case is your motion to withdraw the plea is granted, and then your case is dismissed. Okay,
Now, did she post a bond, Your Honor?
So
do you have a bond?
they paid the fines and costs in full when they signed the plea bond, so or directly be carried to refund.
Okay, so how much did they pay?
She paid $200 even.
Is that what you would call 200 was paid?
Yeah.
All right, so okay. I'm gonna have the 200 refunded to you, okay? All right, now, this gentleman, what are we doing?
I'm gonna add a count of double parking.
Of course you are.
Gonna hit double parking. And then, of course, have the misdemeanor charge dismissed.
Okay, sir, do you admit responsibility to the fact that on March 11, 2025, on State Street, Pittsfield Township, Washtenaw County, State of Michigan, that you double parked a motor vehicle?
Yeah.
Yes? Okay. Court will accept that admission to count 2, count 1 is dismissed.
Yes.
All right.
And he may be owed a small refund on his.
So how much did you pay 200?
Yes.
All right. So fines and costs of $180. And I'm gonna put refund $20 to defendant. Okay, so you should get 200 back, you'll get $20.
Yeah.
All right?
Thank you, Your Honor.
You're welcome. Sorry about the wait, too.
Thank
14A District Court, County of Washington, State of Michigan is now in session. All those having been before the court draw near. The Honorable Judge Judge Simpsons presides. You may proceed.
Aye.
Good morning, Your Honor. Hannah Mackey, requesting permission to practice under Michigan Court Rule 8.120 under Deputy Chief Public Defender Lauren Brown.
You doesn't care what we do. You just jumped in. You're excited to be here, aren't you?
I forgot, Your Honor.
You're excited to be here.
I'm so sorry.
You're really excited to be here.
Always, every
Are you?
Thursday.
Are you?
I look
You're
forward
just-
to it every week.
You were so excited you couldn't wait, right?
I'm sorry.
No, you're not. Okay, so we'll do it this way. Good morning, Ms. Zenda.
On behalf of the people, Your Honor, the people waive any potential conflict between this honorable court and the Office of Public Defender. While the people don't believe such a conflict exists, people make this waiver and avoid it laid down.
Thank you. Now you may.
Good morning, Your Honor. Hannah Mackey, requesting permission to practice under Michigan Court Rule 8.120 under Deputy Chief Lauren Brown.
Permission to practice is granted.
Thank you, Your Honor. We waive any potential conflict between this honorable court and our office, and if any conflict were to arise, we waive that conflict so that this honorable court could hear these matters.
Thank you, Ms. May. The court for its part also does not believe that there's a conflict either under Michigan court rules or the cases decided there under. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Maurice Griffin.
Jennifer Douglas, the people. Good morning, Your Honor. Assistant Public Defender Alexis Smith, and on behalf of Mr. Griffin, who's appearing on Zoom from MDOC.
Yes. Mr. Griffin, can you state your name, please, sir?
Maurice Griffin.
Thank you. He's waiving.
Yes, Your Honor.
Mr. Griffin, you're waiving your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense was committed and that you committed it?
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant filed over to circuit court on count 1 with 2 filed.
Your Honor, we acknowledge receipt of the information, waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to both counts. Pretrial in this matter will be set for.
June 9th at 1:30 PM. Please judge your move.
I move.
Yes, sir.
June 9th, 2025, 1:30, Judge Hamud.
Thank you, Your Honor.
Thank you. Bond will continue. All right. Thank you, Mr. Griffin.
Thank you.
Court does call the case of the people versus Terrell Green.
And good morning, Your Honor. Assistant Public Defender Jonathan Carey, I can really, on behalf of Mr. Terrell Green. Mr. Green, state your name for the record, please.
Terrell Green. Thank you.
Your Honor, we're asking that this matter be set for preliminary examination, please.
All right.
I just want to ensure Ms. Carey is updated. We previously discussed potentially, I understand that's a choice, waiving Mr. Green's cases because there were two others that were coming through. I did authorize both of those. I communicated with Mr. Feaster earlier. He has an uttering and publishing case that I authorized on the 16th of May. And he has a FTD with a second misdemeanor count as well that I authorized back on May 7th. It looks like they have not been sworn to yet. I think it's just an issue opening up. So free to set it for exam, but just to let you know that those two are also.
Well, when are they going to be sworn to? I mean,
I will reach out to the officers on those respective cases and try to find out when we can get that done. I'm surprised they haven't been done yet.
So am I.
Mr. Green, let's go ahead and adjourn so we can see if those new cases are going to catch up, okay? Judge, can we have 2 weeks?
Yeah, well, in 2 weeks, when, because he's got to, if they get sworn to, he's got to be arraigned
Okay.
on them. And if they go through the normal process of arraignment, then he'd be arraigned and then he'd have a PCC date set. But if we can get them sworn to and get them entered into the system, I don't mind putting it out 2 weeks and I'll just do the arraignment.
Okay.
So we can get it moving.
Okay. Sounds good to me, Your Honor.
All right. Probable cause conference in this matter will be adjourned to June 5th, 2025, 9 a.m. Bond continue.
Okay. Okay. Thank you, Your Honor.
Thank you.
Take care, Mr. Green.
Court calls case People versus John David.
Morning, Your Honor. Jacob Kennedy, behalf of the people. Morning, Your Honor. Trustee Stope appearing on behalf of with John David, who is present. Your Honor, we are further discussing the case for a resolution and ask the court for an adjournment so that Ms. Reiser and I can get together.
All right. Will the 12th work for you?
June 12th would be great for us, Your Honor.
Probable cause conference will be adjourned June 12th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court does call the case of the People versus Benjamin Detlefs.
Assistant Public Defender Jay Bellinger on behalf of Mr. Detlefs who approaches, Your Honor. Mr. Detlefs, can you please state your name for the record?
Yes, Mr. Benjamin David Detlefs here.
And Your Honor, I have submitted a form to the court finding an order on competency. At this time, my understanding is that he's still incompetent but restorable.
Was there a communication?
There was on 5/15. My understanding was that the court had the report. If the court doesn't have the report, then I'm happy to send that over.
I may have gotten.
Okay.
It was on 5/15.
That's my recollection of the date, Your Honor.
Yes,
That's when I received the report, I should say.
Mr. Bellinger had to share with me yesterday as well.
I don't have.
It looks like our office received it. And now it's in my file, but I did yesterday morning.
I don't have it.
Okay.
The last report I have, or the last indication was February 10th.
Okay.
So.
Okay.
Do you have a copy of it?
I only have a copy via email, Your Honor, and I'm happy to.
Well, I've got to review it before I can make findings. So why don't we? I'm down a staff member, but send that to Ann.
I will.
And then, we can take a look at it. Why don't we take it back and have it brought back?
Thank you, Your Honor.
Pass.
We'll be back.
Oh, thanks.
Court does call the case of the people versus Alex Saldivar. Alex Saldivar. Alex.
Christie Stope on behalf and with Axel Salvador.
Is it Axel?
Yes. It's okay.
It's okay.
It's a couple letters.
It's gonna
It's
be
a couple letters.
Couple letters, switch them around. It's what I want it to be. Your name, sir?
Axel Salvador.
Thank you.
Your Honor, I have a waiver form. My client's gonna be waiving his preliminary exam.
Sir, is that correct? You're waiving your right to have a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and you committed them?
Yes.
You understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes, I understand.
All right. People also waive their right?
Yes, ma'am.
Preliminary examination having been waived, defendants bound over to circuit court on all 7 counts. Mr. Stowe.
Wait for formal reading of the, he stands mute, Your Honor.
All right. Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
July 17th at 1:30 p.m. with Judge Slay.
July 17, 2025, 1:30, Judge Slay.
Your Honor, if I could address one portion of his bond.
Yes.
He is currently on 2 types of tethers. He's on a GPS tether and an alcohol tether, a scram tether. We had asked the court, this is almost a year-old case. When it occurred, obviously a very serious case. My client doesn't have a history of any type of alcohol abuse or use. He's 18 years of age. He's been on the tether without any violations for some time. Having both tethers is extremely expensive for the family. I would ask the court, either if the court would be willing to take him to random tests and allow the alcohol tether to go away, or let him have some more time. Right now, currently, he's under basically a house arrest with his GPS tether. If the court would allow it to expand the time he can be home till 8 or 10 p.m. at night. He works for his parents in a cleaning business, and he comes home directly. It won't allow him to go out with his parents or anything else after work. So I'm asking the court to consider one of those changes to his bond.
Response.
Your Honor, I with respect to request that the bond remain set, the fact that Mr. Saldivar is not, is pending, in my opinion, a gift, given the charge of nature of this, and also the facts. This involved, the defendant was intoxicated, there was a chase from police. Eventually, the defendant crashed his vehicle, and one of the passengers in that vehicle was killed. The defendant obviously was under the influence of alcohol at the time with the beings.
09.
What's that point?
09. So it wasn't a high BAC, Your Honor.
Right. I know, given all of that, and also given the nature of the charges, I'm not going to change any of the conditions to respond. Judge Slay may have a different view of that, but at this time, I'm not going to change that. All right. So motion for bond modification is denied. Bond will continue. All right. Thank you. Court does call the case of the people versus Jerome Burns.
And Assistant Public Defender, Tammy Carey, really, Your Honor, sorry. On behalf of Mr. Jerome Bird.
How is it, secondly, that there are times I never hear from you, and then I have the extreme pleasure of starting out with Mackie and then you?
It's your lucky day, Judge.
Is that?
Yes, it is.
Call it luck? Okay, go ahead. Yeah, come on.
On behalf of Mr. Gates, who's approaching. Mr. Gates, could you please say your name?
Devin Gates.
Your Honor, we're asking for an adjournment. We're hoping for June 12th. There's co-defendants, and that's the date that we all kind of looked at together.
Who's the co-defendant?
There are 3 other co-defendants. One is actually not scheduled for next Thursday. 2 were up today who are in custody representing Iron Couch and
And the parties have all talked and
Our German Matthews, we've all talked, there's a lot of discovery, our office received a DVD, copies are being made and sent out, hopefully you'll have.
probable cause June 12th, 2025, 9 a.m. bond continued.
Thank you, Your Honor.
Let's call the cases of the people versus Robert Conley.
Morning, I'm Rob Jekyll on behalf of Mr. Connolly. Robert, state your name for the record.
Robert Connolly.
Judge, today's time and date for PCC. I met with Robert the other night. He's charged with 4 serious cases.
Yes.
I'm asking for a 3-week adjournment for further discovery. May I?
All right. Probable cause conference will be adjourned June 12th, 2025, 9 a.m. On all of these matters, bond will continue.
Thank you, Your Honor.
Thank you.
I'll see you in a couple days.
Court does call the case of the people versus Clifford Gordon.
Edward Drukas for Clifford Gordon.
Your name, sir?
Clifford Gordon.
Thank you.
Yeah, I'm still working to mitigate the case. I'm asking for an adjournment today.
Gee. That objection, probable cause conference will be adjourned June 5th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Court does call the case of the people versus Jamari Bagwell.
Kyle Bell on behalf of Mr. Bagwell. State your name for the court.
Job Mayor Bagwell. Thank you.
And Your Honor, I was just appointed on this case yesterday. We are in ongoing plea negotiations. I believe discovery is complete, but I'll have to review it to confirm. We are asking for an adjournment of the probable cause conference.
That objection, probable cause conference will be adjourned June 5th, 2025, 9 a.m.
Okay. And Your Honor, if we may be heard as to bond.
Go ahead.
So Your Honor, Mr. Bagwell is on a $1,000 10% bond, basically a nominal cash bond to give him credit. He has nothing else holding him at this point. We are asking that be converted to a personal recognizance bond. No, he does have ties to the community. His partner is here. He also has a good friend that's in town. And he does work. He works for a home-based catering business as a cook. He's worried about losing that job if he stays in any longer.
Response.
I'll leave it in court's discretion, but I did want to ensure that the conversations that I have with counsel about where we may be going with this case, Mr. Bagwell lives on accessory quarter.
Just basic practice, and we have no objection to that, Judge. However often the court desires.
Was testing ordered previously?
I'm not sure if it was, Judge, because he was in.
Whatever says.
Sure.
Well, what type of testing order are the people contemplating? Because I don't see that he was ordered for testing at all.
Your Honor, maybe approach very quickly.
Why not? Stay here. In bond, I'm going to set his bond at a $10,000 personal recognizance bond. I will also sign an order testing for 2 times per week drug testing. See in a couple weeks. Okay, thank you.
Thank you.
Court does call the case people versus Julius Holston.
Are you Mr. Holston? Come on out.
Edward Drukas on behalf of Julius Holston.
All right.
Your Honor, I need to obtain discovery. I just was appointed. I'd be asking for an adjournment.
Probable cause conference will be adjourned June 5th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. You're not out there. Court call, what'd you say? Her client's next? Except that they're not there. Court calls the case People versus Robert Branscombe.
Defendant's not to carry out through, Your Honor, on behalf of Mr. Branscombe.
3 in a row.
Mr. Branscombe, state your name for the record, please.
Robert Branscombe.
Judge, we are requesting an adjournment. I did have an opportunity to speak with the people this morning about Mr. Branscombe's case. They have some,
Go ahead.
they do have some, we're working on negotiations, Judge, so we're just asking for a very brief adjournment.
2025, 9 a.m.
Thank you, Judge.
Bond will continue. Do I have the form?
I have it here, Judge. I apologize. I will, send the Zoom link.
Or you want us to wait for you to fill it out?
Absolutely not, Judge.
All right, you have it?
Time again.
What? No, gee. Court calls the case People versus Jason Burkett.
Jennifer, that was for the people?
Morning, Judge.
Good morning.
See you. Christina Costantino appearing not with, but on behalf of Mr. Jason Burkett. Mr. Burkett, can you please state your name for the record?
Jason Matthew Burkett.
Judge, I am at this time asking for an adjournment of this matter. I was actually not made aware that Mr. Burkett was in custody prior to today.
Okay.
It makes sense why I wasn't able to get in touch with him over the phone now.
Yeah. Is he in custody on this case or something? Okay.
Last night,
He's in on something else.
On something else, Judge, yes. Do you know what your bond is on this case?
Okay, sir, turn around. So is he, I don't know what he's being held on because he's not held on this case.
I don't know either, Judge. Did you get a new charge?
I don't know what they did with last
Have you
night.
been in front of a judge?
No. I picked you up
Judge,
last
at this
night,
time, we're unsure why he's presently in custody.
Okay. Right, I will adjourn this out June 5th.
Last night.
Oh, Your Honor, he's got a new warrant that was just authorized. So apparently that's what it is. Although he did have an outstanding warrant.
It was just out, is it in our system or, I mean, because I'm gonna adjourn this out and then find out, I mean, it's not gonna make any sense if I put this out to. But we don't have a case. I don't know how you'd be on our arraignment. We don't have a case in JIS.
It's stolen property.
Okay.
So I'm actually for two different things. One is that we are in the process of charging it, and but also he's on the arraignment list, so I'm not sure.
I'll adjourn this case to the 5th at 9. It's bond in this case, I guess, will continue. Unless you want me to give him a nominal bond on this case, because he's got a PR on this case.
Judge, it's a little bit difficult for me, not even knowing what the charges are that they're contemplating potentially authorizing. So
Let's maybe find it out. What are the other charges?
I'm trying to home. I can't read.
That one is all from this guy. Oh, this one was Jenna.
And Judge, just to complicate things even more, I'm not
No,
available
you did this
on the
last week.
5th.
You did it, what?
No, I'm not available on the 5th.
I know, you told me that before, and I know when I was setting the date, I said, she's not gonna be.
I know, I'm sorry.
All right, go ahead.
Entering a vehicle to steal property.
Okay.
Is that being charged as a misdemeanor? A misdemeanor. Judge, given the new charges of misdemeanor, I would ask that you continue the personal bond in this case.
All right, I'll continue the personal bond. I'll adjourn this to the 12th. Then 9 AM. And he is on the list. Can you, is it a felony ring?
You're gonna have to read this later today. Bond violation. I'm gonna do. I was sent. I can pull up whatever. Okay.
What do you mean? Before you send it. Yeah. Then email from him. So he's on the docket this afternoon for a bond violation.
So I'm told there's a potential new case, but they have it as a bond violation.
And would that be a bond violation in my case?
Well, it would have to be only because, because we don't have any other case. So tell them after the arraignment on the bond violation to set it for to get to the magistrate's office to set him for the 12th. So that we get that case together.
Yes.
All right. So I'll put it for the 12th. At this point, his bond will continue. Thank you.
Thank you, Judge.
Thank you. Calls the case, people versus Zachariah Karuska Dennis.
I'm back for more, Judge.
Oh, no.
I brought in the big guns here with me, though.
Lauren?
Yeah. Yep.
That laugh. That's the only kind of gun you can get. That's fine.
Good morning, Your Honor. Lauren Brown, Deputy Chief Public Defender appearing with and on behalf of Mr. Zachariah Karuska Dennis. Could you state your name for the record?
Zachariah Karuska Dennis, Your Honor.
Thank you.
And Judge Christina Costantino appearing on behalf of the defendant in case number ending in 1150.
Yes.
All right.
576.
What are we doing? You're on the other matter, Mr. Brown.
Your Honor, currently we have a mitigation report that is pending. The mitigation office AIM has just requested a report. They have not received that yet. Once they receive it, they'll be able to finish the report and we'll be able to present that to the prosecution to see how we can resolve this case. However, that will take, we expect about 3 weeks to be able to get all of that done.
3 weeks to get it to them?
To get the report has to be finished. After they first receive the information they requested, write the report, we have to review it and then send it to them. Then the prosecution has to read it and make a decision.
Very quick reading.
All right, good. So if I set this for the 12th, or you?
Yes,
that work?
12 was excellent.
Probable cause, thank you. Picked it myself. June 12th, 2025, 9 a.m.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, Judge.
Thank you. That's called the case of the people versus Desmond Burton.
Assistant Public Defender Chelsea Vergils with and on behalf of Desmond Burton, who approaches. Mr. Burton, please state your name.
Desmond Burton. Thank you.
Your Honor, we're asking to set this for a preliminary exam.
All your discoveries complete?
Yes, Your Honor, I believe we have all the discovery that exists.
All right. People have their witnesses available June 3rd?
I will not be going to a training.
So that you got other attorneys. Will the people have their witnesses available on the 3rd?
Yes, we can go to that.
Preliminary examination, June 3rd, 2025, 9 a.m. That is before Judge Perry.
Thank you, Your Honor.
And we'll continue.
Thank you, Your Honor.
Court calls the case people versus Kenia Jackson.
Jennifer Douglas for the people.
Came back appearing to help Ms. Jackson. Your Honor, may we have
your name?
Kenia Jackson.
Thank you.
Your Honor, may we have a very brief conference at the bench?
Why not? Everybody else has. Come on. Record to reflect, we've had a bench conference in the state because the matter for preliminary examination. The court's understanding is discovery is complete and people would have their witnesses available June 3rd. So I set this for a preliminary examination in person, June 3rd, 2025, 9 a.m. That's before me.
Thank you, Your Honor.
Bond continued. Thank you.
I'll come back and see.
Court does call the case of the people versus Myron Couch.
Andrew Childers appearing on behalf of the people.
David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Myron Couch. Your Honor, this is a co-defendant to Mr. Bernstein's case a few minutes ago.
June 12th.
June 12th, yes, Your Honor.
Probable cause conference, June 12th, 2025, 9 a.m. Bond continued.
There is one thing I'd like to address as far as the bond is concerned, Your Honor, and this is a very unusual situation. Mr. Couch, when he was arraigned by the magistrate set the standard conditions, among them being no contact with co-defendants. One of the co-defendants in this case is my client's wife, which creates several problems. One of which is that they run a business together, which they can't do if they can't have any communication. The other is that Mr. Couch has some significant medical problems. She is usually his advocate, takes him to doctor's appointments and so forth. So we're asking if the court would consider dropping that provision. I know she's going to have to address it when she's before the court next week. But as far as my client is concerned, we're asking if the court would drop the no contact provision, specifically as to his wife, not the other defendants.
I would ask that no contact order. This is a pretty significant case involving breaking into a home, tying up individuals, using a chainsaw to access portions of the house looking for money. There is the possible use of firearms. So the defendants are all charged armed robbery, unlawful imprisonment, so on and so forth. It does appear, based on the investigation by the state police, obviously a plan, a concerted effort by these individuals. I would ask, I know it is unusual to have husband and wife charged as co-defendants, but I would ask that no contact will remain in effect at least.
Very briefly, Your Honor, the arguments that Mr. Childers made really go more to the issue of what the bond should be in terms of dangerousness, et cetera. The magistrate considered those.
They were acting in conspiracy with each other, doing it. You would want to keep those people separated.
I wouldn't, Your Honor, but the court might. I appreciate that.
I'm saying you in the general sense of those that rationally think it through. I'm going to deny the bond request. I'm going to have his bond continued till I can maybe take a look at the other case and that I don't have before me that's set for next week.
Yeah, she's set for next week. I'm assuming hers will get kicked over to the 12th also.
12th, correct. Who is her counsel?
Hers?
Yes.
I don't know, Your Honor. It's not public defender because they have another person that's up today. Is the other one up today?
Yes. It's not the public defender's office. I don't know whether she retained her own attorney or.
What's her name?
Christy.
Last name, Couch.
Couch. Chris.
I know she was.
How do you spell Christy?
Kristi. I know she was going to talk to Jeff Osmond in Monroe, but I don't know if she's actually ever done that or not. I spoke to him briefly last week and he said he might be representing her. But...
Okay, so she's been arraigned.
She's been arraigned. She was arraigned the same day as Myron was, Your Honor.
She was arraigned. My understanding is the judge or the magistrate gave her a PR or a substantially lower bond, and for that reason gave her more time. I think at the request of the PD at the time of arraignment, set a later PCC.
Right, but she would have been given counsel.
Your Honor, I was present at the arraignment. She indicated she was going to. I indicated for her because she had asked me to stand in at the arraignment. We indicated she was going to be hiring. And as I said, she mentioned a Jeff Osmond. I spoke to Mr. Osmond. He is familiar with the situation. I can contact him, make sure if he's going to represent her, he gets an appearance in before next.
Well, if he gets an appearance and just a stip to adjourn, so they don't have to.
Okay, I can,
That's what I was trying to get at.
okay, I can let him know that, Your Honor.
All right. Okay, thank you.
Thank you.
Court does call the case People versus Victor Morris Gerard.
Good morning again, Your Honor. Chris Eastup on behalf of and with Victor Morris Gerard, who is standing to my right.
Your name, sir?
Victor Morris Gerard.
Okay.
Yeah, it's just going to be a waiver of the exam.
Waiver. Okay. And sir, you're waiving your right to have a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, I understand.
And you understand that you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on all three counts. Mr. Eastoe.
Waive formal reading, Your Honor. Stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
June 4th at 1:30 p.m. with Judge Conlon.
June 4th, 2025, 1:30, Judge Conlon.
Your Honor, may I address bond really quick?
You may.
Your Honor, my client was initially, when he was charged, he was given a TR bond or a low bond, and then he was ordered to test. He failed, unfortunately, a few tests because he was struggling with substance abuse. And then his bond was revoked. Then this court was nice enough to amend his bond to allow for to go to inpatient treatment. However, he hasn't financially, it's been a little difficult to reach that. He's not on Medicaid yet for Dawn Farm, so that he could only afford less than a month. So he hasn't been able to do that yet. So I'm wondering if the court would consider giving him a second chance on either like an alcohol tether, because alcohol is technically his bigger issue than it is narcotics. He struggles with alcoholism. So if the court would consider putting him on a scram tether or a different type of alcohol tether and putting him back on regular testing at community corrections, I think we do have a plea deal worked out that will be done up in the circuit court, and his guidelines are relatively low given this case. And I think he's spent over a month in custody already.
Right, but I think he really, I mean, part of the reason that we modified it last time is he really needs treatment.
I agree, Your Honor.
And
I would probably agree with that also.
Yeah, and I'm just hesitant to release him on the hope. I mean, I understand the insurance issue, but
could we make it a condition that he attend outpatient treatment as well as testing and scram or something? He's willing to do any of that. It's just the finances right now, I think, are what's keeping him.
He'll be up before Judge Conlon in a couple weeks. What I'm going to do is I'm going to deny your request, and I'll let Judge Conlon's case, let him take a look at that. So the bond will. Okay. And can counsel approach on that last matter? Jesse Crampton.
Good morning, Your Honor. Assistant Public Defender Alexis Zerbs on behalf of Mr. Crampton.
Andrew Childers, attorney on behalf of the people.
Your Honor, let me briefly approach on this matter.
Where's your client?
What was that?
That's
what I want to approach about. Yes, Your Honor.
So if you approach and start talking to me, is that going to change?
I have an update. I think my understanding last time is we weren't sure.
Oh, come on, because this is going to be too long.
Did they call me?
Record should reflect we have a bench conference, one of many. In this case, the defendant not appearing, but I do understand the circumstances. The court is going to issue a bench warrant for defendant's failure to appear. I'll set his bond amount at $5,000 cash surety. If there is the possibility of arrangement, and I've explained to counsel that I would set aside the bench warrant if we can secure his appearance.
Understood, Your Honor. Thank you.
Court does call the case People versus Shane Stout.
Edward Lucas for Shane Stout. Your Honor, this will be a waiver.
Shane Stout?
All right. Mr. Stout, you're waiving your right to have a preliminary examination?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right? Yes. Preliminary examination having been waived, defendants bound over to circuit court on all 6 counts.
Your Honor, I acknowledge receipt of the information, stand mute, waive its reading, and ask for a pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
June 2nd at 1:30 p.m. with Judge.
June 2nd, 2025, 1:30, Judge Hamud. Bond continue.
Thank you, Your Honor.
Thank you. Yes, ma'am. Court does call the case of the people versus Fleming Davis.
Morning, Your Honor. Assistant Public Defender Alexis Zerbs on behalf of Mr. Davis, who's present. Can you please state your name for the record?
Fleming Davis, sir.
Thank you. What are we doing?
We respectfully request that this be set for a preliminary exam.
Discovery is complete.
To our knowledge, yes, Your Honor.
People have their witnesses available the 3rd. Preliminary examination will be set in person, June 3rd, 2025, 10 a.m. before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you.
Here, I don't know why June 3rd.
Court calls case People versus Larzell, Washington.
Edward Lucas for Larzell, Washington.
Larzell near Washington, sir.
Thank you. All right, what are we doing?
Your Honor, we adjourned it a week. I had reached out to the recovery court and Mr. Reyes, his interview date is set for tomorrow.
Pardon?
His interview date is set for tomorrow.
So he's going to be interviewed tomorrow?
He's going to be interviewed tomorrow.
All right, so will they get an answer within a week?
I assume he'll get an answer really quick.
Okay. So I'll adjourn it out one more week to the 29th then.
Period.
June 29th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Excuse me. I would like to waive my circuit court. Thank you.
You want to waive your preliminary examination?
That's right.
And
have you talked to your attorney about that?
Your Honor, if I could approach with counsel.
Yes. Washington, you want to waive your preliminary examination. Your counsel's asking to adjourn the probable cause conference. Certainly you have the right to waive it. But usually people do that in consulting with their attorney. Okay. Now, just listen closely to me. My understanding is that there is the possibility of working this thing out in a way where there may not be a felony for you.
What?
Okay.
Pardon me?
Did you hear me or no?
No, I didn't.
That there may not be a felony.
I understand.
Okay, so that may not happen if you waive. Okay, right. So here's what I'm gonna do. I'm not saying no to what your request is, okay? What I'm gonna do is I'm gonna put it over a week, let that process happen. If it doesn't work out or whatever happens, then we can do the waiver next week.
Right.
Fair enough?
I'm actually okay. No, we just waive it.
Your Honor, he's asking for a PR. I mean, I don't know if the court would allow him to get the interview conducted tomorrow.
Once I get an answer from hang on a second, Mr. Washington, you gotta listen to me now.
Yes, sir.
Okay, so once I get an answer from that, I'll consider release on a PR. Okay, I'm not saying that I will, But once he does the interview and I get some information from that, then I'll.
Right.
consider doing something,
With all due
okay?
respect,
But-
Your Honor, I was supposed to been had this business taken care of with this young man.
This what?
Would you explain to him I was supposed to been had this taken care of? Please send me.
No, he's explained that to me. I understand that.
Well, I'm
not.
I just rather just let it go through, let it play the role, because I'm not gonna keep coming in here every week going through this. I'm saying $174, good Lord. Y'all letting people out with worse things than that. You know, it's been a month. Forgive me, I was homeless. I missed court. My father's in the hospital. I'm a working man. If you check my check record, my ground record, I don't watch jail.
Mr. Washington, I usually don't adjourn a week out. I usually go in 2-week intervals.
I know I've been
trying to get you before the court as quickly as I possibly
right,
can.
but I've been back, sir, with all due respect, a month. You know, I'd be a fool not to show back up in court in front of Judge Simpson anyway. You know, I'd be a damn fool if you let me go not to show back up. But
that's probably accurate.
Right.
So
you know, with all due respect.
No,
right, but
that was a heap of respect.
Right, I'm just saying.
I'm good.
You know, my father is ill right now.
Mr. Washington, okay. I know you may want me to do it a different way, but you also know me well enough to know I'm gonna do it my way. I'm gonna hear everybody out, and this is the way I'm gonna do it. So I'll see you next week. If at that point the stuff that's supposed to happen doesn't happen, then I'm gonna deal with that. I'll let you waive. I'll let you do whatever you need to do. But I don't want you in a circumstance where you might be hurting yourself. If something worked out that's gonna be beneficial for you, then let's get it worked out and let's get this thing moving. All right? Thank you. His bond will continue.
Thank you, Your Honor.
Court calls the case, People versus Amari Douglas. Somewhere on my desktop.
And Mackie on behalf of Ms. Douglas, who is approaching. Please
Good
state your name
morning.
for the record. Amari Douglas. Good morning.
All right, what are we doing?
Your Honor, at this time, we would request an adjournment.
We did receive a mitigation report from Ms. Mackey yesterday. Speaking of big job.
All right. Probable cause conference, June 5th, 2025. 9 a.m. bond continue.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Thomas Elkins.
Thank you, Richard, good for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Elkins, who approaches, Your Honor.
Waiving.
Yes, Your Honor.
Mr. Elkins, you're waiving your, state your name, I'm sorry.
Thomas Dale Elkins.
All right, you're waiving your right to have a preliminary examination?
Yes, sir.
All right, you understand that's a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed.
Right. Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
Your Honor, we acknowledge receipt of information. Wait for me reading, stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter not guilty plea to both counts. Pretrial in this matter will be set for
June 4th at 1:30 p.m. with Judge Conlon.
June 4th, 2025, 1:30, Judge Conlon.
Okay, that's
Your Honor, I couldn't hear, was that Conlon or Conlon?
Conlon.
Thank you. And does the bond violation just follow since he waived?
What's his bond violation?
Your Honor, it's my understanding that Mr. Elkins was alleged to have failed to download his Scram tether after February 24th. And also there was a drinking event alleged in that violation as well.
On March 5th, after his bench warrant issued for the first violation.
But he's in custody now. What's his bond? He doesn't have a bond.
It's denied from the warrants.
That's correct, Your Honor.
I'm not going to issue any, I don't know what further sanction you want me to do. So I'm just going to have his bond continue as denied.
Thank you, Your Honor.
Take it. Court calls the case of the people versus, he's back, Tequila Evans Guyton. Come on up here, Tequila.
Waiting 2 weeks to say that.
I have. I said, when is Tequila coming back?
Can we call this case?
Pardon?
Can we recall it? in a little bit?
You want me to pass it?
Yes, Your Honor.
Thank you.
So I get,
I want whatever
I get
you
to
want.
say Tequila again?
Yeah.
Okay.
Twice in a row.
Court calls the case people versus Montel Gatlin. Tequila's back here all. She's like, why you call me out like that? The prosecutor say something.
No. Sorry, just another question.
Assistant Public Defender Chelsea Vergils with and on behalf of Montel Gatlin, please state your name.
My name is Montel Gatlin. Thank you. What are we doing?
Your Honor, we are asking to set the preliminary exam in both of these cases. We do not have discovery in one case. I informed my client of that. He does not wish to waive the 21-day timeline in these cases. He asks to set preliminary exam regardless of knowing we don't have discovery in one case.
Which, yeah,
I mean, may I speak?
if you want.
I kind of I don't want her to represent me
Okay, so you don't get that choice necessarily, but why?
because, this conflict, like, we had a back and forth back there in the back room. Like, I don't think she has my best interest.
Really?
Yes.
Why? Because she wouldn't do what you
Huh?
want? Because why do you say that? Because I've never known Mr. Deals not to have her client's best interest at heart. Ever.
A lot of things she said, this,
A lot of things that she said you may have disagreed with, right?
really all things. she
Okay,
said.
all she said. Sometimes that's a lawyer's job. Sometimes they have to give their client the hard facts of what's going on. And they have to do that they have to give them their legal interpretation of what's going on, which may not suit with what you want to happen in the world. But they just give you a steady dose of reality. So if you disagree with her legal analysis, then fine, but show me your law degree.
No, I'm disagreeing with her legal advice.
Okay, and you're doing that with your legal degree that you have, right?
No, she was.
Yeah, that's what I thought.
No, I don't have a legal degree, but
I
she
know.
was trying to get me to waive things. And like I was telling her, it would kind of waive my rights to 180 days into trial, right?
She
And-
just got before me. Did you even listen to what she said? She has indicated that you don't want to waive any statutory period. So she listened to what you said. She told me that, and I was going to set these for exam. Anything else?
Yeah, I don't want her in my case.
Well, she's on your case.
Your Honor, I would ask to also address bond if possible.
Yes, you may. Hang on a second. Let me set the exams in these cases. And which case don't you have discovery on that he's trying to set it before you guys get a chance to even look at it? That makes so much sense, but go
We're
ahead.
asking, media discovery on 25 FB 1090.
On 1090,
Yes, Your Honor.
discovery on that one is not complete. I'm gonna note that. Do people have their witnesses available on the 3rd? Pardon? All right. Preliminary examination in these matters will be set June 3rd, 2025. 9 a.m., that's before me. Those both come before me. They're in person, as to bond.
Your Honor, we're asking the court to consider lowering the bond on case 25 FB 1142. Currently, it's set at $50,000. He's asking you to lower it to the same amount as his other case, 10%. Mr. Gatlin is an Ypsilanti resident. He is employed as a plumber. He at least was before he was in custody and plans to go back to that work. He's involved with his church. He plans to abide by his bond conditions. At this time, he's been in custody for 11 days now, and he is being held until May 29th on a case with Judge Washington. His sentencing is May 29th on that case. So he hopes that the bond will change at that time and that he'll be able to be released. So we're asking you to lower to something he'll be able to pay
So he's being held on a case before Judge Washington now.
until May 29th,
What's the proceeding on May 29th? Do we know?
sentencing.
Sentencing. What kind of case is that? Do we know?
I don't know, Your Honor.
All right. Response from the people?
Your Honor, we've asked for the bond to stay the same. We think it's appropriate. He does have multiple pending cases at the same time. The case in 1090 is a installment case. This case has concerning elements of that. He's accused of child abuse, but also fleeing police and possessing a firearm. He's both a danger and a flight risk, and we think that this bond is appropriate.
All right. In this case, what I'm going to do is I'm going to deny the request for a bond reduction in this case and leave his bond in place. If something happens on the 29th, before your, because that'll be about 4 days before you see me. If something happens on the 29th where he's eligible for release, then you can contact my office and I'll reconsider this decision.
Thank you, Your Honor.
Thank you. Thank you. Clerk calls the case, People versus Mohammed Farah. Good morning.
Public defender, I'm Mr. Mohammed Farha. Mr. Farha, state your name for the record.
Mohammed
please.
Farah. Good morning.
All right, what are we doing?
Your Honor, the people who this matter, NRA is on its way to your staff.
All right.
for signature.
Any objection?
Do you object to that, Mr.
No.
Farha? No objection at all, Your Honor.
He said no, had a big smile on his face. All right, this case is dismissed. Good luck to you, sir.
All right,
Thank you very much, Your Honor.
Court calls the case of the People versus Sheena Stout.
Sam Bernstein with and on behalf of Ms. Stout.
Your name, ma'am?
Sheena Stout.
Thank you. What are we waiving?
Yes, Your Honor. We're going to be waiving and I hope to address bond afterwards.
Ma'am, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single charge.
Your Honor, we ask the court to please waive any further reading, continue not guilty plea. I can confirm receipt of the information.
Defendant having waived reading, pleading not guilty, court will enter that not guilty plea. Pretrial will be set for
June 3rd at 1:30 p.m. with Judge Conkey.
June 3rd, 2025, 1:30, Judge Conkey. As to bond.
Your Honor, Ms. Stout is already before Judge Conkey on a probation violation. She's scheduled for that same day. She went in front of her earlier this week and Judge Conkey allowed a release to treatment for her bond right now. And we're asking if the court would please consider making her bond in this case consistent with that.
If you prepare an order for release to treatment, I'll sign it. I mean, I tell people that I don't have a problem with that at all.
Oh.
So
well,
I will continue her bond. You guys get a stipulated order for release to treatment and I don't have a problem.
Sounds good.
Thank you.
Court does call the case, People versus Durantu Francis.
Andrew Children's Grant on behalf of the people.
Second, really, I think this is your case, as is everyone here. And so, you know, you were really good for the first 4 or 5 cases that you appeared timely. You started wandering.
Where did she?
No, you started just wandering around and we almost couldn't find you. And then Lauren Brown had to get up and he said, I don't know what's going on. Just didn't. Now you're here. All right.
Thank you, Your Honor. Assistant Public Defender Chinazi Kyriakin Ruli on behalf of Mr. Durantu Francis. Durantu, state your name for the record, please.
Durantu Francis.
Judge, we respectfully request that this matter be set for preliminary examination.
Council approach. Yes.
Maybe sent you right before they come back to the, because they're on me now. I said they're on me now. Do you want me to sit you correctly before they come?
All right, Ms. Francis, I'm going to pass your matter briefly, okay?
Okay.
All right, thank you. All right, let me do some other. Court calls the case People versus Gervonta Davis. Gervonta Davis. Is that Davis?
Good morning. Good morning, Your Honor. First Assistant Public Defender Kalina Anderson with on behalf of Mr. Davis. Mr. Davis, state your name.
Oh my God.
Davis.
Thank you, sir. Oh my gosh.
She's here.
I know. No. Right, is my day.
Your Honor, we're requesting an adjournment in this matter. We referred this to the investigator and we need to do a little bit more
All right.
research.
Probable cause conference will be adjourned to June 5th, 2025.
Your Honor, the investigator is asking for 30 days. If Your Honor could give us.
The investigator's asking for 30 days?
Yes, Your Honor. If you could, please.
Oh, so apparently now they're setting my docket. It'd be on a Tuesday, the 24th, 17th.
Okay.
So I'll go out to June
We'll see you on the
17th,
17th. We'll come talk to you.
2025.
Got it. We'll be ready.
That's at 9 a.m.
Thank you, Your Honor.
Well
June
done.
7th, Mr. Davis. Have a good one.
Court calls the case People versus Taiwan Griggs.
Hannah Mackey on behalf of Mr. Griggs, who's appearing via Zoom, I believe. Yep.
Mr. Griggs, state your name.
Taiwan Griggs.
Right.
Your Honor, we're requesting an adjournment in this matter pending mitigation.
Without objection. Probable cause conference, June 12th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Mr. Griggs, I'll be in touch. I'm sorry. Your Honor.
Remember, I
I'm
get
so
in
sorry.
contact with you as soon as possible.
I just saw him.
No, any more messages you want to send? Go ahead. No, you sure?
So you guys have a blessed day.
I'll wait. Court calls the case People versus Larry Hickman.
Assistant Public Defender Chinazi Kyriakin Ruli on behalf of Mr. Larry Hickman. Mr. Hickman, could you state your name for the record, please?
Mr. Hickman, can you state your name?
Okay, he's got a really low voice, Judge.
Okay.
Okay, so Your Honor, we are asking for an adjournment in this matter. I know the last time we were here, we requested an adjournment because the people, there were new charges. They've been authorized.
They have not been authorized.
They have not been authorized, but
There still a phone bill to be completed. We're waiting for that to take place. Still waiting for that final.
Well, how soon are we?
I can do a precursor charge of what I know now, or I can wait until the phone number.
I don't care what you do. I just need to know how much time I need to give you.
I'd say 4 weeks, and then I can alert the court if get something sooner.
June 17th, 2025. 9 a.m. Bond continue.
thank you, Judge.
Thank you.
Happy to see you, Mr.
What? Wow. 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 That was so wrong on so many levels, but I like it. Court calls the case of the people versus Lena Arbali.
We're ready, Mr. Donna.
Owen Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Harbali, who approaches the podium.
Hello, your
Harbali,
name?
please state your name.
Lena Harbali.
Thank you. What are we doing?
So, Your Honor, this is something that we are trying to get into the mental health court. There's an evaluation pending. I think we'll need 2 weeks to make sure that that evaluation is complete.
All right, has the process started yet, or?
According to Mr. Gaddy's notes, I'm not clear, but
I'm in CMH, so yes.
yes, it has started.
I think yes.
Okay. Well, I'm not certain. My client thinks that she is because she's part of CMH, but that's not here in Washington.
All right, why don't we
Yeah,
do this?
it's Washoe Community.
Okay.
All right, why don't I go 3 weeks instead of 2 and make sure. Probable cause conference, June 12th,
So we have
2025, 9 a.m.
that
Bond continued.
was the 12th, Your Honor, June 12th.
12th.
I'm going to give you a note. So you don't have to.
All right.
I can have anything on me.
Then I can do that. Court does call the case of the people versus Chad Jones.
I never said good morning. Good morning, Your Honor. Khidma Dadish on behalf of Mr. Jones. Can you state your name for the record, please?
Chad Jones. Thank you. All right.
Your Honor, I had not previously had client with Mr. Jones. He got into custody yesterday. I did speak to him with this morning, but we are gonna ask for an adjournment, please, so we can go over discovery and talk to the prosecutor about any potential offers.
And also deal with his violation of the court.
Yes.
All right. Data. Probable cause conference in these matters, June 5th, 2025, 9 a.m. Bond will continue in these cases.
Thank you, Your Honor.
Thank you. All right, yes. Second Ruley and Mr. Childers, court's gonna stand in brief recess. Take it back and we'll talk about this. All right.
I can see you. How about you?
Thank you. Court does call the case. People versus Paris Lester.
Khidma Dadish with and on behalf of Mr. Lester. Can you say your name for the record?
President Lester. Thank you.
Your Honor, we are going to be requesting an adjournment to review discovery.
Probable cause conference will be adjourned 5th, 2025, 9 a.m. Bond.
Thank you.
Court calls the case of the people versus James Harbin.
People.
Owen Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Harbin. Mr. Harbin. He's at St. Joseph
Hospital. Correct. I changed his. This was the one I changed his bond on. I don't know that we have a indication, but what I will do is I'll adjourn it to the 12th. Let's see where everything is at.
Thank you.
All right. June 12th, 2025, 9 a.m. Bond. Court does call the case of the people versus Germond Matthews.
First Assistant Public Defender Queen Anderson, on behalf of Mr. Matthews, who's approaching. State your name for the record, Mr. Matthews.
Matthews. Thank you. You're requesting an adjournment.
Yes, Your Honor, we referred this to the investigator. I did hear Your Honor give the co-defendant June 12th.
Will that work?
That should be
So
fine.
the co-defendant was,
Yes, Your Honor.
all right. Probable cause conference, June 12th, 2025, 9 a.m. Bond continue.
We'll come talk to you before the stuff, okay, but call me or Monday, once you know what happened.
Court does call the case of the people versus Jennifer Jones.
Hello, Your Honor, I'm sorry. Can you hear me?
Yeah, we can hear you.
Okay, cool. Assistant Public Defender Natalie Pate with and on behalf of Ms. Jones, who is present via Zoom. Ma'am, can you please state your name for the court? Jennifer Lee Jones.
Thank you, Your Honor. At this time,
She's upside down, but that's okay.
she is, but she's here.
I don't want to lose you.
Your Honor, at this time, we would request to set this case for preliminary examination. I believe discovery is complete.
You believe, okay.
I'm sorry, Your Honor, I didn't know how to fix it.
You did not what?
I didn't know how to fix it to make me go straight.
No, you're okay. You're okay.
I'm sorry.
No, you're fine. You're fine. We'll be able to deal with it. Miss Pate is just happy you're here.
All right,
Okay?
this is my first time on Zoom.
Yeah, I wouldn't know it. You're such a pro at it. You're doing well.
I'm upside down.
Yeah, no, it's okay. It's okay. Will the people have their witnesses available on the 3rd or what? What's the date? The 5th? Yes, the 3rd.
What's our best, Your Honor?
Preliminary examination in person, so you don't have to do this again. June 3rd.
Okay, I gotta go there because I live in Flint. June 3rd.
2025.
Uh-huh.
It's 9 a.m. That will be before Judge Perry.
All right, cool.
All right, yes. Your bond will continue, okay? Miss
All right.
Jones, you have a great day.
You have a blessed day too. Holla at you.
Bye-bye.
Thank you, Ms. Jones. Thank you, Your Honor.
All right.
Okay, so everybody else is there. Court does call the case, people versus Jacqueline Murray.
Prosecutor Victoria Clark here on behalf of the people.
Emma Dadish on behalf of Miss Murray. Thanks, Murray. Statement of the record.
Jacqueline Annette Murray.
All right.
Your Honor, first we were going to adjourn to try to get her released into treatment, but I talked to the prosecutor and we have come to an agreement that we believe it's best for her to get released into treatment if Your Honor would grant that. I did send Anne a stipulated order if you need that. Otherwise, we can just adjourn it to get that order in.
What?
We're trying to get
You're
her-
trying to adjourn it. You want me to make a condition of her bond that she be released to treatment?
Yes, Your Honor.
Okay.
Yeah, we don't need to adjourn it. Unless Your Honor needs to adjourn it. I thought we could do it today.
Do what today?
Modify her bond conditions so gets released into treatment. Oh. The case we are adjourning.
You're adjourning. Okay, how much time did you need?
Couple of weeks, Your Honor, please. Thank you.
You're just parroting what Bellinger's saying. It's okay. It's okay. Probable cause conference will be adjourned June 5th, 2025, 9 a.m.
Thank you, Your Honor.
Bond, you're welcome. Her bond will continue, and I, of course, will sign the order for her to be released on a PR.
Thank you, Your Honor. Thank you.
Thank you, Your Honor.
You're welcome. Court calls the case, people versus Emmett. Oh, well,
No, it's okay. Ask me in a second.
Yeah, I know. But Emmett Pawa,
And then on behalf of the people, Your Honor.
Assistant Public Defender Jay Ballinger on behalf of Mr. Pawa, who approaches. And Mr. Pawa, can you please state your name for the record?
My name is Emmett Powell.
thank you.
And Your Honor, we're just asking to set this matter for preliminary examination. Discovery is complete to the best of my knowledge.
People have their witnesses available on the 3rd. Preliminary examination in person, June 3rd, 2025, 9 a.m. before Judge Perry.
Okay.
Bond will continue. Thank
Can you
you.
touch okay? Okay.
Court does call the case of the people versus. You took my file away. Durantu Francis, just one moment. No, that's not that person. Hang on.
Andrew Childers, appearing on behalf of the people.
And Assistant Public Defender Tanaka Carey, I can really again, Your Honor, on behalf of Mr. Rantu Francis.
All right, the record should reflect, we had an in-chambers conference. I'm going to adjourn the probable cause conference based on that conference to June 5th, 2025, 9 a.m. Bond in this matter will continue. Thank you. Thank you, Ms. Francis.
Thank you, Your Honor.
Court does call the cases of the people versus Siobhan Benson.
Benjamin, on behalf of the people, Your Honor.
There are how many cases? 1, 2, 3, 4.
Ready?
Huh?
Good morning, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Vincent. Ms. Vincent, could you state your name for the record, please?
My name is Javon Benson.
Thank you.
Your Honor, today's the date and time set for, I believe, a competency review hearing.
Yes.
We do not yet have any updated reports. Does the court have a report?
I do not. I think the information that we had is that she was interviewed. They were accumulating the information and preparing a report. So what I will do in this instance is I'll adjourn this out, indicating that we don't have the report yet. But they did indicate that that report should be available soon. So I'm going to adjourn it to June 26th. We will move that date up if we receive the report earlier. June 26th, 2025, 9 a.m. Bond will continue as denied.
Thank you.
All right, thank you. They've got more. Who? Detlefs. I already called that, right? Yes. Correct. Court does call the case of people versus Benjamin Detlefs. This is a recall.
Andrew Childers, appearing on behalf of the people.
Assistant Public Defender Jay Ballinger on behalf of Mr. Detlefs.
Made that 890 out.
Mr. Detlefs, can you please restate your name for the record?
Yes, Benjamin David Detlefs, Your Honor. Detlefs.
And Your Honor, it's my understanding that the court is now in receipt of the competency evaluation and also the finding in order. I did indicate to the court via email that I did only include the case number that was indicated in the report itself for the finding in order. Would ask that that be signed and would also ask to address bond.
All right. I've signed the order. The defendant, after the court has reviewed the report, still remains incompetent to stand trial, but likely to obtain competency with treatment. And so the court will set the next review hearing for, August 14th, 2025, 9 a.m. as to bond.
Thank you, Your Honor. As to bond, Your Honor, my client has been in the Washington County Jail for the last 259 days. His current bond is set at $1,000 cash or surety and $1,000 10% on his respective cases. I have talked to my client. He advises that he can attend smart recovery meetings at the Annex building. He has a local Ann Arbor address. He advises that he can get his medications there, that he can get his therapy there, that he can do drug testing there as well. He advises that he can attend that 3 times a week. My client also advises a more recent update with regard to his medical. He has a chipped tooth, Your Honor, that's causing him a lot of pain. He's asking for release so that he can get that taken care of with his own dentist, considering that he may be at a bit more of a detriment in terms of getting medical treatment for that within the Washington County Jail. I am asking that the court release him on tether. Home confinement would be okay. In terms of flight risk, Your Honor, I don't know that the issue is necessarily flight over potential dangers of the community. I do believe that that would be alleviated with the home confinement tether GPS for tracking purposes so that he can go and start taking care of his mental health and his medical issues.
Response.
Your Honor, I would ask that bond remain as currently set. The defendant's charges are all basically for assaulting police officers and corrections staff. The defendant is currently incompetent but restorable. If there were there's a very clear documented plan in place for the defendant to address his mental health issue if he was out of the jail, that would be something I would be more amenable to. But I think the best place, unfortunately, for the defendant in order to regain competency and make it so he's less likely to reoffend is to stick with the current plan, have him receive the treatment from the CFB and hopefully regain competency in a short time.
Your Honor, to that, my response would be that I will be in contact with Sarah Stewart from CMH so that I can see about working on a treatment plan for him, and then I will file a motion with the court so that we can readdress this at a different time.
All right. And I'm not going to do anything unless I can see a plan for this. Okay. Cool. So the motion for bond modification and reduction is denied at this time.
Thank you. All right. I'll be in contact with Sarah and we'll see about getting a plan started, okay? All right. Thank you, Your Honor.
Thank you. Court recalls the case. Hang on. Gotta make sure I see the name. Tequila Evans Gate.
That is on behalf of Ms. Tequila Evans Gayan.
State your name, please.
Tequila Evans Gayan.
That's it. Go ahead.
Your Honor, the prosecution has offered that Ms. Tequila can plead to an added count 2 attempt resisting police officer with no objection to HIDA with count 1 dismissed. Here's all the forms.
All right.
R.
And that's a guilty plea?
Yes, sir.
All right. The plea form the court has in front of it is indicating that she would be pleading to attempted resisting and obstructing a police officer, the 1-year misdemeanor. Upon her successful guilty plea to that charge, count 1 would be dismissed, and there's no objection to HIDA. That's the court's full understanding of it.
Yes, Your Honor.
Yes, Your Honor. And for the record, we are going to be requesting that she gets this under HIDA.
Pardon?
We're requesting that this be under HIDA. I don't know if I had to say that on the record.
Didn't you already say that?
Well, she has no objection to HIDA. That doesn't mean I'm requesting it.
Anything else you got?
Anything else?
All right, I'm going to talk to Tequila now. Can you have her sworn?
Raise your right hand. Do you solemnly swear in affirmative testimony about to give the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Tequila Evans Gayan.
All right. And it is this court's understanding that you are going to be pleading guilty to an added count 2 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes.
All right. I further have to advise you that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Washington in the 14B District Court. Do you understand that?
Yes.
Understanding all of that, you still wish to plead guilty? And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Oh, that's the same thing.
It's the same thing, actually.
Yes.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
January 20th, 2025, at the location of East Clark Road near Centennial Avenue in Ypsilanti Township, Washtenaw County, State of Michigan, did you come into contact with Washtenaw County Sheriff deputies?
Yes.
What happened?
They basically told me I swerved, my tail light was out, which it wasn't. But I guess they're allowed to do that because I guess there was a phone call in the area that basically there was some stuff going on in the area, so they just wanted to make sure it wasn't me. They see me with a nicotine breeze. I didn't know that we could be detained for that. So I was kind of scared when I seen 6 police officers, and then they were trying to tell me to get out the car, but I didn't know I could be detained for a breeze. So I was resisting, and then they placed me in the car and basically told me, oh, okay.
So you resisted and obstructed them by not exiting your vehicle upon their request.
Yes.
Is that correct?
Yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, sir.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
July 10th at 10 a.m. with Judge Washington.
July 10th, 2025, 10 a.m. before Judge Washington. Bond in this case will continue.
Thank you, Your Honor.
Take care.
Thank you.
All right,
Say your
be
name
real.
4 times.
That's it.
That's it.
Highlight. Mr. Cody Jolly was the first one. They've never seen you in
So what are all these smells? I don't call them.
work that he's doing. Yes.
Okay, we didn't have to say it that way. Court does call the case, People State of Michigan versus Cody Jolly.
Andrew Childers appearing on behalf of the people.
All right, Mr. Jolly is acting in pro per. Mr. Jolly does not wish to appear again.
The only update I have for the court is, myself and some colleagues have done some research about our case proceeding basically without the defendant.
Correct.
If the court wishes for us to go that route, my thought is that I would prepare a motion for this court to consider, and obviously we will serve it upon the defendant in the jail. But basically, if he continuing to make this what appears to be a knowing decision to not involve himself in the case, that doesn't mean that the case stops.
Correct. Okay, if you would file that motion, I'd
Yep.
certainly entertain it.
Okay.
Why don't I set a date for the I'll just set a date for the motion, which will be the same adjourned retrial. Can we get it in with adequate notice, say within, so I can hear it on the 12th?
The 12th would be perfect. That's
All
fine.
right. So I'll adjourn the probable cause and the motion to June 12th, 2025. I'll make that at 3 p.m. since we'll be dealing with the motion. Bond will continue.
Thank you.
Thank you.
Honor,
Oh, no.
on a non-case related matter.
Yes, ma'am.
I'll say the Michigan is now back in session. The honorable Judge Simpsons preside.
You may be seated. Court does call the case, People versus Denalia. Madam Attorney General, can you State your appearance.
Christina Beta on behalf of the people, number 74583.
Thank you.
Thank you, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Mr. Young, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Donnell Young.
Pick him up, he's Samson. All right. This is gonna be a waiver.
Yes, Your Honor.
All right. Mr. Young, you're waiving your right to preliminary examination?
Yes.
All right, you understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you will not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor, we would just ask that the defense attorney would put the offer on the record. I know she received an email from another assistant attorney general.
Yes, I can go back and read that word for word from if that,
Go ahead.
like, I'm sorry. That will take a moment for me to pull up. So this is the offer as stated from the Attorney General, that the $3,934 cash bond that was already paid to bond will be applied to the arrearages. If he continues to pay his $100 a month arrearages, as he has been for the last 2 months, he can plead guilty to 1 count of felony non-support and the other count will be dismissed. And then he would be asked to be placed by the Attorney General on delayed sentence under MCL 771.1 subsection 2. If he continues to pay the specified amount each month during the delay and pays the arrearage down to $7,500 or less, he may withdraw his plea and conviction for attempted felony non-support would enter. If he pays in full, the charge will be reduced to disorderly person, the 90-day misdemeanor, and that in both felony counts of felony non-support would be dismissed. And that is the offer as presented to me by Attorney General Mr. Mitchell J. Wood. And that is what I have discussed with my client.
Okay.
Thank you.
Preliminary examination, we're gonna waive.
Excuse me.
Mr. Young, it's what we discussed. I just had to put that on the record. Let the judge give us our next date, sir.
But you said something about pleading guilty to a felony. We didn't discuss that.
No, you're not pleading guilty today to a felony, sir.
All right, Mr. Young, do you still want to waive?
Sure, because there's some things she said that we didn't discuss.
All right, why don't I do this? So that, because it involves a discussion as opposed to what's happening here
So we can talk about it again, Mr. Young. It was exactly the offer we discussed a few times on the phone, including today, but we can ask for an adjournment to discuss it again.
So why don't I adjourn this out? I'll adjourn this out to June 5th, 2025 at 9 a.m. or as your invite indicates, bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Mr. Young. We'll discuss this again.
Thank you.
Court does call the case of the people versus Matthew Fitzgerald. 2 cases.
Assistant Public Defender, Chinaki Akinrumi, Your Honor, on behalf of Mr. Matthew Fitzgerald on the 7-3.
Yes, Your Honor, and Robert Ellman with and on behalf of Mr. Fitzgerald on the matter ending in 7-2.
So Judge, I think we can go first. In our matter, we ask that this court set this matter for preliminary examination.
And on that matter, the discovery is complete.
To my understanding, Judge.
People have their witnesses available the 3rd.
You can certainly try. I do want to confirm with both counsels of Mr. Ellman, the offer that you have been negotiating in circuit court does not involve this case. Is that correct?
That is correct.
Okay.
So in the case ending in 7-3, preliminary examination will be set in person, June 3rd, 2025, 9 a.m. before
Judge Perry.
Judge Perry.
Thank you, Judge.
In the other matter, he's waiving.
Yes, Your Honor, you should have a signed waiver there in your file.
Sir, is that correct? You're waiving your right to a preliminary examination?
That is correct.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and you committed it.
I do.
You understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution.
I do.
People also waive the right.
Yes, ma'am.
Preliminary examination having been waived, defendant is bound over to circuit court on all three counts. Mr. Elman.
All right, thank you, sir.
Waive formal reading and stand mute, Your Honor.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Pretrial will be set for
June 17th at 9 a.m. to Judge Bell.
June 17th, 2000. That can't be right.
Judge Bell?
Said Judge Valvo.
I could have been making stuff up.
You did?
Yeah.
I need a preliminary date. I need a pretrial date on this.
July 16th at 1:30 p.m.
July 16th, 2025, 1:30 before who? Judge Conlon. That makes sense. Bond will continue.
All right, thank you, sir.
Thank you, Your Honor.
Court calls the case People versus William Phillips.
And then we have people run.
They need to sign that information.
Good afternoon again, Your Honor. Robert Elman with and on behalf of Mr. Phillips. Your Honor,
Your name, sir? William Phillips.
and Your Honor, may we approach briefly?
Everybody has been all day. Why not? Yeah. Discovery to your knowledge is complete.
Yes, Your Honor.
And people have their witnesses available on the 3rd.
We'll do our best.
Preliminary examination will be set June 3rd, 2025, 9 a.m. That is before me.
Thank you, Your Honor.
Bond will continue. Court calls case People versus Lemaine Caba.
Jennifer Douglas for the people.
Assistant Public Defender Natalie Pay on behalf of Mr. Kaba, who may be present via Zoom.
Yes, I do see. Mr. Caba. Okay. Oh, there he is.
Yes.
Sir, can you state your name, please?
Lamine Kaba.
Thank you.
Thank you, Your Honor. I'm respectfully requesting a brief adjournment to continue plea negotiations with the people.
Probable cause conference, June 5th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Montez King.
Assistant Public Defender Natalie Pay on behalf of Mr. King also be present via Zoom.
Mr. King, can you state your name? You don't have him? I thought, no, that was the other one.
I'm right here. You hear me?
Yeah.
Okay, state your name.
Montez King.
Okay, you got it.
Thank you, Your Honor. I have discussed this matter with my client as well as APA Willenbring. I'm ultimately requesting a very brief adjournment so that we can confirm that discovery is complete. There may or may not be some outstanding discovery from return of a search warrant. Ms. Willenbring did check with that detective. We just need to get an answer from her to confirm that whether or not there's anything forthcoming from that. I believe 2 to 3 weeks should be sufficient.
June 5th, 2025, 9 a.m. Bond continue.
I hate to
Thank you, Your Honor.
interrupt, Your Honor, but I have a prior court proceed in Jackson County, June 5th.
June 12th.
Thank you, Your Honor.
Bond continue.
Thank you, Your Honor.
Thank you.
Thank you, Mr. King.
Court calls case People versus Alante Lindsay.
And then on behalf of the people, Your Honor.
Assistant Public Defender Chelsea Vergils on behalf of Alante Lindsay. I believe he is here today. I spoke with him just a few minutes ago. Do you mind passing it so I can go find him?
We did this with you the last time, didn't we?
I don't recall, honestly.
What a perfect answer.
If he shows, if you tell me he's on a bus, I'm coming up.
No, I believe he's in the restroom, actually.
Oh, okay, all right, I'll pass it.
Thank you, Your Honor.
Court calls the case, People versus Timothy Lloyd.
Can I be happy people, Your Honor?
Back on behalf of Mr. Lloyd, who is approaching, Your Honor. Please
Your name,
proceed to the
sir?
record.
Timothy Lloyd. Thank you.
Your Honor, we respectfully request to adjourn this matter pending more immediate discovery.
Probable cause conference will be adjourned June 5th, 2025, 9 a.m. as your invite indicates. All right. Bond
Thank you, Your
continues.
Honor. I'll text you.
Court calls case People versus Emily Bates.
Andrew Childers again on behalf of people.
Madam Mack, on behalf of Ms. Bates, who is appearing via Zoom.
Ms. Bates, can you unmute and state your name, please?
Thank you, Your Honor. Good morning. Good afternoon. My name is Emily.
That is Ms. Bates.
Yes, it is.
Go ahead.
Your Honor, I believe we are also requesting to adjourn this matter.
Got it. Probable cause conference, June 5th, 2025, 9 a.m. or as your invite indicates, bond continue.
Thank you, Your Honor.
All right. Thank you. Court calls case People versus Robert Martin.
Good afternoon, Your Honor. Chief Assistant Prosecutor Victoria Burton here is appearing on behalf of the people.
Assistant Public Defender Chelsea Virgiles with and on behalf of Robert Martin. Please state your name.
Robert Martin?
All right, what do we do?
We're asking to adjourn this for a plea discussion.
Fifth, 2025, 9 a.m. or as your invite indicates, bond continue.
No, it only happens on Thursdays.
Thank you. Court calls case People versus Jeremy Meza.
Jeremy Mesa.
That was him. Got it.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Meza, who is present via Zoom. I believe he may have already stated his name.
He did.
Thank you, Your Honor. I'm respectfully requesting an adjournment to finish reviewing the media discovery in this case.
Got it. Probable cause conference, June 5th, 2025, 9 a.m. bond continue.
Thank you, Your Honor.
Thank you.
Thank you, sir.
Thank you. Court calls case People versus Jacob Miller.
Good afternoon, Your Honor. McKenna, Assistant Prosecuting Attorney on behalf of the people.
Assistant Public Defender Dave Bellinger on behalf of Mr. Miller. Mr. Miller, can you please state your name for the record? Jacob Miller.
All right. I have before me a plea form that indicates that the defendant would be pleading no contest.
Yeah.
No contest to charge of assault and battery. That's the 93-day offense. Upon a successful plea to that charge, count one would be dismissed, and people are agreeing to HIDA probation per the pre-sentence recommended.
That is our understanding of the offer, Your Honor.
That's correct, Your
All right. May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Jacob Miller.
All right, sir, it is this court's understanding you're going to plead no contest to the charge of assault and or assault and battery.
Yes.
It's a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. Do you understand that?
Yes.
Do you understand what a no contest plea is?
Not guilty. No, do you understand that a no contest plea is a plea where the judge would take a factual basis from the police report, like we discussed.
Okay.
The court would still consider it a guilty plea. Yeah. However,
okay. So you understand that a no contest plea means that you're not further desirous or wanting to contest this charge of assault and battery. You understand that? You also understand that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty to this charge. You understand that?
Yes, Your Honor.
All right, do you have any other questions at all regarding the no contest plea?
Nope.
All
Thank
right. Basis for the no contest plea.
Fear of potential civil liability, Your Honor.
All right. And so I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1483 District Court. You understand that, sir?
Yes.
All right. You still wish to plead no contest?
Yes.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No, Your Honor.
All right, please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights in that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
All right, the court has been provided and has reviewed Northfield Township Police Department report for their case number 246227. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of the defense counsel. Have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be
July 14th.
July 14, 2025, 9 a.m. before Judge Freshour.
Thank you, Your Honor.
Thank you. Bond will conclude.
Okay. Thank you. If you have any questions, let me call.
Court calls case People versus James Moody.
Good afternoon, Your Honor. Assistant Prosecutor Victoria Burton here is appearing on behalf of the people.
First Assistant Public Defender Kalina Anderson with and on behalf of Mr. Moody. Mr. Moody, state your name.
James Moody. All right. I have before me a plea form. Is that what we're doing?
Yes, Your Honor. Thank you. My client will be pleading guilty to an added count 3 of retail fraud 3rd. In exchange for that plea, counts 1 and 2 will be dismissed.
Yes. All right. That's the court's understanding of the agreement. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
That's your name?
James Moody. All right. Sir, it is this court's understanding you are going to be pleading guilty to the charge of retail fraud in the 3rd degree.
Yes.
That's a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs.
Yes, sir.
Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes, sir.
All right. Understanding that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's
No, sir.
stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will.
Yes, sir.
All right. And because you believe that you are guilty of this offense?
Yes, sir.
May 18, 2024, at the location of 3825 Carpenter Road in Pittsfield Township, Washington County, State of Michigan. What did you do at the Meyer store that makes you think that you're guilty?
I stole some. I took something that wasn't mine without paying it.
All right.
Out
You
of the
walked
store.
into the store. You took certain items and tried to walk out without paying for them. Is that
Sir.
correct? All right. Store was open to the public at the time.
Yes, sir.
You didn't have anybody's permission to take that property, did you?
No, sir.
And this property you took was property that was offered for sale by Meyer?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
So satisfied.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed.
Thank you.
Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be June 28th, 2025, 9 a.m. That's before me.
Thank you very much, sir.
Thank you.
Thank you, Your Honor.
Bond will continue. Thank you. So you can stop down at the probation department on your way out and check in with them so we can get that process started. Thank you. Court calls case People versus Antoine Patterson.
Assistant Public Defender Jay Bellinger on behalf of Mr. Patterson, who approaches.
Thank you.
Your Honor, may Mr. Bellinger and I approach?
You may. Why not? All right, record should reflect that a bench conference in this case, the probable cause conference in this case will be adjourned to June 17th, 2025. 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Thank you. Court does call the case of the People versus Carlos Payne.
Your Honor.
Assistant Public Defender Chelsea Vergil Smith, and on behalf of Carlos Payne, who appears via Zoom, Mr. Payne, please state your name.
Carlos Payne.
You got it.
Your Honor, we are asking to set a preliminary exam in these cases, and I would ask to address his bond conditions.
All right, so discovery is complete in both matters?
To the best of my knowledge, it is, Your Honor.
All right. People in these cases have their witnesses available to third. Okay, in these matters, preliminary examination will be set June 3rd, 2025, 9 a.m. before Judge Perry. As to bond.
Your Honor, we are asking the court to consider allowing him to remove his GPS tether, of course, keeping the no contact and no go-to orders in place. He's been on the tether a few weeks now with no violations. He lives in a separate city from the complaining witness, with him living in Detroit and her living in Ypsilanti. He does work full-time. He shares a child with the complaining witness, but I spoke with him about how he can meet with her or meet with a third party to exchange the child if necessary. For financial and just general comfort reasons, he's asking to have the GPS tether removed, as well as he's got a physical job. It does get in the way. Again, full-time, working, no violations. We ask you to consider removing his tether.
Is there any response from the people?
Your Honor, we would object to removal of the tether, given the facts of these cases. They're very serious. One of the cases is GBH, in which he was dropping off belongings for the child. After dropping off these belongings, he came at the victim, got in her face, they went upstairs. He was stating he was going to kill her and her mom, and then punched her in the head. He then got behind her, was strangling her from behind with a headlock and slammed her to the ground. And then in the other case, he threatens her with a knife and a gun, saying that he would shoot her through the door. So I have great concerns with the safety and would ask the tether remain here.
Your Honor, he of course denies the allegations, but further, he's shown that he can comply with bond conditions so far, fully compliant. I don't believe that would change simply due to the tether removal. He understands the risk of being brought back into custody if he were to violate.
Motion for bond reduction or bond modification is denied. GPS tether will continue in place, and certainly feel free after the exam to bring that up for Judge Perry. I'm going to deny it at this time. Thank you. Court calls the case People versus Taiwan Felon.
Others for the people. Others on behalf of Mr. Taiwan Phelan.
Phelan.
Um,
State your name.
I just realized.
Taiwan Phelan.
Phelan. I remember from the last time.
Oh, I already have one. Sorry about that. I'm not doing well today. Your Honor, we were going to be requesting an adjournment to continue plea negotiations with the prosecution. I can't believe I forgot the green sheet, but
I don't know. You said you had one and then you didn't have one.
There you go.
What I'm talking about. I just. God's conference will be adjourned June 5th, 2025, 9 a.m. or as your invite indicates, bond will continue. Thank you. Court calls case People versus Austin Lee Ray.
Good afternoon, Your Honor. Chief Assistant Prosecutor Victoria Burt here is here on behalf of the people.
Anna Mackey on behalf of Mr. Ray. Your Honor, we've been trying to get a hold of Mr. Ray. We have not been successful. I've reached out to his CMH worker who has also been trying to reach out to him. So we respectfully request an adjournment to see if we can find him.
He also has a violation, community corrections violation report.
He does. He has failed to report to community corrections. I think the problem is, Judge, no one has heard from him or seen him, and he's done nothing to report to.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls case People versus Joanna Reed.
Assistant Public Defender Jeff Bellinger on behalf of Ms. Reed, who approaches, Your Honor.
Your name, please?
Johanna Reed.
And you're requesting forensic referrals.
We are, Your Honor. I have submitted that to the court for its signature, and I would also ask to address condition of her bond when appropriate.
Forensic evaluations are ordered. I'll set a competency hearing for 90.
August 14th.
August 14th, 2025. 9 a.m.
Thank you, Your Honor.
Esteban.
Esteban, Your Honor, my client is requesting that she not have to drug test anymore. I know that that is generally a basic condition of bond. However, the allegations in this incident don't prescribe to the fact that she was using, there's no allegation that she was using drugs or alcohol. This is a case, Your Honor, that I have submitted for competency, certainly. But with regard to the drug testing itself, my client simply can't afford to do it. She does not want to get a bond violation for her inability to afford it. So we would ask that the drug testing cease at this time.
Response.
Your Honor, the people actually don't have an objection. I don't have any information to indicate that Ms. Reed has ever had a substance abuse problem. She was recently petitioned a month or two ago and is currently undergoing by court order. And so, Your Honor, at this time, I don't see that.
I'm trying to see what was the original. You say she's drug testing off of this case?
That is my understanding, Your Honor, based on my
Does
conversation.
she have any other matters pending? No?
Not that people know of, Your Honor.
Being asked for drug tests right now?
Every week.
Every week?
Ma'am, do you have any other cases pending?
I think so.
Your Honor, she advises she's being asked to drug test once a week on this case.
Your Honor, I'm wrong. She does have another case. She does have another case.
Oh, not one on. Oh, okay.
OWI on the 15th?
I
I
apologize.
don't have a drug testing order.
Your Honor, I apologize. That was something that I wasn't.
Hey, no, I'm used to you wasting my time. So I can't.
Understood, Your Honor.
No, I got you. So August 14th, 2025, 9 a.m. Bond will continue. All right, thank you.
You can't do anything about the testimony. I have to ask the 15th district court how he's going to do that.
Nothing. Court calls the case People versus Deborah Spears.
Anna Mackey.
If you were to me, this is the people.
Anna Mackey on behalf of Ms. Spears, who is on Zoom, I believe.
Ms. Spears? You try.
I am.
Good morning. Can you hear me?
There she is.
I'm sorry. I'm not sure what's going on with the Zoom.
Oh, okay. Ma'am, how do I spell your last name?
Spears.
Okay, we'll need to amend the complaint. The spelling of her name, I think off of the complaint is EERS.
Yeah,
Just
it
double
is.
check. Yeah, I think, well, actually, there's an AKA that covers it. That's why. It's EERS, and then there's an AKA also known as with the last name spelled EEARS. So I think we're good. All right. In this case, I have before me a plea form that indicates the defendant is going to be pleading guilty by to the offense of embezzlement by an agent or trustee, 200 to 1,000. The 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. There is further an indication that the defendant must pay $1,170 restitution in full to Speedway to comply with all other conditions of probation of the court sentence to receive the dismissal of count 2 via prosecutor's deferred. Okay, that's a lot, but okay.
That's the correct statement, Your Honor.
So I guess I'm trying to figure out what's going to happen if.
Yes, Your Honor, I can clarify. There was previously discussion of a resolution in this case with prepayment of restitution. When this was pending back in 2023, Ms. Spears had not been able to make those payments at the time, and then she was out for a while on the bench warrant. So we decided to resolve it in a way that will have her commit to paying that amount rather than a prepayment, so that they'll end up in the same sort of cycle. I did also add a prosecutor's deferred to that offer as well. So when she does repay that amount, whatever the sentence may be in the other court, if she complies with that, she can get dismissed.
That's your right.
That is correct, Your Honor.
Spears, can you please
Yes.
raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name for the record, please.
Deborah Spears.
All right, you can put your hand down. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of embezzlement by an agent or trustee, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine can be increased if 3 times the value of the property, which is the subject matter of the theft or embezzlement. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes.
All right. Now, taking all of that in consideration, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
I did. Well, I gave permission because I'm not in Michigan, so I gave permission to Miss Apple to sign it on behalf of me.
All right. And they went through that with you, correct?
Yes.
All right. And they explained to you your trial rights, which are contained under paragraph 5?
Yes.
And you understand that you are waiving those rights as well as all the rights that are on that form?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes,
of your own free will
yes,
and because you believe that you're guilty of this offense?
yes,
January 4th, 2019, at the location of 2020 West Stadium Boulevard in the city of Ann Arbor, Washtenaw County, state of Michigan. Were you an employee of Speedway gas station?
yes. Mm-hmm.
And what did you do that makes you think that you're guilty of this offense?
I took money from Speedway without their permission.
All right. And the amount of money, and you came into possession of that money by virtue of the fact that by virtue of the fact that you were employed there, correct?
Yes,
All right. And you didn't have anybody's permission to take that money, did you?
no,
And this money, you converted this money to your own use,
yes.
meaning you spent the money.
I did.
All right. And the amount was in excess of $200, correct?
Yes, I honestly, I only know the exact amount, because you guys tell me, but yes, I believe it was more than 200.
All right. You don't have it. You're not disputing that you took more than $200.
No, no.
All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People satisfied.
You have your honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
June 17th at 9 a.m. with Judge Bell.
June 17, 2025, 9 a.m. before Judge Balbo.
Okay.
Bond will continue.
Thank you, Your
Thank
Honor.
you.
Ms. Spears, I'll be in touch, okay?
Okay, thank you. Have a
Any other messages? You know what?
great day.
All right. Thank you, Ms. Spears. I don't know.
Thank you.
I
I'm
make
sorry the Wi-Fi cut out, but thank you.
You're welcome. Court calls the case People versus Carl Tenzin. I don't know why Mackie has a cell phone.
Here to make that for the people.
Talking.
Anna Mackey on behalf of Mr. Tutson, who is approaching. Please state your name for the record.
Tenzin. Thank you.
Your Honor, I believe we'd like to set this matter for preliminary examination and all discovery is complete as far as we are aware.
People have their witnesses available on the 3rd. Preliminary examination in person, June 3rd, 2025, 9 a.m. That's before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Matthew Vermillion. Vermillion?
Assistant Public Defender Chelsea Virgil with him on behalf of Matthew Vermeulen. Please state your name for the record.
Matthew Vermillion. All right, you're requesting an adjournment.
Yes, there's some discovery yet to be received in this case, and I would ask to address a condition.
And Your Honor, I did discover you did request it yesterday. So it should-
Got it. Should be here soon. Okay. Probable cause conference will be adjourned June 5th, 2025, 9 a.m. Yes, Esteban.
Your Honor, we are asking to have the no contact order lifted. My client has been staying with his mother in Chelsea. He plans to continue doing so. We're not asking to have the no go-to order lifted. I think the concern in this case is that my client's family typically runs a business that the complaining witness may be involved in, and that business needs my client's help to continue running. That business is not anywhere near the complaining witness's home, from what I understand. He understands what consensual contact means and is committed to continue following his bond conditions. He hasn't been on bond long, but in the time he has been, there have not been any violations. I believe the complaining witness may be here to address the court today.
Your Honor, she is present today to address the court.
All right. Step back. Where is she? Ma'am, come on now.
Hello. Hi. So I own a business with Matthew's sister. and
Hold on,
he-
hold on, hold on. I know you were ready to start. You got to that line and just took off.
Sorry,
I need you to state your name.
Amy Phillips.
All right, now go ahead.
I own a business with Matthew's sister, and he's played a vital role in the business for the last 2 years. We're about to get into a really busy season. It's a canoe and kayak rental business, so I would like to ask to remove the no contact order so I can efficiently run our business.
Okay, all right. And you think that he will cooperate with a no non-consensual contact?
I do.
All right. Thank you, ma'am.
Thank you.
Any objection from the people?
This time I would object. This case comes just around on 513, and I have serious concerns with this case. It involves him going to Miss Phillips' house in the middle of the night to take her phone to go through it. She wakes up, calls 911. He comes back to the house, walks in, is screaming at her. She had her foot in a doorway. He slams the door on her foot 5 times. And then she went to call 911 again. He saw her on the phone, chased her to the back of the house and tackled her while she was on the phone 911, ripping it from her, the phone from her hands and throwing it at a wall, breaking it. I just have concerns given the facts of this case. And from that, she had a contusion on her thigh, bleeding on her foot, and on the back of her foot a cut. So I just have concerns given the facts of this case and how recently this happened, for any contact at this point. I would be objecting.
Anything else, Mr.?
I would just say that my client and I feel strongly that he is able to comply with court orders and that there wouldn't be any further criminal activity from my client, and that the bond conditions with the no contact order lifted are sufficient to protect the complaining witness who can revoke consent for that contact at any time.
I will grant the request. I will delete the no contact provision, having heard from the alleged victim in the case. I'll delete the no contact and add no non-consensual contact. So young man, you understand what that means, that if she doesn't want you in her presence, you must immediately leave.
Yes, Your Honor.
Understand that?
Yes, sir.
All right. With that added condition, bond will continue, or that adjustment.
Thank you, Your Honor.
Thank you.
Court date's on.
Court calls the case People versus Aaron Washington.
Thank you, Richard McGuffey, for the people.
First Assistant Public Defender Quinn Anderson with on behalf of Mr. Washington, who's here.
What? Where is he? Where'd she just ran out? Pass it. Yeah. Court calls the case, People versus Cynthia Weber. I pass it. I'm done. I'm done. I'm so done with you. I'm done. I'm done. Cynthia Weber. I called the next case. Cynthia Weber, come on up. Don't pay attention to these people.
It's my turn.
Your name?
Cynthia Weber.
Okay. That's yours too?
You want my name?
Is that yours? Is that yours too? I was hoping to call one that wasn't yours.
May I approach?
Oh, wow. Really?
No, not really. I just. I figured since you didn't want to see me, I was going to let you see me up close.
Yes, you can go ahead and put your.
Thank you, Your Honor. First Assistant Public Defender Kalina Anderson with and on behalf of Ms. Weber. Your Honor, Ms. Weber is in treatment. We're trying to get some treatment information and allow her an opportunity to complete. She's set to complete on June 10th, and we'll be going to residential after that. So if we can have the next available date.
After that, 10th, you want
after the 12th, because she's going to go to transitional, get set up, and then get the information. on
Then
that.
she'll have, okay.
Mhm.
So I will adjourn this to, it's actually a Tuesday, the 17th,
Okay, June 17th.
June 17th. That's at 9 a.m., 2025.
Okay, and I put my email there, but I think they already have it. Somebody sent it.
Bond will continue.
Thank you, Your Honor.
Thank you.
You're all set.
Nope, not doing it.
Can we please?
Nope. No, I'm not gonna punish you.
Washington is,
What?
but Mr. Washington is here though.
He was just right outside the door. He didn't even go far.
I know, we all heard you screaming at me.
Oh. The shade of it all. What is happening right now?
No, she has been throwing shade at everybody in your office all day.
All day.
Well, all what she did to Miss Mackey,
I'm so glad you noticed.
That hurt my feelings. Court recalls the case People versus Aaron Washington.
First Assistant Public Defender Kalita Anderson with on behalf of Mr. Washington, who's approaching.
Good afternoon, Aaron Washington. Sorry for the discrepancies.
No, you know what? You were fine. It was your attorney that was having the issue. I mean, you were just sitting out there peacefully in the hallway, and then she came out screaming at you, didn't she?
Yeah, I was.
I know. I know. It scared me too.
I disturbed his peace, Judge. I'm so sorry.
My heart dropped.
And why do I have two green forms?
Okay, so what happened?
Able to scream at me as well. The man that had me adjourned.
Oh.
I never screamed a day in my life. No, my circumstances changed for why I was adjourning, and that's why I gave you another.
Okay. So I don't know which one was the later one, but do you want 3 weeks?
Sure.
Is that what you were looking for? Or?
Do you need 3 weeks? Oh, she does not. Next available, I'll be ready.
Mr. Washington.
You know what, Judge? I should have given you a pink sheet to go with that green sheet, and then you could have kept them both in the file. Just saying.
And you know, because of my sister, I'd have to throw it out and tell you to get me a red one.
I don't want anything red.
Stop. Seriously. I can really sit down.
Right. We should change the colors of these mic lights.
That what?
That's okay. Your courtroom's beautiful, Judge. But you do have a green light here.
Washington may have to find a new attorney.
Don't leave.
The one standing next to him may be locked up in a minute.
Oh, okay. We're good.
That's okay. You can go to visitation and see her.
Keep me in good favor.
Mr. Washington's like, let me up.
Please. I almost had a heart attack in the hall.
I know, but that is not my fault.
I thought she said bench warrant or something. I'm like,
what? Right? And I had no intention of that.
Thank you. Thank you.
Right.
June 5th.
I would never say bench warrant. That's
June 5th, 2025, 9 a.m. Mr. Washington's bond will continue. Thank you, sir.
Thank you.
Did you and Bishop making the call?
No, not yet.
Oh, Miss Vicky. Yeah. Court recalls case, People versus Alante Lindsay.
Assistant Public Defender Chelsea Vergils with and on behalf of Alante Lindsay. Mr. Lindsay, please state your name.
Alante Lindsay.
Thank you. Have I been able to stop anybody all day? Come on. But Mr. Lindsay wasn't here. Did she yell at you? No. Tell me. All right. All right. Okay, we're in the Lindsay matter. Record should reflect we had a bench conference. And counsel, you wish to set for preliminary examination?
Yes, Your Honor.
And you do have all the discovery?
Yes, Your Honor.
Get it. The people have their witnesses available to the third, I'm sorry.
Yes, Your Honor, and then for discovery, I did reach out to the OIC in this case for one more piece of media, but I haven't heard back yet, but I would assume that if it is there, we would have it by the date of the.
Sure.
Preliminary examination, June 3rd, 2025, 9 a.m. That's set before me. And that'd be in person. Then Esteban.
It's come to our attention, the victim has promised that the defendant's been having third parties reach out to contact her to tell her not to come to court. I just have concerns with ask the court to want the defendant to not have third parties or anybody in contact with the victim on his behalf or contact on his own.
You understand that, Mr. Lindsay?
Yes, sir.
So part of your bond condition is that you can't have third parties contacting. It would behoove you that if you think there are third parties that think they're acting in your interest contacting, that you tell them to stop contacting.
Yes,
Because
sir.
you're the one that would bear the burden and face the penalty if something happens. Do you understand that?
Fully understand.
All right. Thank you. Bond will continue.
Thank you.
Thank you.
Court does call the case, People versus Roman Whitfield.
Defendant not carry I can really, Your Honor, on behalf of Mr. Roman Whitfield, who was approaching. Mr. Whitfield, state your name for the record, please.
Roman Whitfield. Thank you.
Judge, we are requesting an adjournment in this matter. Thank you.
What else is new with you? I'm just kidding.
We are very close to a resolution, Judge, and the people just need a little bit more time to consider our counter offer.
June 5th, 2025. 9 a.m. Bond will continue.
Yeah. Okay. Thank you, Judge.
You too. Court does call the case, People versus Aaron Wright.
Alexander, on behalf of the people, Your Honor.
And again, on behalf of Mr. Wright, approaching to my right. Wow.
Put your hands under your pockets.
Please state your name for the record.
Aaron Wright. All right, I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Yes, Your Honor.
Plea form indicates. I have no idea.
Your
What
Honor,
this
I put the offer. The plea agreement on the
Thank you.
record.
Okay, go ahead.
Your Honor, it's my understanding the defendant, we no contest, count 2 and count 1 will be dismissed. It's also my understanding that after this plea is taken, this case was accepted into mental health treatment court and will be transferred to mental health treatment court.
Hold on, that's I just right. I never said that this right. The stated count 2 is already the domestic violence, second offense.
Correct.
So he's pleading to count 2.
Yeah,
Count 1 would be dismissed.
correct, Your Honor.
Okay, I don't think I needed a plea form actually on that, but okay. May I have him sworn?
Raise your right hand. Do you solemnly swear in affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Oh my God.
State your name.
Aaron Wright.
All right, sir, it is this court's understanding that you are going to be pleading no contest to the charge of domestic violence second offense.
Yes, it is.
That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that? Is he done? That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes.
Do you understand what a no contest plea is?
Yes, sir.
All right. For 2 things about it, however, I have to make sure that you understand it. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
No.
Could you repeat that, Your Honor?
Okay. One thing that you have to understand is it means that you're not further desirous or wanting to contest this charge.
No, I'm not wanting to contest it.
Okay.
Yes.
Oh, I'm sorry.
You understand that that's what a no contest means?
Yes.
Are you having problems hearing me?
Yes.
Okay, do you need some hearing? We have.
Yes, please.
All right.
Thank you.
Thank you. Okay, is that better?
Yes.
Okay, so you understand that a no contest plea means that you're not further wanting or desirous of contesting this charge of domestic violence. You understand that?
Yes.
All right. You understand the other thing I have to make sure that you understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. Get away from my bench. All right, record should reflect that a bench conference in this case, the probable cause conference in this case will be adjourned to June 17th, 2025. 9 a.m. bond continue.
Thank you, Your Honor.
Thank you. Thank you. Your Honor. Thank you. Court does call the case of the people versus Carlos Payne.
And then on behalf of the people, Your Honor.
Assistant Public Defender Chelsea Vergil Smith, and on behalf of Carlos Payne, who appears via Zoom, Mr. Payne, please state your name.
Carlos Payne.
You got him.
Your Honor, we are asking to set a preliminary exam in these cases, and I would ask to address his bond conditions.
All right, so discovery is complete in both matters?
To the best of my knowledge, it is, Your Honor.
All right. People in these cases have their witnesses available the third. Okay, in these matters, preliminary examination will be set June 3rd, 2025, 9 a.m. before Judge Perry. As to bond.
Your Honor, we are asking the court to consider allowing him to remove his GPS tether, of course, keeping the no contact and no go-to orders in place. He's been on the tether a few weeks now with no violations. He lives in a separate city from the complaining witness, with him living in Detroit and her living in Ypsilanti. He does work full-time. He shares a child with the complaining witness, but I spoke with him about how he can meet with her or meet with a third party to exchange the child if necessary. For financial and just general comfort reasons, he's asking to have the GPS tether removed, as well as he's got a physical job. It does get in the way. Again, full-time, working, no violations. We ask you to consider removing his tether.
Is there any response from the people?
Your Honor, we would object to removal of the tether, given the facts of these cases. They're very serious. One of the cases in GBH in which he was dropping off belongings for the child. After dropping off these belongings, he came at the victim, got in her face, they went upstairs. He was stating he was going to kill her and her mom, and then punched her in the head. He then got behind her, was strangling her from behind with a headlock and slammed her to the ground. And then in the other case, he threatens her with a knife and a gun, saying that he would shoot her through the door. So I have great concerns with the safety and would ask the tether remain here.
Your Honor denies the allegations, but for that he can comply with bond conditions so far, believe that would change simply due to the tether removal. He understands the risk of being brought back into custody if he were to violate.
Motion for bond reduction or bond modification is denied. GPS tether will continue in place, and certainly feel free after the exam to bring that up for Judge Perry. I'm going to deny it at this time. Thank you. Court calls the case People versus Taiwan Felon.
Representative people.
Bangladesh on behalf of Mr. Taiwan Phelan.
Phelan.
Um,
State your name.
I just realized.
Taiwan Phelan. Phelan. I remember from the last time.
Oh, I already have one. Sorry about that. I'm not doing well today. Your Honor, we were going to be requesting an adjournment to continue plea negotiations with the prosecution. I can't believe I forgot the green sheet, but
I don't know. You said you had one and then you didn't have one.
There you go.
What are you talking about? I just. Cards conference will be adjourned June 5th, 2025, 9 a.m. or as your invite indicates. Bond will continue. Thank you. Court calls case People versus Austin Lee Ray.
Good afternoon, Your Honor. Chief Assistant Prosecutor Victoria Burt here is here on behalf of the people.
Hannah Mackey on behalf of Mr. Ray. Your Honor, we've been trying to get a hold of Mr. Ray. We have not been successful. I've reached out to his CMH worker who has also been trying to reach out to him. So we respectfully request an adjournment to see if we can find him.
He also has a violation, community corrections violation report.
He does. He has failed to report to community corrections. I think the problem is, Judge, no one has heard from him or seen him, and he's done nothing in order to do.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls case People versus Joanna Reed.
Assistant Public Defender Jay Bellinger on behalf of Ms. Reed, who approaches, Your Honor.
Your name, please?
Johanna Reed.
And you're requesting forensic referrals.
We are, Your Honor. I have submitted that to the court for its signature, and I would also ask to address a condition of her bond when appropriate.
Forensic evaluations are ordered. I'll set a competency hearing for 90.
August 14th.
August 14th, 2025. 9 a.m.
Thank you, Your Honor.
Esteban.
Esteban, Your Honor, my client is requesting that she not have to drug test anymore. I know that that is generally a basic condition upon. However, the allegations in this incident don't prescribe to the fact that she was using, there's no allegation that she was using drugs or alcohol. This is a case, Your Honor, that I have submitted for competency, certainly. But with regard to the drug testing itself, my client simply can't afford to do it. She does not want to get a bond violation for her inability to afford it. So we would ask that the drug testing cease at this time.
Response.
Your Honor, the people actually don't have an objection. I don't have any information to indicate that Ms. Reed has ever had a substance use problem. She was recently petitioned a month or two ago and is currently undergoing by court order. And so, Your Honor, at this time, I don't see that.
I'm trying to see what was the original. You say she's drug testing off of this case?
That is my understanding, Your Honor, based on my
Does
conversation.
she have any other matters pending? No?
Not that people know of, Your Honor.
Being asked for the drug test right now?
Every week.
Every week?
Ma'am, do you have any other cases pending?
I think so.
Your Honor, she advises she's being asked to drug test once a week on this case.
Your Honor, I'm wrong. She does have another case. She does have another case.
Oh, not one Oh, okay.
OWI out of 15th?
I
I
apologize.
don't have a drug testing order.
Your Honor, I apologize. That was something that I wasn't.
Hey, no, I'm used to you wasting my time. So I can't.
Understood, Your Honor.
No, I got you. So August 14th, 2025, 9 a.m. Bond will continue. All right, thank you.
You can't do anything about the testimony. I have to ask the 15th district court to do that.
Nothing. Court calls the case People versus Deborah Spears.
Hannah Mackey.
People.
Hannah Mackey on behalf of Ms. Spears, who is on Zoom, I believe.
Ms. Spears? You try.
I am.
Good morning. Can you hear me?
There she is.
I'm sorry. I'm not sure what's going on with the Zoom.
Oh, okay. Ma'am, how do I spell your last name?
Spears.
Okay, we'll need to amend the complaint. The spelling of her name, I think off of the complaint is EERS.
Yeah,
Just
it
double
is.
check. Yeah, I think, well, actually, there's an AKA that covers it. That's why. It's EERS, and then there's an AKA also known as with the last name spelled EEARS. So I think we're good. All right. In this case, I have before me a plea form that indicates the defendant is going to be pleading guilty by to the offense of embezzlement by an agent or trustee, 200 to 1,000. The 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. There is further an indication that the defendant must pay $1,170 restitution in full to Speedway to comply with all other conditions of probation of the court sentence to receive the dismissal of count 2 via prosecutor's deferred. Okay, that's a lot, but okay.
That's the correct signature on.
So I guess I'm trying to figure out what's going to happen if.
Yes, Your Honor, I can clarify. There was previously discussion of a resolution in this case with prepayment of restitution. When this was pending back in 2023, Ms. Spears had not been able to make those payments at the time, and then she was out for a while on the bench warrant. So we decided to resolve it in a way that will have her commit to paying that amount rather than a prepayment, so that they'll end up in the same sort of cycle. I did also add prosecutors deferred to that offer as well. So if she does repay that amount, whatever the sentence may be in the other court, if she complies with that, she can get dismissed.
That's your right.
That is correct, Your Honor.
Ms. Spears, can you please
Yes.
raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name for the record, please.
Deborah Spears.
All right, you can put your hand down. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of embezzlement by an agent or trustee, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court. The fine can be increased if 3 times the value of the property, which is the subject matter of the theft or embezzlement. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that? You tell them to stop contacting.
Yes,
because
sir.
you're the one that would bear the burden and face the penalty. In the Lindsley matter, record should reflect we had a bench conference. And counsel, you wish to set for a preliminary examination?
Yes, Your Honor.
And you do have all the discovery.
Yes, Your Honor.
Get it. The people have their witnesses available to the 3rd. I'm sorry.
Yes, Your Honor, and as for discovery, I did reach out to the OIC in this case for one more piece of media, but I haven't heard back yet, but I would assume that if it is there, we would have it by the date of the exam.
Sure. Preliminary examination, June 3rd, 2025, 9 a.m. That's set before me. And that'd be in person. Then as to bond.
It's come to our attention, the victim informed us that the defendant's been having third parties reach out to contact her to tell her not to come to court. I just have concerns with as the court 2 months and it's not have third party. Is there anybody in contact with the victim on his behalf or contact?
You understand that, Mr. Lindsay? Yes, sir. So part of your bond condition is that you can't have third parties contacting. It would behoove you that if you think there are third parties that think they're acting in your interest contacting, that you tell them to stop contacting.
Yes, sir.
Because you're the one that would bear the burden and face the penalty if something happens. Do you understand that?
Fully understand.
All right. Thank you. Bond will continue.
Thank you.
Thank you.
Court does call the case, People versus Roman Whitfield.
Public defender, not carry I can really, Your Honor, on behalf of Mr. Roman Whitfield, who is approaching. Mr. Whitfield, state your name for the record, please.
Roman Whitfield. Thank you.
Judge, we are requesting an adjournment in this matter. Thank you.
What else is new with you? I'm just kidding.
We are very close to a resolution, Judge, and the people just need a little bit more time to consider our counter offer.
June 5th, 2025. Bond will continue.
Yeah. Okay. Thank you, Judge.
You too. Court does call the case, People versus Aaron Wright.
And then on behalf of the people, Your Honor.
And again, on behalf of Mr. Wright. Approaching to my right. Wow.
Please put your hands out of your pockets.
Please state your name for the record.
Aaron Wright. All right, I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Yes, Your Honor.
Plea form indicates. I have no idea.
Your
What
Honor,
this
I
is.
put the offer. The plea agreement on the
Thank you.
record.
Okay, go ahead.
Your Honor, it's my understanding the defendant, we plead no contest on count 2 and count 1 will be dismissed. It's also my understanding that after this plea is taken, this case was accepted into mental health treatment court or will be transferred to mental health treatment court.
Hold on, that's just right. I've never seen it done this way. The stated count 2 is already the domestic violence, second offense.
Correct.
So he's pleading to count 2,
Yeah,
count 1 would be dismissed.
correct, Your Honor.
Okay, I don't think I needed a plea form actually on that, but okay. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Oh my God.
State your name.
Aaron Wright.
All right, sir, it is this court's understanding that you are going to be pleading no contest to the charge of domestic violence second offense.
Yes, it is.
That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that? Is he done? That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes.
Do you understand what a no contest plea is?
Yes, sir.
All right. For 2 things about it, however, I have to make sure that you understand it. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
No.
Could you repeat that, Your Honor?
Okay. One thing that you have to understand is it means that you're not further desirous or wanting to contest this charge.
No, I'm not wanting to contest it.
Okay.
Yes.
Oh, I'm sorry.
You understand that that's what a no contest means. Are
Yes.
you having problems hearing me?
Yes.
Okay. Do you need some hearing? We have.
Yes, please.
All right.
Thank you.
Thank you. Okay, is that better?
Yes.
Okay, so you understand that a no contest plea means that you're not further wanting or desirous of contesting this charge of domestic violence. You understand that?
Yes.
All right. You understand the other thing I have to make sure that you understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. Get away from my bench.
Sorry, Your Honor.
You understand that, sir?
Yes, sir.
Not to get away from the bench, the part about that it means that the court is going to treat you the same as though you had pled guilty to this.
Yes, sir.
All right. Do you have any other questions regarding the no contest plea?
No, sir.
All right. Basis for the no contest plea?
Civil liability, Your Honor.
All right. So, sir, to that charge, how do you plead?
No contest.
All right. Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
One thing that I did forget to advise you of, sir, you understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes, sir.
And you still wish the court to take a no contest plea?
Yes, sir.
All right. Court has been provided and has reviewed Ypsilanti Police Department report for their case number 22-13159. Any objection to the court having reviewed that report?
And Your Honor.
Based upon the court's review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
You have, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
June 18th at 10 a.m. Judge Barr.
Your Honor, I believe there is a sentencing scheduled already for Mr. Wright in 15th District. I think it's on the 6th of the 4th, 6/4.
That was one of the things that they were doing in the mental health court.
Yes.
Okay. Remember what?
I could.
Somebody's gonna have to get that straight. So what I'm gonna do is what time do you think it's set?
It's set at 1.
6/4, we believe the date.
At 1 o'clock time, he said.
I don't know what time, did they give us a?
We have no information in JIS.
They were awaiting for this plea to happen. before-
Right, but they don't give us so when they're happening here, they're causing more confusion by doing that because usually it would go to the underlying jurisdiction court and then they send it over. Right, so here's what I'm gonna do. What time was the 18th?
10 a.m.
10 a.m. I'm gonna set his sentencing for June 18th, 2025 at 10 a.m. before Judge Barr. If you guys arrange, however you arrange that it go over to 15 prior to that time, I'm not gonna have a problem, but the only date I have is that. Okay,
Okay. Thank you, Your Honor.
thank you. This bond will continue. Thank you, sir.
Thank you.
That's it for that block? All right, court's gonna stand in recess.
All rise.
Court does call the case of the People versus Alan Payne.
Right here. Mr. Childers, okay?
All right. I have before me a plea form, and the plea form indicates that the defendant will be pleading guilty to the offense of OW second, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement.
Andrew Tillman declaring on behalf of the people, that is correct, Your Honor.
Joe Simon on behalf of Mr. Payne, that's correct. He filled out a fresh advice of rights and a sentencing judge waiver.
Adam sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name.
Alan Payne.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense.
Yes, Your Honor.
That is a misdemeanor punishable by up to 1 year incarceration, $1,000 fine plus court costs. The court could also order community service and any rehabilitative services the court deems necessary. Court order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court.
Yes, Your Honor.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to the charge of operating while intoxicated, second offense, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed any place of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty?
Yes, Your Honor.
June 29, 2024, at the location of 39 East Michigan Avenue in the city of Ypsilanti, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
All right. Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
Do you recall what you had and how much?
Scotch and, sorry to say, I don't know how much.
All right. Were you stopped by the police or did the police arrive at your stop vehicle?
A wellness check, Your Honor.
A wellness check. All right. And were you ultimately arrested after
Yes,
that?
Your Honor.
All right. Were you taken to the hospital?
Yes, Your Honor.
Or was there a blood draw?
Yes, Your Honor.
And what were the results of that blood draw?
0.161.
161?
Yes, Your Honor.
Do you have any reason to dispute those blood test results?
No, Your Honor.
All right. And had you, previous to this time, been convicted of operating while impaired on or about December 22nd, 1983 in the 2A District Court and or of operating while intoxicated on or about September 9th, 1995 in the 2A District Court and or convicted of operating while impaired on or about June 26, 2004 in the 15th District Court?
Yes, Your Honor.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report and screening and assessment is ordered at 1482 District Court. Sentencing in this matter will be
June 25th at 10 a.m. with Judge Barr.
June 25th, 2025,
10 a.m.
10 a.m.
I'm gonna have to move that
before Judge Barr.
on that date.
Bond with its conditions will continue.
Thank you, Your Honor.
Thank you.
And
Court does call the case of the people versus Kathy Johnson.
Ready, Your Honor. A.K. Richmond, Justice for the people.
Good afternoon, Your Honor. My name is Tim Hensick. I appear on behalf of Ms. Johnson, who's standing to my right.
All right. Can you state your name, ma'am?
Kathy Renee Johnson.
All right. Thank you. What are we doing?
Your Honor, my understanding is that after Ms. Johnson was referred to the 14B recovery court, that is underway. I think she has been interviewed, but they still have a few more steps to go regarding some, I think, assessments or something like that. So counsel may be needing a few more weeks.
Your Honor, that's correct. It's my understanding.
That there's more time needed to do the, all right. Well, take 2 weeks or 3 weeks?
3 weeks, Your Honor.
Probable cause conference will be adjourned to June 12th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond will continue with its conditions. Thank you.
Thanks.
Court calls the case People versus William Doster.
Good afternoon, Your Honor. Dan Garrett on behalf of Mr. Doster.
Sir, can you please state your name? You'll need to unmute Mr. Doster.
Apologies. William Doster.
All right, thank you. Okay, what are we doing today?
Your Honor, I've had a lot of conversations now with Ms. Reiser, who's taken over the case. I think both sides agree we need one last probable cause conference, and we should be able to resolve or waive on that date.
All right. And how much more time did we need?
3 weeks, please, Your Honor.
3 weeks. All right. June 12th, 2025. A.M. as your invite indicates, bond will continue with its conditions.
Thank you, Your Honor.
Thank you. Oh, hold on. No, it's okay.
She said preferably not week of June 16th, so.
That would be the following. That's okay. It's Kennedy's calendar. It's all out of whack. All right. Thank you.
Thank you.
Court calls the case People versus Jeremy Vermeulen.
A.P.A. Richard McDonough for the people standing in the.
Good afternoon, Your Honor. Lawrence H. Margolis with and on behalf of Jeremy Vermeulen. Jeremy, please state your name for the court.
Good afternoon. My name is Jeremy Vermeulen.
Judge, today is the date and time set for PCC. I have worked with Ms. Harris, Burton Harris, on this matter, and we are prepared to move forward with the plea. There was a sentence agreement. I know Your Honor doesn't always like to do the sentencing in these matters.
I'm not doing the sentencing.
Understood.
So
we filled out the paperwork in case Your Honor wanted to, but I have been advised that you would not be doing that.
What are the maximum penalty? I have that he's obtaining a firearm in violation of MCL 2842 by false statement. He's going to plead guilty to that, but I don't.
So
I don't have the maximum.
So under 232A, the PAC code is 750.232A. It's a 90-day misdemeanor or a fine of not more than $100 or both. And the basis is the failure to register the firearm.
I'm sorry, Councilman, Your Honor. I'm noticing that the plea that. Okay, I'm sorry. I wanted to ensure that was a hyper misdemeanor.
That was concerned.
Okay, we're good. I'm sorry. My apologies.
That was the added.
Does the court need the maximum penalty for? I can look these up really quick.
750-232A. Stated it, but it's not on the plea form.
I can approach if Your Honor would like to look at the statute.
You can show it to her. If everybody's in agreement, just give it to me.
Looks like that is a 90-day misdemeanor with a $100 fine, Your Honor.
I haven't sworn. That's fine. I don't need that. That's what it is.
You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Jeremy Vermeulen.
Sir, it is the court's understanding that you are going to be pleading guilty to the charge of obtaining a firearm in violation of Michigan statutes by intentionally making a false statement. Is that correct?
Yes, Your Honor.
That is a misdemeanor punishable by up to 90 days incarceration, $100 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes, Your Honor.
All right. Understanding all of that, you sure wish to plead guilty.
Yes, Your Honor.
To that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights in there.
Yes, Your Honor.
You understand you're giving up your right to upright.
Yes, Your Honor.
Are you on probation or parole?
No, sir.
Anybody promise you anything other than what's been stated here today on the record?
No, Your Honor.
Anybody threaten you or coerce?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
As soon as I can find my plea form. Oh. On the date, March 13, 2025. I think it's supposed to in the street. Washington Avenue. Eastern Michigan campus. What'd you do that makes you
Possession, unregistered. Possession with unregistered firearm.
all right? So you failed to register your firearm.
Yes, Your Honor.
Got it. And you had possession of that?
Yes, Your Honor.
All right, so and you knew it was not registered, is that
Yes,
correct?
sir.
All right, so taking the plea to the higher offense for this lower offense, counsel, have I complied with the court ruling?
You have, Judge.
Accept this defendant's plea.
Yes, Judge.
Court will accept the defendant's plea of guilty to count 3, counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
June 25th at 10 a.m. for Judge Barr.
June 25th, 2025, 10 a.m. before Judge Barr. Bond in this case will continue with its conditions.
Thank you, Judge.
Your Honor.
Thank you for work. Court does call the case People versus Nyland Mitchell.
Good afternoon, Your Honor. Lawrence H. Margolis, standing in for attorney of record Ivan Land on behalf of Mr. Mitchell. Please state your name, sir.
Nyla Mitchell. How you
Do you
doing?
have any issue with Mr. Margolis standing in for your counsel record?
No.
Okay, all right, what are we doing?
I was advised that Mr. Land would like this set for an exam. I believe, he has spoken with the people's representative. June 17th was the day that he had asked me to request.
So what? I'm gonna set the exam.
Yes,
So,
I'm just advising what you advised me. Judge.
okay, well, I've shot the messenger before.
Perfect.
So all discovery to your knowledge is complete?
I believe so, yes.
This is gonna be set on the 3rd. I don't understand why. So that's the date it's gonna be set.
Is that June 3rd, Judge?
Will the people have their witnesses available that day?
Your Honor, we'll do our best.
Pardon?
I said we'll do our best.
All right. Preliminary examination in this matter. Person will be set June 3rd, 2025, 9 a.m. That is before Judge Perry. Bond will continue.
Thank you, Judge.
Court calls the case of the People versus Jason Thomas.
Lawrence Margolis on behalf of David Goldstein for Mr. Thomas. Jason, please state your name for the court.
Jason Thomas.
Do you have any objection to Mr. Margolis stepping in for your counsel of record?
No, sir.
All right, thank you. What are we doing?
I'm sorry, I think we're too for.
We would like a 1-week adjournment, and Mr. Goldstein believes they can get it done of the PCC, adjournment of the PCC, if Your Honor is inclined.
1 week or 2?
He asked for 1. The court obviously can choose.
Probable cause conference will be adjourned. I don't think he's available that following, if I'm recalling.
Mr. Goldstein is scheduled for an exam that same week. He did mention his availability next week, so I'm going to assume it is one.
May 29th,
Thank you, Judge.
2025, 9 a.m. Bond will continue.
Thank you.
Case of the People versus Jeffrey McCullough.
Andrew Childers appearing on behalf of the people.
Christopher Quinn appearing on behalf of Mr. McCullough.
Good afternoon.
Jeff McCullough, Your Honor.
Thank you, sir. All right, what are we doing?
McCullough is requesting an exam, Judge.
All right. All discoveries complete, counsel?
Yes, Judge.
People have their witnesses available on the 3rd.
That's fine.
Preliminary examination in person, June 3rd, 2025, 9 a.m. before Judge Perry.
All right, thank you, Judge.
Thank you. Bond continue. Court calls case of the people versus Matthew Newton.
Jeremy Glick appearing with and on behalf of Mr. Matthew Newton, who's standing at my right. Can you state your name?
Matthew Newton, Your Honor.
Thank you.
And Your Honor, we'd be asking for a 3-week adjournment so we can deal with an application to sobriety court in this matter and continue plea negotiations with the prosecutor.
All right. You corrected any issues you had with the sober link and making sure you're tested?
Yes, I have, yes, Your Honor.
You said 3 weeks, counsel.
Yes, Your Honor.
June 12th. Double cause conference adjourned June 12th, 2025, 9 a.m. Or as your invite indicates, bond will be with its conditions.
Thank you, Your Honor.
Court does call the case people versus Michael Williams.
Good afternoon, Your Honor. May it please this honorable court, David Burgess on behalf of Michael Williams, who's approaching.
Your name, sir?
Michael Williams.
Thank you.
Your Honor, today's date and time set for probable cause conference in this matter. I've spoken to my client regarding his right to an exam in this case. He's choosing to voluntarily waive his exam and have his case bound over to circuit court for further proceedings.
Is that correct, sir?
Yes, sir.
And you understand that at the preliminary examination, that's a proceeding where people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that here and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on counts 1 through 4.
Waive formal reading of the information, stand mute as the charges contained within, Your Honor.
Defendant every waive formal reading, standing mute. Court will enter a not guilty plea. Pre-trial will be set for
July 16th at 1:30 p.m.
July 16th, 2025, 1:30, Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue.
Thank you, sir.
Thank you.
Yep.
Court does call the case of the people versus Cyrus Abadi.
And good afternoon, Your Honor. Uwe Daus with and on behalf of Mr. Abadi, standing to my right. Cyrus, please state your name for the court.
Good afternoon, Your Honor. Cyrus Abadi here.
We're looking for a green sheet adjournment of 3 weeks for additional discovery.
Any objection?
No objection, Your Honor. I also do have some additions to the
Probable cause conference will be adjourned June 12th, 2025, 9 a.m. Yes, Esteban.
Your Honor, there are a few addresses that I need to add to the protective conditions. These are addresses that the victim in the case will need to regularly be at for her employment. So I don't know if the court would like to appropriately give those addresses or.
What, is he on a tether? With exclusion zones? Is that what we have?
Yes.
Yes, we have exclusion zones, Your Honor, and it's actually a longer list of addresses, but those other addresses fall within the exclusion zone, so they don't need to be mentioned. These are addresses that are outside of the exclusion zones.
Okay, so here's how I'm gonna do it, because is the defendant aware of these addresses or?
I gave them to Mr. Dowse this afternoon. And we had some back and forth about them. My understanding, my question was, will these addresses be a problem for the defendant not to go to? I believe the answer is no. And Mr. Dowse can fill you in on the details of our conversation. But I think his concern may be related to making sure that there's not further exclusion around those specific addresses. But he may be okay with a no go to those addresses, but he doesn't want the exclusion zone to be expanded. I'm gonna leave that up to the court. My two objectives here are, one, I want the victim to be safe. This is part of her employment. It's already a bond condition. We want to make sure that the defendant is on notice and is aware of the addresses, so we don't have any issues with them running into each other. So it's really for her protection, but also the specific addresses we're looking at.
Okay. May I respond? And if the court needed to, I did bring the exclusion zone map with me if there was any need to look at those. What Ms. Tanner says is right. We, as far as any of these addresses, Mr. Abadi has no purpose, no reason to go to any of these addresses. And we don't have a problem with those being no go-to addresses. However, we don't want every one of these to become another half-mile exclusion zone, because if you add those up on the map, ever larger parts of the city will become inaccessible to him. For one, he could not get straight from his home to our office if that was done. So adding those as no go-to addresses is not a problem. I would not want each of those to be an exclusion zone. Like there is around.
But it would be an exclusion zone. I guess I don't see what the problem is.
It's a difference not to go to a particular address at a particular street corner and not be there.
Difference, but I don't understand what the problem is. If there has to be a provision that would allow him to get to your law offices, that provision can be made.
But these are altogether 1, 2, 3, 4, I understand, 5 or 6 addresses. Each of those is gonna essentially take up a half-mile radius of the city that he can then no longer traverse, even go through, go past. That's the issue. Not going there, not an issue, but being excluded from ever larger parts of the city is.
But if he were not already on an exclusion zone tether, I could potentially see your argument. But if these are addresses that are addresses of employment, they would become subject to the exclusion zone.
Well, if that's the court's position, then so be it, but I make my argument.
All right. So typically how those would then be added is, so that we don't put them on the record, is that community corrections would be contacted with those addresses. What my order will read is that additional addresses as supplied by the prosecutor are to be included in the exclusion.
You're gonna have to forward those to them. I've already provided them.
All right. Anything else on this case?
No, not today.
All right, we'll continue. Yes.
Sure.
Just a second. Court does call the case People versus Molly Fox.
Good afternoon, Your Honor. Ellen Dennis, appearing on behalf of Molly Fox.
Okay. What, Mr. We may have an issue. Go ahead. What are we doing on this? I am.
So the court received bond.
Oh,
Have you seen it, counsel?
yes, Your Honor, I have seen it.
She's positive for cocaine.
Right. Your Honor, when the bond was set, I wasn't actually present when the bond was set, but at that point, I think they all agreed that her major problem was that alcohol. That was why she entered a recovery program through community corrections. And she's also been attending AA. Now, she's not been positive for, as I understand it, she's not been positive for alcohol use since that time. This cocaine use is kind of, I don't know, an anomaly. And it seems from my discussion with my client, it's kind of situational, and she realizes that this is absolutely unacceptable.
She had another anomaly back in March.
Right, I understand. But what I mean is, it's not, unlike the alcohol, it was not the dominant problem. And yet it is a problem, of course, but it stems, I'm told, from a friendship that she has with somebody that she's had for many, many years. And apparently this other person got into cocaine use, and she would sometimes participate when she was with that person. She realizes she has to break off all contact with this friend because it's apparently evolved into a relationship in which cocaine is customarily used. So we would ask, of course, that bond be continued, and if court thought it was appropriate, she could be put on a tether. She has been going to, she had 8 weeks of first phase recovery program, and she'd started the second phase prior to this cocaine use. And she also has been going to AA once a week in addition. So the recovery program, I guess I would have to say, has been partially successful. And we would like to have an opportunity for her to continue to work on her recovery through that. And I know Mr. Kennedy and I have talked about possibility of resolving the case through recovery court, but he's not sure that she's eligible. And I've been waiting to find out if that's true, because that might very well be a good resolution. So, and in the meantime, I mean, she is the caregiver for three minor children, ages 10 and 5. They're all her children. And her significant other with whom she lives, he works full time for one of the car companies, I forget which, for Ford, and is gone in the daytime. So caring for the children, especially when school gets out, which will be pretty soon now, would be very difficult without her presence. But so of course, we're asking for bond to be continued or possibly be modified to have provide for her to have an alcohol drug tether. I might also say, I think that she entered the recovery program was not a bond condition. Is that correct? It wasn't. She says it was not. So she is she's attempting to do recovery on her own, but of course, community corrections made it possible for her.
Violation with cocaine.
I'm sorry?
This is her third violation with cocaine.
Apparently so.
Yeah, that's a problem.
It is a problem, and but I think a tether would definitely take care of that problem.
I don't have a tether that reads cocaine.
Well, that's what I wasn't sure when she suggested it, whether that was feasible. She seemed to think it was, but I don't know.
She who?
My client.
Of course. She's going to tell you that, and then she's going to go out and use cocaine.
Well, maybe she just doesn't know. I didn't know.
She does what drug addicts do, and they tell you something that's not true.
Well, I don't know that she's truly an addict because her use has not been that frequent. But at any rate, I totally agree with the court that she can't be using cocaine, and I think she also agrees, and she understands.
At what point did that dawn on her?
I'm sorry?
At what point did that dawn on her? When we ordered that she couldn't use illegal drugs? In January when she tested positive? In March when she tested positive? Or this time when she tested positive? Which point did she also figure out she can't use it?
Well, she should have figured it out beforehand, Your Honor, but she now tells me she has figured it out, I guess you could say.
I always hate asking, but I'll ask why not. I'll bite. What this time made her figure it out?
Well, maybe she's come to a realization that it's not a good thing for her. I mean, she's brought it up in the group sessions that she's had, these weekly group sessions, and I think they've convinced her that she has to cease her friendship with her old friend because obviously it's not a friendship that's furthering her best interests. And she tells me that she's going to do that. So I think I hope that she has come to the realization of how damaging to herself that this is.
I'm going to adjourn the probable cause conference in this case to June 5th, 2025, 9 a.m. Because of her violation, defendant's bond is revoked, defendant is remanded.
Thank you, Your Honor. That's it for me today, Your Honor.
Thank you.
Yeah.
Happy birthday.
Thank you.
Court calls the case, People versus Jerome Burns. Well, he's in back, right? So we might have to wait. Oh, no, there he is.
And this is public information not to clear half of Mr. James Burns. Mr. Burns, say your name for the record, please.
Jerome Robert Burns.
The people's motion, this was discussed this morning regarding access to the premises.
Yes, Your Honor, I did, send out a motion to start in the since the council and I have been speaking. It's my understanding that the apartment, is actually leased to defendant's father and, I believe his mother potentially. I don't believe the victim is on that lease, even though that was her home and that was her residence. But I wanted to forward that information to the court. I don't believe that we are in a position where we can ask, for her to be able to stay in that residence since she's not on the lease and it is the defendant's father who is.
Well, I think we're absolutely in that position. I mean, that would occur, that occurs all the time. Well, and the problem that I have with not being able to do it, or at least forcing it to happen, is that you would have individuals that may be potentially victims of, in a domestic violence situation, where the leased premises, which is their home, is leased. Can't go back there, and they didn't do anything to be sort of on the outs.
Judge, if I may, I think there's a little bit more information that the court should have. My understanding, my client's father is here present, and he was the one that was able to update us on what was happening. The apartment is leased to him and his wife. That has been their home for the past 9 years.
Whose home?
Father and mother, not defendant and complaining witness.
Okay.
Yes, so it's leased to them, but that's their home. And my client and his wife were living with them at the time. They still live in the home currently.
Okay.
And my understanding as well, and it states it in the report, before this incident even occurred, the complaining witness had left the home. She had already moved out of the home. I know that the original allegation or issue was that there was the locks in the home were changed.
Yes, that's what I heard.
That is correct.
I set the hearing.
I spoke with Dad about that, and Dad said, yes, I did change the locks because she had since moved out the home probably about a month before then. And later he found out that the complaining witness was entering the home with the keys that she did have while he wasn't home, moving things around. And he stated that he felt it was necessary to change the locks because she was no longer living there.
Your Honor, my understanding is that the victim left because of the physical abuse and fear by the defendant. So she left and sought a safe place for her and the child. So that part's true. My understanding is the same, that she left, however, under those conditions, and I think that is an important addition. But going back to why I don't believe we cannot exclude defendant's father from a place. Right. Of course. So in regards to that matter, we'll just ask for there to be a civil standby so she still has belongings there. I of course ask that none of her belongings be touched by the defendant's family and that they cooperate with law enforcement to allow her to come and retrieve those. There's also a matter of the vehicle. So at this point, the concern I have for this victim, and more so for the child, quite frank, that this child has very serious medical needs. This sexual assault took place at Mott's Children's Hospital. While their child was in the hospital, defendant sexually assaulted the victim. This victim is in fear of the defendant. She, as far as I know, does not have a home to go to. She, as far as I know, does not have a vehicle for transportation. And we're not just talking about going to get groceries. She has a child who has serious medical needs. And so it's concerning to me that she is not able to take that child where that child needs to go for medical needs and other basic necessities. So she's, of course, in a very, very bad situation. The two of them are married. There is a car that is, from what I understand, just sitting there, and there are car keys that go to that car. Counsel and I have been speaking throughout the day, and I thought we had an agreement that the victim could use the car since it's just sitting there, and she desperately needs it for their they have in common to be able to do what she needs to do for that child. Since then, I've learned that the defendant is not agreeing to that. My understanding is that he has some concerns about the condition of the car. And I'll let Ms. Akuri speak to that. But again, my more immediate concern is this child right now. I'm not suggesting we should talk about the ownership of the car, but I don't understand why this victim cannot have access to their joint car to transport the child if she needs to.
And Your Honor, I did have an opportunity to speak with my client. Initially, the client's father, again, was the one who was able to facilitate. He did inform me where the vehicle is, that there are keys to the vehicle. And speaking, he doesn't have permission to give them over, obviously. I spoke with my client. He reports that there is front end, it's not damage, but there are front end issues with the vehicle. It's a work truck. It's a very large truck. It's a Chevy equivalent to, I think, a Ford 350. It doesn't have any of the additional enhancements, but he said it's a very large truck. All of his work stuff is in there. He's concerned.
His work, dad's or?
My client, Your Honor. This is his vehicle. He reports that this vehicle was his prior to. He does not feel that it's safe. Marriage, I apologize, because the people indicated that this is like joint marital property or something to that effect. But this is a work van or truck that he has been using for his construction business. I do not think when she left the home, she left without the truck, Judge. The truck has only become an issue now. And I don't really understand how, if there is an emergency, the truck would really be of any help, because I think 911 would be the more plausible way to go if there's a medical emergency with the sick child. Back to the truck though, Judge. The truck, we don't know.
I guess I don't get this. I mean, I'll let you finish. But these are two people, married and or not married, who have a child together.
Correct.
That has special needs and may require medical care.
Mm-hmm.
For whatever reason, the big people don't get along now. And what I'm hearing you say is that as a father, I'm not going to make sure that the other caregiver of this child at least has some ability to get the child where it needs to go. That's what I'm hearing you say.
That's not necessarily what we're saying, Judge. I think that my client, again, with the mechanical issues with the vehicle, he indicated that it's not safe for her to drive. So it's not the safest vehicle to turn to if you needed anything in regards to transportation. And also, if he was in the process of getting the condition or the issue of the car fixed, and he hasn't been able to do that. So it's possible that driving it any further would possibly make it, put the car in a worse condition mechanically. What else to do?
So, Your Honor, if I may.
Yeah.
I'm not here to argue the condition of the car, just I understand it's all coming to the defendant. Again, and I want to be very clear that the victim has not asked for access to the car. I reviewed the case. I found that she does not have any transportation. And based on my experience, that is concerning to me when there is a sick child. How that car may be affected, potentially or not, by her driving it to provide for this sick child doesn't really matter. That is not what matters here today. This is an urgent situation. It's bad enough that she is homeless because of the physical assault she endured while having a sick child, the least we can do is give her access to the car for those purposes, and then they can work it out later. I'm not worried about whatever's going on between the two of them. She needs to be able to have some transportation. She has a small child that is sick, and she needs some help.
And Your Honor, my client, he did raise his hand. He just wants the court to understand that he's not trying to keep the vehicle from them. He says it's not a safe car to, that normally when the child has appointments, the state provides transportation for the child to get to and from his appointments. He has indicated to me that he has transported the child in their vehicle previously, but the wife does not normally drive that vehicle. It's not a vehicle that she's used to driving. She doesn't drive it normally. It's his work truck. And aside from—
So she's incapable of handling what would be—
No, I don't know. I don't know if she's licensed. I don't know if she's insured on that vehicle. I don't know. She's not. They're just—
Not insured?
She's not insured on the vehicle, Judge, according to what my client just told me.
How does that happen?
It's a joint insurance. So if I would have added her to the insurance, then she'd be able to legally drive that vehicle. If she's not added to the insurance, she legally cannot drive that vehicle.
That's not what he's asking you. Why did he?
Your wife?
Do it.
Why did he
Really?
insure her in the vehicle?
And it cost way too much money having her insured on that vehicle.
And that's my understanding, Your Honor.
Was there a vehicle she was insured on?
When her dad had a vehicle for her, she was insured on that and had received a—
Where's that vehicle, man?
That was 7 years ago, sir.
And that's—
So for 7 years, she hasn't been able to drive?
She's able to drive. She just hasn't, she chose not to.
And that's kind of what Dad told me, Your Honor. Dad just says he doesn't really know her to drive. She's not one that drives normally. She's usually at the house, or they use the transportation provided by the state whenever they needed to take the child to the vehicle. Other than that, my client was the one who would do the majority of the driving.
Your Honor, what we're seeing, I'm sorry, this is a perfect example of the worst domestic violence dynamic you can possibly imagine. The fact that the defendant and the defendant's father are deciding whether or not this victim can drive a vehicle, when she can drive, how can she, I mean, this is—
I don't think that that's what we're saying, Judge. We're just stating facts that he stated that she had a vehicle at one point. She no longer has a vehicle. If she doesn't have a job to go to and she doesn't have any other need to drive, all we're stating is that she does not drive normally. The bottom line on our position, Your Honor, is my client indicates that the vehicle is not safe. Now, we've concluded from him that she's not insured on the vehicle. I don't know the status of her driver's license. So honestly, I think that this is a family law issue. I don't think that this pertains to our case at all. She left the home previously before this case happened.
I want the keys turned over.
You want the keys? No worries, sir.
I want her given access to the truck. She can then make— I'm assuming she's a grown woman, so she can make her own decision as to whether or not she wishes to drive that truck.
Okay.
She can also make her own inquiries as to the insurance that's available on that truck and the like. She can even take it to a mechanic and have them look at it as to its roadworthiness. But she's grown and she can make her own decisions and doesn't have to have defendant dad make those decisions for her. So how are we going to get these keys to her?
Dad says he has the keys. It's not with him right now, but I mean, previously, again.
Them to the public defender's office. Public defender's office can get them to the prosecutor's office. Prosecutor's office can get them to the victim. All right. What do we then need to do on this case?
So, Your Honor, initially we were asking for the adjournment. There was a little bit more discovery or investigation, I would say, on our end that we needed to complete before we decided which way to go.
Want the 5th or the 12th? Counsel?
I didn't hear you, Your Honor.
5th or the 12th?
Let's do the
mean, he's in custody, that's why I'm asking.
Let's do the 5th, Judge, that's fine.
June 5th, 2025. Any whereas your invite indicates bond will continue.
Thank you, Judge.
And I have whatever. Yeah, I think the keys need to be.
Like a blue form.
Yeah.
I'm sorry.
Okay. That's it. I got 3 o'clock. All right, you guys gotta give me about 5 minutes. And then I just tried to figure out. Court does call the case of the people versus Danielle Pressey.
Afternoon, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Ms. Pressey, who's here to my right. State your name.
Danielle Pressey?
I think we're looking for Mr. Childers, Your Honor.
Oh.
Mr. Childers is coming down the hall. Yes, sir. We should start the drum roll now.
Get your parents.
Andrew Children, on behalf of the people, Your
Your
Honor.
Honor, may we approach briefly?
Okay, yeah, why not? It's been that way all day.
I'd like to say. My script.
Okay. Record should reflect we've had a bench conference in this case. I'm gonna pass this matter and then we'll deal with it. All right? Thank you. Mr. Gaddy can have a conversation with you. Court does call the case of the people versus Holly Brown.
If you ever to make that before the people.
Carolyn Foster Tucker on behalf of Holly Brown, who is approaching.
Thank you. Counsel, this is your motion.
Yes, Your Honor, and I know that the court reviews all written motions
I do.
filed before it, so I will not go on for too long. But Ms. Brown is seeking to withdraw her plea today. She asks that this court finds that it is within the interest of justice. She does not believe she's guilty and wishes to contest the BAC blood results. And so she just asks that the court allows her to withdraw her plea.
The BAC in this case.
0.124.
Response from the people.
Your Honor, I would first like to ask of the court, it appears that another APA in our office was served with this motion notice of hearing back on, it's like April 25th or so. Did the court receive anything written from our office? If not, I can respond verbally.
I have nothing written.
Okay, no problem with that. I was informed about this a few days ago. I can provide a verbal response as best I can at this time. There's a view council motion, and it appears as though, as you stated, that Ms. Brown now has come up with, I guess, essentially a defense in this case, and therefore, that is the basis for their withdrawal of the plea. The people do not agree that that constitutes, number one, the finding that must be made of the interest of justice being served by the plea being withdrawn. And number two, I have a concern that the, I suppose I should approach him and very briefly mention this one point with counsel in the court, because it's referring to a letter that was written to another judge. So I don't know if that should be placed on the record. But
a letter.
There was a letter previously written. Ms. Brown is represented by Mr. Ed Drugas at some points, and there was a letter submitted to Judge Anna Freshour when that sentencing was pending in her court regarding her direct feelings and complaints about this matter that I think relate to this motion. But since it was a letter written to the judge, I don't know if it's appropriate to refer to that on the record or not.
Well, a record should reflect the defense conference in this case. What the court is going to do, there's some information that needs to be provided to counsel for everyone, the counsel and the court to look at. So I'm going to adjourn this motion to June 12th, 2025 at 3 p.m. All right. Defendant's bond at this time. And
Thank you.
I will indicate the prosecutor's response will be due by the 5th. Okay.
Thank you,
All right.
Your Honor.
Thank you.
Thank you, Your Honor.
Mr. Getty, are you ready, Mr. Getty?
Yes, Your Honor.
All right. Yeah, we can call that. Does recall the case of the people versus Danielle Pressey.
Andrew Childers appearing on behalf of the people.
Michael Gaddy, Assistant Public Defender for Ms. Pressey, who's here to my right. State your name again.
Danielle Pressey?
Thank you.
Thank you. Your Honor, may we approach? Please?
Yes. All right, the record should reflect in this matter that we have have had another bench conference in this case. But I don't really, the record, I'm ready to rule on the motion for bond modification. I will grant a personal recognizance bond to the defendant. The defendant is to, prior to her release, be fitted with a scram tether. There is to be no driving by the defendant in this case. The defendant also is to continue and maintain her current therapy or the therapy that she was engaged in prior to her incarceration. And also the defendant is to maintain her grief counseling. All right. So Mr. Gaddy, if you can put an order together for the court, I'll be more than happy to sign off on it. I will sign off on the order. I'll prepare the order regarding the scram tether.
Okay.
So that she can be out on the PR, but I need the other terms encapsulated in a.
Okay. I will draft an order and get it over to Your Honor, Mr. Childers immediately.
All right. Were we set for PCC too?
Well, yeah, I believe we're up next Thursday, Joe.
We're up next Thursday. All right. So on this one, the motion's granted. We'll continue to PC probable cause conference next week.
Thank you, Your Honor.
Thank you.
Hello, folks. Thank you for tuning in to Judge Simpsons Week in one stream. This was his criminal docket. Tomorrow, we will go into his other responsibilities, which is tenant and landlord docket, with tenants who can't pay rent, won't pay rent, and landlords who raises rent, doesn't renovate, and kicks people out, and everything in between. Thank you all for showing up, and I will see you tomorrow on his landlord-tenant docket at 9 a.m. Eastern Time. Thank you. See you tomorrow. Bye-bye.
I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases.